Uh, There, I just got the message. This is being live streamed.
I just got it too.
1, 2, 3, 4. 4 interveners plus staff plus the applicant. Two of these parties have 1, 2, 3, 4. One has 4 lawyers, which sounds to me like 3 lawyers too many, but that's just my experience having practiced law for a while. And then another one has at least 3 lawyers and possibly 4. And it can be very useful, to spread the duties of preparation among several lawyers. It's not uncommon in large law firms to have one lawyer assigned to cross-examine each witness. But I'm not sure why we have all these guys participating. It may make it more ponderous and it may make it easier. We'll see.
Yes, sir. I'm prepared for all eventualities.
And lifting those heavy reporter weights again.
Yes, sir.
Well, we lost Anna, so we didn't lose her, but she probably checked out, so that's fine. She's got other stuff to do. Oh, you'll see, Mr. Lee, when my eyes get tired, I switch to my alternative glasses. When those eyes get tired, I switch to my third alternative glasses. It has something to do with age and peering at the screen at the same distance for hours and hours and hours and hours.
I hear you. I have the same thing.
Mr. Lee, this is probably we are on YouTube, but it's an opportunity for me to apologize for the issues related to you getting copies of exhibits in another case. We don't have to name the case or name the exhibits, but I want to tell you I apologize. I'm not trying to duck the blame, but some of these parties send me everything they could possibly move to admit or need to use on cross-examination admit, and of course they never become exhibits unless they're moved for admission and then they're admitted, and they're identified, I wouldn't say haphazardly, but not sequentially as they are admitted, which causes a lot of problems when I go through my notes and then I have to go through their lock boxes to find the various exhibits. Without, of course, I don't have the benefit of the transcript at that point. I just have my notes. So it gets kind of it gets confusing.
I hear you.
So
I appreciate the work you do in that regard.
Well, the work I try to do, and Anna helps somewhat, so I appreciate her helping. Let's go, since there's a Mr. Smith. I see you there, Mr. Josh Smith. Can you hear me? Hi there, Mr. Smith.
I can. Thank you, hearing examiner.
That's
Josh
fine.
Smith, on behalf of Sierra Club.
You're on a smartphone. You're standing too, aren't you?
I am standing. I'm at a stand-up desk right now, and but no, I'm just on a laptop.
Okay, I only see your shoulders, but I can tell you're standing. There's something about that. I'm not sure what that means. Are you in Oakland, California?
That's where we're based. That's where we're based. Yeah.
You remember the bar in Oregon and Florida, right?
That's correct.
Okay. Good morning, Mr. Marks. One of you guys is already here. How are you today? I'm just checking on connectivity, as I call it, to make sure we all have bandwidth and stuff like that, so we don't lose each other during the rest of the day or days, because it disrupts the hearing. And the more people we have, the more likelihood we are to have such a disruption or a dog bark or something like that. So Mr. Marks just checked out. It's about, let's see what time it is. I'll check my 8:51. My computer says 8:53, but the state government IT doesn't allow me to change my computer time. I'm going to try that.
I have 8:51.
You have 8:51, okay. Yeah, my clock on my computer is about 3 minutes early. I think that's so that state government employees can go home 3 minutes early. in the afternoon. Hi, Mr. Marks, how are you? You're low contrast. That's how you are.
I am trying to hear. Okay.
Okay, that's exactly why I wanted to check. You're like cracking up.
Okay.
Audio.
It's sideways, but
No, it's not better, actually. Your voice, I just hear crackling, basically. It's probably, I don't know what it is. Sometimes if you turn off other applications on your computer, especially if they are being streamed or somehow using a lot of bandwidth.
it should be anything. I computer and I'll log back.
Okay, great. Thank you.
Okay. Good morning, Mr. Lee. Good morning, John.
Morning, Jason.
Can't hear anything. No audio. Mr. Lee, can you hear me?
Yes, sir.
Okay. How's the audio for you?
It sounds good.
Okay.
A world of difference.
Okay.
What's your
Well,
secret?
Last night this computer I'm using now was being used to do karaoke at my bar. So might have been the some remnants of the karaoke program running.
I actually believe you, Mr. Marks. Can I put you under oath, and then we're going to see if you get the same answer to that question?
Yeah. And I will tell you, I did not sing, but my wife did.
Karaoke at the bar. I can visualize that.
Yeah. So,
That's a very large coffee cup. It's like as big as your head.
it's the
I know. It's the wide angle view and you're holding it close to the.
yeah.
Well, it's good that we're checking the video and audio, so this isn't just wasted time, actually. But I expected more of these persons to be checking in right about now, later. Uh, Let's see what happens. Here's somebody. John, can you hear me? Morning, John.
Morning.
Someone put you in the corner in your office.
I am just trying to make this work.
Okay, I can hear you, so that's good. That's half the way there.
Excellent.
Okay, Mr. McMillan, how are you this morning?
Doing well. Good morning, Mr. Hearing Examiner.
Good morning. It's nice to see a face to the name. I had no idea what you looked like. Okay, so you have good audio and good video, and we've already checked other persons. Let's see who else might check in. Drew Spiller, would he be coming online this morning?
Drew is a woman, but no.
Oh, I don't know that. Okay.
Uh,
Short for Andrew, right? No, don't mess with me.
You know, we'll put her under oath and we'll figure that one out when she is able to make it to this.
You've picked it up and run with it. I got it.
Yeah.
I understand. Okay. And Nick Stoffel, I want to especially thank you for being present. I think it's appropriate as a counsel for up to a party, even though you asked to not be present. I think it's more appropriate that you be here. Mr. Oh, there you are.
I'm here.
Hi there,
Thank you.
you're there. Excellent. And that other thing marked SPS, I think those are the IT guys for SPS. Am I correct?
No.
Who is that? Who's the people on one screen?
You've got Mark Santos and Mark Walker for SBS. Two of the council up here, and we'll also have one other council, Kate Norman, who will be presenting witnesses.
Okay, explain to me, counselors, while we're still checking in, who is C. Glenn Adkins?
He's an attorney at our firm. He's an associate. He won't be appearing on the record. So he's probably on some of the pleadings, but will not be here at the hearing.
Yeah, I saw him on the pleadings, and that's why I'm asking. And I don't know. I don't think you can do that, actually. But that's your business. I was just wondering about him. Okay, and let's check Miss Lynch and make sure she has audio and video. Miss Lynch, are you there? Sorry for a second. Oh my God, that was exciting. Katie Coleman is spinning around. Hi, Miss Coleman. I know you can hear us.
Good morning.
Can you say good morning again? I only heard a chunk of it.
Good morning.
Okay, good. So you've got good audio. Miss Lynch, do you have any audio or video? There she is. Hi, Miss Lynch. Good morning. Miss Lynch, please say a few words. Unmute yourself. You guys are jumping around on my what do they call that? Squares or something. Miss Lynch, I'd like to hear you say a few words so that we know that we can hear you. And you're in black and white. I'm not sure why, but okay, there you go. Let's go to Lauren Hagru.
Hi there, I'm here to support Sierra Club.
Do you have video, Miss Hagru?
Yes, I do.
Okay, wonderful. Thank you. So it works as well. Miss Lynch, I still haven't heard your audio. Does it work? Maybe she's not hearing us. Maybe she's not hearing. Let's give her a minute or so. It's 9 o'clock and we're ready to roll. In this case, I think we should roll as soon as possible for practical reasons. We're not going to go on the record, Mr. Lee, at least not quite yet. I found we are on YouTube. I might remind everyone. We're being streamed publicly. This is a public hearing. There's a lot of reasons for that, and most of them are good reasons. keeps us all honest, keeps us behaving. It's transparent to the public. And if there's one word for state government, it's transparency. That's an important word. Ms. Lynch, can you hear me talking? Yes, would you please unmute and say a word or two?
Good morning. My headset wasn't working. I apologize.
That's fine, either way. Good morning. Now, I think we have, let's see, I'm looking at my checklist here. Is there Philip Oldham here? Who's representing Occidental?
Sorry, Your Honor, Katie Coleman and Michael McMillan are here for Oxy. Philip's not going to be appearing, most likely.
Okay. So Katie Coleman is here. There she is. So we've got counsel for Occidental, we've got staff, we've got large customer group, we've definitely got Sierra Club and Southwest is here. I think we've got all the parties. Am I missing any parties? Did anybody know of a party that's not here represented by counsel? No. Okay, I'd anticipate that the witnesses will be checking in later in the day, but if we've got all counsel, we can at least begin our pre-hearing conference. I'm allowed to call pre-hearing conferences, and I find that they kind of grease the wheels and allow the rest of the hearing to go more easily. I spent most of the day yesterday with this file and quite a bit of time last week. There was a pleading filed as late as yesterday morning, as you guys know. So I'll just get to that right away. It was filed by Mr. Walker, but of course it was a pleading supposedly with the agreement of at least two of the parties through counsel. Ms. Lees is not going to be here either. Is that correct, Mr. Walker? Zoe Lees?
That's right. She will not be appearing.
Okay. She's located just a block away or so, so it's kind of interesting that we talk so distantly, but Miss Lees is around the corner.
Yeah, she'll be watching on YouTube if you need her, Your Honor.
Okay. And the pleading was also filed electronically. Well, everybody was electronically, frankly. But the pleading was interesting to me. For one thing, when I get something a day before, I usually do nothing with it. And I wait till I get a responsive pleading from the other counsel or anybody else that has anything to say about it. And obviously, I don't have the luxury of that. The pleading covers the type of things that I would discuss right here at this conference. And that's why I answered with an email to the two parties that had filed the pleading with me, the two signatories, and told them that we would address this stuff in the pre-hearing conference. So that's what we're going to do right now. The pre-hearing conference is not on the record. This is not part of the evidence. But very often we'll put on the record what we've agreed to in the pre-hearing conference. So now we have all the parties. Let's address this pleading that came in yesterday. I'm very happy, frankly, that the parties talk with each other. The two, I'm going to call them primary parties, for lack of a better term, of course, the Sierra Club and Southwest Public Service Company. The applicant, this is the applicant's case, and the primary intervener, and by the way, there's not an order on that yet, but we'll get to that in a few minutes too. Primary intervener, and I'm counting 4 lawyers for Sierra Club or so, communicated with each other, and that's just beautiful. Because I've had cases where they come to me and no one has even seen each other, not to mention talk to each other, and they just throw pleadings across the records department. So when I have counsel talking to each other, that's really a good thing. So thank you both. Thank you all, Mr. Marks, Ms. Lees, Mr. Santos, Ms. Norman, Mr. Walker, of course, Mr. Smith, Miller, Spiller, whoever participate, wonderful. I'm gonna let you speak in a minute. Do you have something to say, Mr. Marks?
I wish we were on the record because I would commend SPS's attorneys have communicated extremely well with us throughout this. This is just the only one that's needed to come to your attention, but the two parties have certainly have differing positions on the substance of the case, but Mr. Walker, Mr. Santos, Ms. Norman, Mr. Norman, Ms. Norman have really been exceptional in communicating with us, and both sides have had various issues and worked them out. And you would be very happy, Mr. Lennon, if you had witnessed it, but you didn't need to.
Thank you, Mr. Marks. I can infer from the pleading. The substance of the pleading is wonderful, and we'll get to that. The pleading, that it even exists, is interesting. I usually don't get such a clearly defined resolution of matters that we would discuss now. So let's go to the easy stuff. The easy stuff is the presentation of witnesses. I have no problem with the order, Mr. Grant, Mr. Lytle, then Mr. West, Mr. Goodenough, Mr. Kojak, and then Mr. Elsey. The reason I'm affirming that is because I think there's a certain amount of authority that has been, not actually authority, I call it duty, which has been placed in my hands to maintain control of the hearing. It comes from the commission's order appointing me, and their power comes, of course, because they are the commissioners elected as for now within the state of New Mexico. And they have a duty to do what the statutes say they do, and they say they delegate to me control of the hearing. So I have to maintain control of the hearing and not allow the parties to control the hearing. So I take this pleading as a suggestion, and now I'm going to take the suggestion and ask if there's any objections among the other parties concerning the order of the witness presentation. Are there any? Okay, this is, I presumed, I thought not. So that will be the order, the 1, 2, 3, 4, 5, 6 on page 2 and page 3, and that will begin the hearing. And well, after we have a brief opening, and then the next point raised in this pleading was that there be a continuation of those witnesses into tomorrow, the ones that are not finished. Implied in that is that if we finish those today, we'll stop the hearing. We'll not stop, but we'll end the hearing for today for continuation tomorrow. Is that my understanding, Mr. Walker?
It is.
Okay, good. So the reason behind this is the late filing of some other pleadings, and it allows time basically before proceeding on Thursday for the parties to deal with things that have been raised, which they can address on Wednesday. Is that my understanding? Yeah, it's a bit confusing at first glance, but that basically you create some time in the middle of the hearing, likely time. It's either going to be tomorrow if we finish off all of these SPS hearings today, or it's going to be in the afternoon of tomorrow if we finish the SPS presentation tomorrow morning or early tomorrow afternoon, correct?
That's correct. We proposed to recess between the presentation of SPS witnesses and then picking up Ms. Glick on Thursday.
Exactly. You stated so concisely. Thank you. I appreciate that. So anyhow, so I don't have a problem with that either, but I got certain signatories to this pleading, and I can't, I'm going to ask the other parties if they have any problem with that procedural, that procedure. Any problem with that from any other parties? Or if you have any questions, do you understand it? I see Mr. Stoffel is waving his head negatively. Are there any other objections? Mr. Bagatko, you good with that?
Yes, sir. We do not oppose what SPS and Sierra Club have formulated for the procedural approach to this case. Thank you.
Wonderful. Ms. Coleman, does your party have any problem?
No, Your Honor.
Okay, who do I leave out? We got Mr. Stoffel. I stated that he waved his head negatively. All right, so anyhow, the reason I do this stuff and go around and ask people is I'm frankly trying to prevent any type of appeal, any grounds for any appeal. If I have no objection, frankly, there's not going to be any appeals for me adopting the procedure suggested by, as far as I can see on the pleading, two of the parties. Anyhow, moving along, let's see what else I wanted to address in this pre-hearing conference. Okay, it's also that we would start on Thursday with with the Glick testimony. Of course, there's a redacted version and an unredacted version. Hopefully you guys can work something out on that and we will proceed easily. Then we'll have Mr. Seidler, the only commission staff, on Thursday. So I have no problem with that. Does anyone have any objection to Glick and Seidler going on Thursday? Okay, no, I hear no objection, so that's fine. Next, the next issue, which rubbed me a little bit the wrong way, and I just want to state that normally direct testimony is only accepted in writing here at the commission. And I think you guys all know that. It's a rule of the commission. It's one of my rules. It's in the, I believe it's in the procedural orders or order, the initial one. It's also the practice of the commission that there only be live direct testimony. We don't even allow what we call friendly cross-examination, which we characterize as live testimony. So we take that rule kind of seriously. And this final proposal in the box on that matrix on page 3 indicates that the agreement between those two parties is that SPS presents live testimony, including that of Mr. Elsley, in response to Sierra Club's notice and second Sierra Club notice filed February 10th and February 14th. Because, of course, those are the late pleadings filed, which we hope we're going to talk, the parties will talk about and perhaps resolve tomorrow. But, you know, when I see something like that, that doesn't sound like rebuttal testimony, if you will. That sounds like new direct testimony. So I'm going to ask Mr. Marks to address that. Well, first I'll ask because they're the applicant, I'll ask Mr. Walker to qualm, if you will, or quash my fears that he's going to be presenting live testimony, direct testimony, and Mr. Marks is to address it as well, so I can extinguish my concern that we're going to be violating commission practice. So Mr. Walker, why are we not violating or proceeding outside of normal commission practice by accepting direct testimony of Mr. Elsey?
Yeah, Your Honor, Mark Santos will respond to you.
I'll take a shot at that, Examiner Lennon. You know, the whole reason for this proposal is that we have had some changes to Sierra Club's testimony that came in on Friday, Saturday, and yesterday. They are relatively substantial to us. We view them to be relatively substantial in nature. And so in order for us to have time to address it, that's why we propose taking a recess in the middle of the hearing and starting Thursday with the cross of Sierra Club's witness and then finishing with Mr. Elsey. What I would say, Your Honor, is that I believe it is the practice of this commission to allow redirect examination of witnesses. Mm-hmm. And even if you think this is rebuttal, this is basically live redirect. It is also in that vein that we're offering Mr. Elsey on Thursday. So he's having the opportunity to respond, and the company has an opportunity to present evidence on something that is completely new. And I think we would be allowed to do that on redirect in any given case. I understand, you know, the commission's practice with respect to live testimony, but this is also a bit unique. It maintains the due process that should be afforded an applicant and the parties, and it's been agreed to. So I think at this point, you don't have an objection to it, and I really urge you to be okay with the parties' agreement.
Mr. Marks, please.
Yes, Mr. Lennon, certainly you're correct that the standard practice avoids or disfavors oral testimony, but it's from time to time the commission has permitted and required oral testimony, and particularly in situations like this, in the P&M San Juan replacement case, which was also a heavy modeling case, there was a procedure such as this, I believe, with their expert Nick Phillips. I can't remember the details, but sometimes the commission has allowed a party to file written rebuttal I think this is a rebuttal. I agree very much with SPS that this is a due process issue. They made the point that they filed rebuttal to Ms. Glick's original file testimony. Her testimony has changed. They should be entitled to give their response to it. And I think that's correct for them, and it's correct for the commission. The commission needs a full record to make a decision on this case. And that full record needs to include Ms. Glick's corrected testimony because it's, because there was an identified error in the file testimony. And then since that needs to be in the record, the commission should hear from the company. It's happened before. It sometimes happens with filed written rebuttal. The time, I assume the company determined that there really wasn't enough time to file this in writing. And we were agreeable to them presenting it orally. I suspect, and I suspect it will not be hours on the stand for Mr. Elsie on Friday. And that, but in any event, I think the commission needs to hear Ms. Glick's corrections, and it needs to hear what SPS has to say about them. And we would ask that you grant the request that the requested procedure that we agreed to with SPS.
Okay, keep in mind, we're still not on the record. We're going to probably place this agreement, these things on the record. I'm going to ask any other party, coalition, OPL, staff, large customer group, do they have a position or on the deviation from standard practice in allowing a live testimony of a witness who would address the changes to Ms. Glick's, the recent changes to Ms. Glick's testimony? Any opinion from other counsel? Mr. Bagatko, you're moving.
Mr. Hearing Examiner, I think under the circumstances, it is allowable. The two erratas that were filed by Sierra Club went into substantive changes as far as SPS was concerned, and I tend to agree with them, and I think I understand that Sierra Club agrees with that estimation also. So in that sense, these erratas are not erratas per se, which usually just go to fixing typos and things of a non-substantive nature. And so instead of SPS filing motions to strike and clogging up the pipeline with more for you to do, they reached an accommodation with Sierra Club. And I think under the circumstances, it's appropriate and staff does not oppose.
Thank you, staff. You need not respond, but if there's a position from Ms. Lynch or Ms. Coleman or Mr. Stoffel, now would be the time to say something. We're not on the record. This is a pre-hearing conference, informal. We are on YouTube, so is there any other issues? No. Okay, well, I'll tell you my position, frankly. I'm not going to, there was an implied ruling there about whether or not the changes are substantive or not. I'm not making any ruling on whether they're substantive or not at this point, whether those changes are substantive. I looked at the changes. I've looked at the errata documents. I've looked at the redacted and the unredacted version of Ms. Glick's testimony and the errata, both of them. But, that's the kind of thing, you perhaps council can discuss tomorrow and make it easier on Thursday, if at all possible. And if we can do it without the testimony of Mr. Elsie or however they want to call, that's their prerogative, actually, SPS's prerogative, I think. I'm not holding you to just Mr. Elsie. That's fine. But I'll tell you my concern, if you will. My normal solution to some late filing of essential evidence or proposed evidence would be to postpone the case, to set this back another 2 weeks so that no one can claim in a appeal memoranda to a judicial court, to a judge that, well, that stuff came in late and the parties didn't have an opportunity to prepare a response to it or to prep their witness. And Mr. Lennon should have obviously postponed the case. I'm not going to have that. And the reason I don't want to postpone this case is pretty simple to me. We have, according to the statute, 9 months for the commission to pass an order. And unless one of you guys sees a different computation, it looks a lot to me like May 6th is the expiration of the 9-month. And, you know, the commission does these orders on Wednesday typically. And I should look and see what date May 6th is. Let me take a look. Sometimes you guys are quicker than me. May 6th looks like a Friday. So that means the commission could possibly pass an order on May 4th. And that means the commission's lawyers would like to have a recommended decision no later than the week before, no later. And, you know, much earlier is much better than the end of April, which means I should start writing the beginning of April. And you probably, because, you know, sometimes other stuff gets in the way. I mean, always other stuff gets in the way. So, a matter of fact, I'm going to be attending CLE with the Judicial College the first week of April. So what I'm telling you, there's time constraints. And if you guys are going to want to do a post-hearing briefing, and if this case really takes 3 days, and if Mr. Lee gets us an accelerated transcript, which I know SPS has agreed to pay for, which is wonderful, we still have time constraints. So I don't have time to postpone this case, and you don't have time to postpone this case in order to comply with the statutory deadline, which to me looks like May 6th. Did everyone else have that as a statutory deadline? Is there anybody has a different opinion on that? SPS, nobody? What? Okay, so good.
Can we reserve on that, Mr. Lennon?
Well, we're not.
Reserve
on what?
Mr. Lennon, I recall that time is tight on this, but it's been several months since I contemplated what the actual date was. So
okay.
I think my silence doesn't mean I'm agreeing, but I certainly don't disagree that time is of the essence.
Well, my point is I don't want to postpone the case. And that's why I'm even more appreciative of you guys working this out. You know, a resolution to the late filing of the errata, whether it's characterized as substantive or not. So those are let me see what else I wanted to discuss in this pre-hearing conference. So I'm looking at my notes. Oh, I wanted to go through what I want to do as preliminary matters or motions, what I want to dispose of as housekeeping at the beginning of the hearing. I'll do this on the record, but I also want to make sure I'm not missing anything. I actually looked for outstanding motions. There's been no ruling on the first motion to intervene of Sierra Club of October 6th. I'm not going to presume anything. So is there going to be any objection to Sierra Club intervening? I know there's automatic if there's no objection, yeah. Mr. Marks. Yeah. I'm familiar with that, but I like belts and suspenders sometimes. And you know, if my belt breaks, I got the suspenders, and my suspenders break, I got the belt. And if there's been no objection and you're in, and you're obviously, people have known that your client is in on the case and no one's raised any objection. So I considered you in. I've been talking to you all morning as if you're in. I just never issued an order. Sometimes in the procedural orders, there'll be like a line at the end that all the, there's been no objection to the motions to intervene and they are now parties. And I didn't put that in either of my procedural orders. Okay, anyhow, so that's the first thing I just want to clarify, and I'll do that for the record. Next thing, there's been these pro hac vices. That's how I say that. That's one of those Latin words. or 3 words. There's been, it was filed on behalf of Joshua Smith, Matthew Miller, and Drew Spiller. I found no objection to granting the motions for them to be admitted. I'm going to ask, is there going to be any objection? There is none, correct? Those are out-of-state law. Pardon?
No objection from SBS. Your Honor.
Okay, good. SBS would be the one to object if there was someone going to object, I would think. So since there's not going to be any objection, I'm just going to notate for the record that they are allowed to participate in the case. There's, as you guys know, there's a certain, it's not commission practice, it's state law. And I had to pull out that 24106 practice by non-admitted lawyers and read what was required. And it was interesting. And I believe these applicants have satisfied the statutory requirements. Moving on. And then there's an outstanding motion perhaps from Coalition for Clean Energy where they filed a leave to intervene as well. That was dated December 20th. So that's different than the one from Sierra Club. And theirs is what they call out of time. I kind of like that phrase. It's another nice way of saying late. Nice way of saying late. And I like nice ways of saying things. Very diplomatic. So the question is there any objection to Coalition for Clean Energy? Is there going to be any objection to Coalition if we're granting the leave to intervene from Coalition for Clean Affordable Energy? There's nothing been filed in writing. Good, no objection. That'll get into. Next one I see in my housekeeping is also pro hoc vice filed by SPA for Mark Santos, for Catherine Norman, for Kate Norman. That was filed October 6th. Is there any objection to that one? No, thank you all. Anyhow, moving along, that's one of those good for the goose and good for the gander kind of things, I think. Or okay, excuse me. And then we get to a couple easy ones. Excuse me. Oh, Mr. Stoffel, once again, thank you for being here. Where is he? There he is.
I'm here. My pleasure.
Thank you for being here. Every once in a while, there's actually an objection to someone not appearing and not being present if one of the other parties were relying upon you making your arguments and a motion or relying upon you presenting a witness. I know you don't have a witness, but they might have presumed that you would be here and actively participate. And that's why your request it was actually an emailed request on February 8th. I consider it a motion to be excused from appearing, even though you're a party to the case. And can I ask why you were interested, or your client was interested in participating, but now they're no longer interested in participating?
Yes, certainly. We had an interest in where this proceeding is headed, but as the case proceeded, opted not to sponsor a witness or to offer any evidence in the hearing. And so we will continue to monitor and are interested in the outcome, certainly, but didn't want to devote client resources to attending the full hearing when we are in, I think, a non-primary role is what you'd kind of categorized us as earlier.
Okay, well, that's great. And I appreciate you enunciating that. Is there going to be any objection to Mr. Stoffel on behalf of his client, New Mexico Large Customer Groups, participating in this hearing, or not participating? Okay, no, just I suspected there's none. So I'll grant that motion too. Next thing, I'll do it on the record. Then there's the request for confidentiality followed by SPS, which looks a lot like a motion to me. That was filed on the 11th. That's probably going to be addressed, and I'm going to probably ask for some kind of argument or explanation for that on the record. Mr. Walker, it hasn't been resolved, right?
No, Your Honor. No, Your Honor. We filed that last week. I think it's a fairly standard request when dealing with confidential information in a case like this.
Okay, well, I might ask you to just say that on the record and give the others an opportunity to respond to that. And then the final thing that I see that needs to be addressed on the record, outstanding housekeeping motions. Oh, it's the agreed request I've already been talking about. So never mind that one. So I look like 6 things that I need to clean up just to make sure the pleadings in the record there's nothing hanging out there, so to speak. When we finally conclude the case, I like to do it at the beginning. I'm almost ready to start on the record. Does anybody have anything else they want to discuss during this? Oh, let's talk practical stuff. In the unlikely event that, Zoom goes down or the power goes down, boy, that's ironic, or or that some important person loses their connectivity. What I'll usually do is go off the record and, wait about 5 minutes and see if we can get connected back up. One time it happened to me. That was really disconcerting. But I hope that doesn't happen. But if it happens, we'll deal with it. Usually we'll go off the record and give 5 minutes or so to get connected back up. Does anybody else have any opinion about that? No? Okay. As you guys are all Zoom veterans, so as you know, we try to keep the audio off unless you're speaking, but of course we have to click to get back on. I usually keep my audio on so I can rule on objections quickly. What's I about to say? I expect that witnesses are probably going to be checking in or appearing on the screen during this hearing. I don't know. That's fine with me. If there's somebody that shouldn't be attending the hearing via Zoom, let me know, because I do have to maintain control of this. And what I expect is counsel for the parties and the witnesses. That's about it. Because you have corporate witnesses, of course, there could be a corporate personage, if you will, present as well, but I don't think anyone is elected to do that. Oh, what else did I want to discuss? We'll probably take a break for Mr. Lee, if not for all of us, at least every hour or so, and hopefully for 5 or 10 minutes, just because we need it. And at the end of the day, it makes a big difference. What else I was going to say? Oh, lunch break. I'll leave it up to you guys. Anywhere between, say, 11:30 and 1:30, we should consider a nice place to cut, which would typically be after the cross-examination of a witness. And we'll discuss at that point off the record whether it'll be an hour. Well, does anybody have an opinion right now whether it should be a half hour, an hour? I don't think it's timely to discuss it now. Okay, no, we'll discuss it later. As for ending for the day, I think we should close down about 5 o'clock. I'm willing to go longer. Of course, if we're in the middle of testament cross-examination, we're gonna probably go longer. I don't like to cut that up, but I like to end at 5 and then begin again tomorrow at 9 o'clock. I'm going to shut up and listen to you guys. Any opinion on any of that stuff? No. All right. I think,
Mr. Hearings Examiner?
Yes, sir.
I just wanted to make sure that on your list of unresolved motions, you had my motion for pro hoc vice that came in last week, I believe. I didn't hear you mention it, is what I'm asking.
Mr.
Mr. McMillan on behalf of OPL.
Mr. McMillan, that's exactly why I go through that in a pre-hearing conference, because actually I don't have that motion on my list. So I have my pleadings right in front of me. It's actually a big, thick book. What date did you file that?
One moment, I have the wrong case up in the interchange.
Your Honor, it looks like it was filed on the 7th, February 7th.
Aha, so it's very recent. I don't know. Did you send me a copy of it when you filed it, Mr. McMillan?
If I did not, it was an oversight on my part, so I apologize for that. I can make sure that gets to you presently.
I'm not saying that's the case, because I just got a flurry of emails, mostly on this case, actually, on the 7th. Let me pull my emails on the 7th and see if I received it. February 7th. No, sir, I do not see it. But did the other parties receive a copy of that motion?
SBS did. We don't have an objection.
So SBS did. There's no objection from them. So you're in the place of Mr. Oldham, right? Or,
Well, he is still listed as counsel in the case, but I will be participating.
and you've got Mrs. Coleman, co-counsel, right?
That's correct.
Well, two of you ought to be able to take on these guys, right? It sounds like more than one.
Sounds right to me.
You know, there's certain redundancy. One lawyer is really helpful, but once you start getting more than one, well, okay. So, and I understand about delegating duties, and the big firms like to assign one person to cross-examination of witnesses. Okay, yeah, I didn't see that preliminary matter, but we'll dispose of that. If I forget on the record, let me know. Okay, what time is it? We've been just going for about a half an hour. It's not enough, 40 minutes, when it's not enough time to take a break yet. So I'm going to proceed and see if we can take care of at least putting this stuff on the record before we take a break. Does anybody have anything? Yes, sir.
Examiner Lemon, just one housekeeping matter.
Yes, sir.
I think we owe you some cleanup. Both us and Sierra Club may owe you some cleanup on the exhibit list.
Oh,
I know that
yeah.
the new errata that Sierra Club has filed, I don't know if I've seen an updated exhibit list for that. And I also know that with respect to SPS, we serve everyone with our exhibit number 15, but it's not on our exhibit list. So I probably need to get you an updated list. Everyone has the exhibit, but on the Word document that is our exhibit list that was originally circulated, our exhibit 15 hasn't been added there yet.
Okay, well, could you send that, just email it to me during the hearing? It'll pop up on my screen.
Well,
If you were wondering, I always think there should be a word stuck in there that is called a proposed exhibit list, because these are not exhibits yet. And, you know, if they all became exhibits, my life would be a lot easier, and Mr. Lee's would probably be a lot easier too. The problem is that all the proposed exhibits don't ultimately get admitted into the record as exhibits. I appreciate you guys marking them in advance, but simultaneously, I also don't appreciate you marking them in advance. When I do hearings in person, I put my two hands on the exhibit. I sometimes put a sticker on it, and sometimes I just write on the front page, exhibit number 1, then the next exhibit's exhibit number 2, the next one's exhibit number 3, the next one's exhibit number 4, and that works really well. With these pre-marked exhibits in a Zoom hearing and sending them by email, sometimes exhibits are not admitted into the record, and it causes a lot of confusion in accumulating the record correctly. Anyhow, you just opened the door and allowed me to walk through it. So I took the opportunity to walk through it so you can hear some of the issues that I have to deal with on this end. So the exhibit lists are very appreciated. I call them proposed exhibit lists. They are not evidence. They're not part of the evidence. They just kind of help me to get through the hearing and perhaps help you to get through the hearing efficiently. So send me an updated one. Sure, send me the, I did receive exhibit 15, proposed exhibit 15, pardon me. I'll tell you what it consisted of, if you don't mind. It was crazy. I mean, really? Where is my email? It was not one, it was 3 emails, and each of the emails consisted of many Excel spreadsheets. Is that exhibit 15, the 3 emails with the many Excel spreadsheets?
it is, Your Honor. It is in today's world, in order, to get you this type of, as you referenced, if we were in a real hearing, I would get you a thumb drive and it would have all of that information on it. In today's world, an email was, pursuant to your order, quite frankly, the best we could do to get you that evidence. And so it was a little unwieldy the way we had to transmit it to you.
Well, I got it. Did everybody else get it? Probably. It's just a proposed exhibit at this point. It is unwieldy. And I did not read all those little numbers and all those lists of things yet. But if I have to, I will, if it's admitted into evidence. It looked to me like each of those things were distinct from each other, and there may be argument on excluding one or 52 of those Excel spreadsheets and admitting one of those spreadsheets or two or three or four. So, you know, it looks like we might have to cut up Exhibit 15 into 15A through Z or something like that. So it really looks crazy. But, you know, we'll deal with it as we go along. You know, it's a big case, and big cases with big power plants have big exhibits and big Excel spreadsheets. That's life as we know it. That's the nature of proceedings before the PRC. Okay, I've been talking way too much. I'm going to be really quiet for most of the hearing, as you probably know. Mr. Marks.
I am not sure I have that Exhibit 15, and Mr. Smith has confirmed we don't have 15. Could SPS please, either that or we lost it or overlooked it. Could you please email it to us again, and maybe everyone?
We can, Jason, just so you know, it's just your response and supplemental response to our RFI number 1. So it's discovery you gave to us. So we'll send it back to you to confirm that. But that's all that exhibit is. And it's for use on cross-examination later on, should it come in.
I'm not, sounds like I won't be posing an objection to it, but I would like to have it.
Sure.
Thank you, Mr. Marks. Any other comments about that? Boy, I'm forgetting what we talked about at the beginning of this pre-hearing conference. Okay, are we about to go? It's 9:45. We've been going for 45 minutes. Does anybody want to take a 5-minute bathroom, pour yourself a coffee break?
Judge, I would appreciate it just to use the restroom, and then we can go for the next stretch.
Okay, so 5 minutes, and my clock says 9:43. We'll be back at 9:48. Thank you all. Recess. Thank you, Elizabeth.
Mr. Lee, have you been back down to Albuquerque lately?
Only to go to the airport. Next time I'm down there with my kids, I'll stop by your place.
Okay. How are you enjoying settling into Santa Fe?
It's working.
The word said one thing and the tone said another thing, Mr. Lee.
You are correct.
Can you note that for the record?
I can.
You know, it's funny. That's one of the things that doesn't actually get noted in the record so much. It's very interesting.
I worked for a federal judge who knew how to use tone. You're right. I'll have to tell you that story sometime.
Okay, it is 9:48 on my my cell phone, and we all should get back and get going so that we can end at 5 today, and then we can end earlier tomorrow and give you guys more time together tomorrow.
Judge, you're not on the screen.
I like it that way. No. There I am. Sorry. Appreciate it, Mr. Lee. Thank you. Oh, my. We'll just wait a few minutes. Some people's coffee cups are deeper than others. That's a book by George Orwell, I think. How did that go? All coffee cups are equal, but some are more equal than others. Who is Miss Hargrove? Have you spoken to me yet? Lauren Hargrove.
Mr. Lennon,
Yeah.
she's our paralegal, and I'm sending a message that she should reconnect on YouTube.
Thank you. Hollywood Squares, that's the name of the show I was trying to remember. Looks like a TV screen for Holiday Squares from this end. Mr. McMillan, are you there?
Yes, Your Honor, my apologies. I was having difficulties unminimizing myself.
Thank you, sir. Okay, are we ready to go on the record, counselors? Or counsel? I think that's a plural of counselors or something. Mice and meese. Okay, everyone. Mr. Lee, let's go on the record. Good morning, everyone. On the record at about 9:54 or so. Put on the record, I'm Robert Lennon. I'm a hearing examiner for the New Mexico Public Regulation Commission. This is the case of Southwest Public Service Company's application to amend its certificates of public convenience and necessity to convert Harrington Generation Station from coal to natural gas. And secondly, for authorization to accrue allowance for fund used in construction. And thirdly, any other associated relief. This is PRC case number 21-00200-UT. I've essentially just read the caption of the initial pleading and the subsequent pleadings. We have actually had a pre-hearing conference off the record immediately before this hearing. It was scheduled for 9 o'clock. Everyone was here timely at 9 o'clock. We took a very short break, but mostly we discussed things which will be placed on the record preliminarily before we proceed with opening statements and and then testimony. I'd like counsel to identify themselves first, and we'll start with the applicant, then we'll go to Sierra Club, and then Coalition for Clean Affordable Energy, then Occidental Permian Ltd, and then staff, and then, well, the Large Customers Group Council is not here. We'll talk about that briefly. SPS, please identify yourself and tell me who your client is for the record.
Good morning, Your Honor. Mark Santos, Mark Walker, and Kate Norman will appear on behalf of SPS in the case today.
Thank you, gentlemen. Sierra Club.
Good morning, Jason Marks appearing for Sierra Club, and I am joined by Joshua Smith, contingent upon Your Honor on the record approving his pro hoc vice.
Thank you, sir. Very thorough. Coalition for Clean Energy. Ms. Lynch.
Good morning. I'm Kara Lynch, representing the Coalition for Clean and Affordable Energy. Thank you, Your Honor.
Thank you. OPL.
Good morning, Your Honor. Katie Coleman and Michael McMillan for OPL.
Thank you. And Mr. Bagatko, please.
Good morning, Mr. Hearing Examiner. John Bagatko, representing the New Mexico Public Regulation Commission's Utility Division staff in this proceeding.
Thank you. And Mr. Stoffel had joined us for the pre-hearing conference. He was a Large Customers Group, and he had requested that he not waste his clients or use up his clients' resources by appearing other than monitoring the proceedings. So he's not here. That's fine as well. I want to remind everybody that this hearing is being streamed on YouTube. I asked for the identification of all of you counsel to make a record, and Mr. David Lee is with much experience in these types of hearings. He is keeping a transcript of the proceedings. That's why I ask you to formally enter your appearances for the transcript, which is, the record of the case. Anybody that's been tuned in on YouTube already knows that we've had a pre-hearing conference. And at this point, I'm going to place on the record some of the matters, and actually rule, frankly, on some of the matters which I considered preliminary matters, preliminary to this hearing. And I call them housekeeping, very simply to clean up the record. I'm always concerned that there's any type of motions that are outstanding that have not been ruled upon. Honestly, I have seen cases appealed and even reversed and remanded for that reason. I've seen them, and I've been counsel arguing for that type of thing. So I want to clean the record up and make sure it's clean. There's been two motions to intervene, one by Sierra Club, one by Coalition for Clean Affordable Energy, excuse me. There's been no objection to those motions. For Sierra Club, it was filed very quickly on October 6th. That was even before I was assigned the case. And the Coalition for Clean Energy filed theirs later on December 20th, but there's been plenty of time to object, and there have been no objections, and there is an automatic, they automatically become parties. But I usually like to issue some sort of line or so to dispose of those motions. As discussed in the pre-hearing conference, I'm going to ask one more time, is there any objection to any of those parties participating? SPS?
No objection, Your Honor.
Thank you. And so I'm going to grant those motions. Sierra Club is a party. Coalition for Clean Affordable Energy is a party. The next.
Was that Mr. Santos?
Yes, Mr. Lee, that was Mr. Santos.
Thank you, Mr. Santos. Go ahead, Judge.
Thank you. Simultaneously, I'm also going to grant the Pro Hoc Vice motions, which were filed by Sierra Club on February 4th and filed by SPS on October 6th. There is no objection to Mr. Santos participating in the case as an out-of-state licensed lawyer, out-of-state lawyer practicing here. And Miss Norman, Kate Norman, as well as Joshua Smith, Matthew Miller, and Drew Spiller for Sierra Club. So all of those motions to practice here in New Mexico are hereby granted. Next, for the record, and I already mentioned it, but Mr. Stoffel has asked that he be excused from appearing and actively participating on behalf of New Mexico Large Customers Group. They didn't have any pre-filed testimony to present, and they waived any cross-examination in the case, and I have informally excused him. Now I'm going to formally grant his emailed motion to be excused from appearing. Let's see what else we have here. Oh, there was Mr. McMillan also filed a motion to appear. Is that correct, Mr. McMillan?
Yes, Your Honor.
So your motion to appear as out-of-state counsel is also granted, there being no objection. Let's see what else. Oh, there was a motion for treating the confidential information as confidential. Always kind of intrigued by that one. That's why we have confidential information, which can turn into a confidential exhibit. There can be exchange of discovery between the parties and remains confidential between the parties, but this is basically to treat such confidential evidence as confidential for public record purposes. And I didn't have any problem with granting that motion. Is there any objection to that motion?
Sierra Club does not object.
Okay. Any other objection? I didn't think there was any, and I know the parties, and I appreciate the parties communicating with each other prior to this hearing. So the request for to treat the confidential information as confidential is granted. We will do so. It can get complicated during a YouTube streamed hearing. Sometimes figures and things that are redacted on the admitted documents could be extraneously mentioned by counsel, say an argument or something, or a cross-examination, or the question of cross-examination. So I ask everyone to be careful with that kind of stuff, if you will. Let's see what else I've got here on my preliminary matters. I have nothing. As far as opening statements go, these cases are unusual in that you guys all know the case. All the lawyers know what's going on in this case, but we have members of the public that may be tuning in on YouTube that don't know the facts. They haven't read all of the pleadings. And I think it's important that we acknowledge their unilateral, if you will, participated in the case. They are unilaterally monitoring it by YouTube, and we owe them, at the very least, some type of opening statement, setting the stage, if you will, for the remainder of the proceedings. So I would like to hear from counsel with a brief opening, just explaining what this case is about, so the rest of the testimony makes more sense. We'll start with the applicant, Southwest Public Service, and then we'll go to Sierra Club. And in no particular order, after that, Coalition for Clean Energy, Occidental, and staff. Thank you. Let's start with Southwest Public Service Company. Tell us about this case, please.
Thank you, Examiner Lennon. As the record already reflects, this is Mark Santos, and I have the privilege of representing SPS in this case today, which is SPS's request to convert Harrington Generation Station from coal to natural gas. As many folks may know, SPS in New Mexico stand united in the effort to transform the power grid of today into one that is reliable and carbon-free in the future. To that end, over the past few years, SPS has added over 2,000 megawatts of clean, renewable power to its grid for New Mexico customers. And SPS has been engaged with its stakeholders over the past few years in an effort to figure out how to retire its existing coal fleet. And In fact, I don't think any part of this case could reasonably dispute the fact that SBS and its parent company, Excel, are one of the most environmentally conscious utilities in the country. And this case is part of that story. It involves a coal plant located outside of Amarillo, Texas, that has been providing reasonably priced and reliable power to New Mexico customers since the mid-1970s, almost 45 years. However, its life as a coal plant is coming to an end. By December 31st, 2024, less than 3 years from today, pursuant to an order from the Texas Commission on Environmental Quality, Harrington must cease operating as a coal plant. At the same time, SBS continues to need the over 1,000 megawatts of capacity that Harrington provides today. They're going to need that after December 1st, 2024. And so that's why we're here today, that continued need for capacity. We're seeking a bridge between now and a carbon-free energy future. SBS's proposal to convert Harrington to natural gas is also the result of a tremendous amount of effort, and that's going to be reflected in the hearing and the exhibits that are entered over the next few days. A tremendous amount of effort to find a reasonable, right path forward. The evidence that you're going to receive demonstrates the company modeled numerous scenarios, both in 2019 and again in 2021, and conducted a thorough request for information, all in an effort to find the best path forward for Harrington. That study and the effort came to one reasonable conclusion, and that is to convert all 3 units at Harrington to natural gas. And conversion is possible for a number of reasons. For one, SBS has been a good steward of the Harrington units. Those units were originally expected to have retirement dates 10 years ago, and those lives have been extended. When SBS also purchased and installed those units, they had the forethought to buy units that could run on either coal or natural gas. So the only thing separating Harrington today from natural gas generation is one, some relatively minor piping changes at the plant, and two, the build out of a natural gas pipeline that can bring enough gas to the plant to allow it to run at full capacity. And as detailed in the direct testimony that we're going to present, those changes are expected to cost somewhere between 65 and 75 million, with approximately 20 to 23 million allocated to New Mexico customers. Now, SBS recognizes that 20 to 23 million is a substantial investment, but the evidence is going to demonstrate that relative to what new generation would cost in order to replace Harrington with 1,000 megawatts of firm capacity, SBS's proposal is by far the best option for customers. It would transform a plant that has historically been a base load generating facility to a peaking facility, one that can handle the changes and the challenges associated with adding more renewable generation to SPS's generation mix, which continues to happen today. We're hopeful that you, after evaluating the evidence, will share our view. As you may know, Commission staff supports SBS's request. Commission staff has found the proposal to be reasonable and consistent with the New Mexico Energy Transition Act. In fact, only one intervener, and you're going to hear from Mr. Marks here shortly, has voiced any opposition to SBS's request, and that's the Sierra Club. And let me address that real briefly, because at the end of the day, SBS's vision of a carbon-free future is actually aligned with some of the goals of the Sierra Club. We're partners with the Sierra Club in that effort. We have been before, and we'll be partners with them regardless of the outcome of this case. And our disagreement in this case with Sierra Club's position really kind of comes down to the fact that we believe Sierra Club's case is based on some flawed modeling that, quite frankly, the Commission has rejected before in a prior SBS rate case and in the company's last IRP filing. At the end of the day, Sierra Club's position would also put at risk reliability for our New Mexico customers. And that's where we really disagree with them. Sierra Club's position would have SPS fall below the SPP required reserve margin of 12%, without any certainty on when or if or at what cost another replacement resource might be found. It's likewise a little disappointing to see some recommendations and suggestions in Sierra Club's filed testimony that would disallow depreciation expense and return on SPS's investment. Recommendations that would undisputedly penalize SPS for being a good steward of Harrington and for extending the life of that plant and extending its depreciation rates, which pay for the original investment, through rates. As Mr. Elsie's rebuttal testimony is going to demonstrate, the reason we believe you see those recommendations coming from the Sierra Club becomes apparent when you really dig into the financial assumptions that drive the model. Simply put, the only way Sierra Club's original filed position makes any kind of financial sense is if you penalize SPS and disallow millions of dollars in investment that this commission has previously found to be prudent and that has been serving SPS customers for years. You're going to see through the cross-examination of Ms. Glick and Mr. Elsie's rebuttal that Sierra Club's modeling has also undergone a few, in fact, more than a few last-minute changes that we just received on Friday, last Saturday, and yesterday, in fact. Ms. Glick's revised calculations now contradict Sierra Club's original position that retiring all Harrington units created savings for customers. In fact, in Ms. Glick's revised scenario, that retirement of all 3 units is now the most expensive. Regardless, we believe the evidence is going to show that these last-minute changes remain flawed. They ignore the reliability need that SPS has, and they continue to demonstrate that Sierra Club lives in a modeling world and not real-life utility operational planning. Nothing in Sierra Club's new changes change the fact that Sierra Club's position is not good reliability policy. And so the adoption of Sierra Club's position would put SPS's ability to reliably serve its customers at risk. We sit a mere 2 weeks from winter weather that caused utility outages and angst around the country. We sit a year from Winter Storm Uri that caused substantial disruptions to the Texas power grid. And while we applaud Sierra Club's zealousness in its pursuit of a carbon-free future, we can't agree with a position that puts reliability at risk when our customers need it most, whether that's in the heat of the summer or it's in a winter weather event. And we can't agree that a utility should be punished for being a good steward of a generation asset. SPS's proposal to convert Harrington to natural gas and its associated request to accrue AFUDC related to the project is reasonable. It's consistent with the ETA, and it should be approved. Your Honor, we look forward to this opportunity to discuss these issues with you this week, and we stand ready for your questions. Thank you.
Thank you very much, Mr. Santos. And before Mr. Marks begin, I want to state something for the record, which is very obvious to lawyers and to hearing examiners, but perhaps not to the public tuning in. These cases are decided. My recommended decision will be based upon the evidence admitted in the case. It will not be based upon arguments of counsel. Mr. Santos, you did a great job there. And I'm sure the public appreciates your very thorough explanation of what evidence you intend to present. Like I said, the case will be decided on the evidence presented, just like any other litigation, not on introductory or closing argument or comments of counsel. So thank you very much, Mr. Santos. That was a great introduction for people that haven't read all the pleadings. Mr. Marks, would you like to similarly make an introductory statement?
Well, thank you, Mr. Lennon. Mr. Smith will make our opening, if that's okay with you, and with the viewing audience on YouTube.
Thank you. Mr. Smith, good morning. How are you?
I'm doing well. Thank you, Mr. Hearing Examiner. Joshua Smith on behalf of Sierra Club.
You may proceed at will.
Thank you, Your Honor. We heard a lot from SPS over the last few minutes about its good stewardship of the Harrington power plant. It's important here to recognize that the genesis of this case and the genesis of this proposal is the fact that SPS has operated Harrington in a way that violates public health standards. And these are national public health standards that EPA has set as a bare minimum to protect public health in the surrounding areas around the Harrington power plant. And over the last several years, it's become clear that the Harrington power plant, because it lacks any modern pollution controls, regularly and routinely violates the standard by as much as 1.5%, 1.5 times to 2 times the limit. And it's also become clear over this particular case that SPS knew that there was a problem with compliance with that health standard as early as mid-2019, and probably earlier. There'll be evidence to that effect in this case. During that period of time in 2019, SPS conducted its first analysis of what it should do to address this problem. And it evaluated installing additional controls and continuing to operate on coal. It also evaluated retiring all 3 units and retiring 1 or 2 of the units. At that time in 2019, the least cost option under the company's own modeling demonstrated that retiring at least 1 of the Harrington units outright was the least cost option for customers. Despite that modeling, this is the company's own modeling, nothing that Sierra Club did here. The company forged ahead with its own business plan and approached TCEQ, the Texas Commission on Environmental Quality, with a plan to come into compliance with the standard. And in a series of backroom conversations in which the public had no participation, TCEQ and SPS agreed upon a plan that would require the conversion of all 3 units, or would contemplate the conversion rather of all 3 units, despite the company's analysis showing that retiring 1 of those units was the least cost option. Fast forward a couple of years, and the company continues to maintain that converting all 3 Harrington units is the best option for customers. Now, in 2020, TCEQ and SPS agreed to this conversion plan. After that conversion plan was agreed to and entered by the TCEQ, SPS put together a updated 2021 economic analysis, which it presented to the commission in this case.
Which commission? New Mexico?
The New Mexico Commission.
Thank you, sir.
Thank you, sir. And SPS's 2021 analysis again shows that under every scenario, retiring at least 1 of the Harrington units is the least cost option for customers. And in fact, as part of the last rate proceeding in New Mexico, the 2019 rate proceeding involving SPS, the company agreed to have an independent evaluator oversee this modeling. And the independent evaluator, you'll hear from him today or tomorrow, confirms that under every single one of the sensitivity runs that the company provided, retiring at least one of the Harrington units is the least cost option for customers. And the independent evaluator confirmed that retiring at least one of those units is both practical and feasible. Nevertheless, SPS put together an analysis for the New Mexico Commission that purports to evaluate 6 different general scenarios. And we'll go through this in later detail throughout the hearing. But what becomes clear is that SPS never really seriously considered or thought that full retirement of the Harrington units was a possibility. And in fact, they now say that retiring all 3 units is, quote, not feasible, impractical, and not credible. Nevertheless, the company put forward an analysis that suggested to the commission that it was a feasible outcome. And where we get to at the end of the 2021 updated analysis that the company has put forward is that there are really only 2 practical alternatives. One is the company's preferred outcome, in which the company converts all 3 units to operate on gas and locks in fossil burning at all 3 units for nearly 20 years. You heard a lot from Mr. Santos about the need for continuing to have all 3 units operating at Harrington. What you'll hear in the evidence today and over the next couple of days is that's just not true. The company could retire one of those units, again, consistent with what the independent evaluator said was the least cost option, could retire one of those units and have sufficient capacity to operate without adding any new resources until the end of 2026. That's a full 4 years from now, so where the company can evaluate and plan its next steps in terms of replacement resources it might need beyond 2026. SPS suggests that all 3 units are needed for reliability. That's simply not so, and the company's own internal reliability analysis demonstrates that there is no system reliability issue with retiring 1 unit. What's more is that the company's own modeling demonstrates that if all 3 units are retired, that 3rd unit doesn't operate at all over the next 20 years. And so the company proposes to spend several $1 million converting all 3 Harrington units to operate on gas for 20 years when its own modeling reveals that one of those units is never going to operate under the company's base assumptions. And what you'll see is Sierra Club, in an attempt to investigate and explore SPS's analysis and put forward a recommendation for the commission, simply used, for the most part, SPS's own inputs. And yes, you will hear that there was an error in the modeling that Sierra Club put together. And when that error is corrected, however, the outcome still demonstrates that retiring at least one of the Harrington units is the least cost option for customers. And the only reason the company puts forward for not, one of the only reasons the company puts forward for not taking that pathway is the purported increase in rates over the next couple of years associated with retiring that 1 unit. But it's important, again, to remember that over the long term, customer rates are going to increase quite substantially to pay for the conversion of a power plant unit that is never going to be used. And so when all the pieces are put together, Sierra Club contends that SPS should have taken a closer look at retiring all 3 units earlier in the process. And if they had done so in 2019, perhaps they could have resolved any capacity needs from retiring all 3 units. And they could have put SPS on a true renewable and carbon-free pathway. But instead, they dragged their feet and they agreed with TCQ, again, behind closed doors, to a gas conversion.
You're going to present evidence of the behind closed doors
Yes, sir.
communication? Okay,
Yes, sir.
go ahead. I'm sorry to interrupt you, sir.
Setting aside the company's slow walk of the potential replacement opportunities for the Harrington units. Once again, the analysis on both sides show that retiring one unit is the best option for customers, and that's the outcome that the commission should adopt going forward. In particular, directing SPS to retire the one unit, unit 1 in particular at Harrington, and possibly allowing the company to move forward with the conversion of the other 2 units as the best pathway for customers. Thank you, Your Honor.
Thank you, Mr. Smith. That was clear and relatively concise, and I appreciate that. I would like to hear if she cares to comment from Miss Lynch, telling us what evidence. Well, you're not going to present any witnesses, but you could participate in the examination of witnesses. Could you please tell me what evidence, if any, you plan to present?
Sir, we didn't submit any evidence in this matter, and I don't have anything to add to Sierra Club's summary of the issues.
Thank you, Ms. Lynch. That was certainly concise. We appreciate that. And let's move on to OPL with Ms. Coleman. Do you have any opening statement you'd like to make?
Mr. McMillan is going to handle it, Your Honor.
Thank you, Ms. Coleman. Mr. McMillan?
Good morning, Your Honor.
Good morning.
So as you know, OPL is an oil and gas consumer, oil and gas producer that consumes a large amount of electricity across SPS's service area, both in Texas and New Mexico. We did not file testimony in this case, and we have not expressed opposition to SPS's proposed modifications to the Harrington station. However, we are monitoring this hearing, so we have an opportunity to cross-examine with respect to any changes to the proposal from SPS or other parties. So ultimately, apart from the environmental considerations surrounding Harrington's future, OPL believes the Commission's decision in this matter should focus on 2 goals. The first, ensuring that SPS continues to have enough generation resources to reliably provide power to its customers. And second, enabling SPS to serve its customers at the lowest reasonable cost. Thank you for the opportunity to provide an opening, Your Honor.
Thank you, Mr. McMillan. I'm sorry you're standing by for such a long time. Appreciate that. Well, Mr. Stoffel won't be here for the large customers group, but we will hear from Mr. Bagatko on behalf of staff, please. What evidence do you plan on presenting, and do you have any argument about that evidence? Thank you, Mr. Bagatko. Proceed.
Mr. Hearing Examiner, thank you. I'll try not to belabor any of the points that have already been made by counsel for SPS and counsel for the Sierra Club, but I think it's sufficient to say, as has been alluded to earlier, that the utility division staff, with some conditions, is supportive of SPS's request in this case. And I would remind Mr. Hearing Examiner and all of our folks in YouTube land that this is primarily a CCN case brought primarily under the auspices of our CCN statute, which is found at Title 62-9-1. And one of the primary concerns in the Commission's review of CCN proposal like the one we have before us now is that whether or not the public convenience and necessity require or will require such construction or operation. And so in this case, it's a little bit different from our usual CCN case in that we are not dealing with request for new generation. The generation components already exist. We're not dealing with a new request for new capacity. The capacity, slightly in excess of 1,000 megawatts, already exists at the plant. The novel question we have before us in this case focuses on changing the fuel source for the 3 Harrington generation units from coal to natural gas. And the new construction that will involve, as counsel for SPS talked about earlier, the piping for the generation sources and the construction of a new gas pipeline to get that gas to the generating station from the main line. And so in that regard, staff's evaluation of what SPS has brought before it under these particular and fairly unique circumstances is focused on whether or not those basic standards applicable to CCNs are satisfied, and with particular regard under these circumstances to the maintenance and continued reliability of the Harrington station as a generation resource. And so while we respect what the parties have brought to this case, especially in regards to SPS's position and Sierra Club's position, staff's primary concern has been focused primarily on what we find in the CCN statute. This is not a continuation of SPS's IRP case. This is not an abandonment proceeding. And we're not looking to do a resource replacement analysis in this. So staff's analysis, as I said before, has been primarily confined to the CCN standards, and we believe that the evidence presented supports SPS's request, of course, with staff's conditions and recommendations. And with that, I'd say nothing more, and I'd welcome the parties putting on their cases and seeing how this process plays out. Thank you.
Thank you, Mr. Bogotko. Yes, I understand that this is pursuant to 6291 and 6296, and you're absolutely right. Thank you for bringing that to the attention of everyone. You mentioned the word staff about 10 times in your presentation. Could you please explain who is your client and what is staff?
My client is the utility division staff of the commission, and they consist of economists, accountants, and engineers. And I have one sole witness in that case, and that would be our electrical engineer, Jack Sidler. And we are charged by statute with trying to formulate positions and present our positions in pursuit of serving the public interest in these cases. And we are always a party to these proceedings automatically by virtue of that statutory framework. And we make recommendations of what staff believes in terms of how these cases should turn out to the commission. You shepherd that decision to the commission, Mr. Hearing Examiner, and then our 5 commissioners in due course get to render their judgment by voting yay or nay on the ultimate outcome of this case, which usually is guided and driven by what you come up with, Mr. Hearing Examiner, in terms of your recommended decision.
Thank you, Mr. Bogotko. That was clear. Appreciate that. Okay, I have been informed that there's been no filing of any public comment or request to do a public comment. I haven't received anything, and my procedural order, I believe, says that anybody wishing to make public comments should notify me in advance. Ms. Kippenbrock, our law clerk here at the Hearing Examiners Division, says there has been no request for public comment, and I don't think there's been any filing without notification, filing to the commission without direct notification to me. So the public comment part of this hearing has just now come and gone, but I wanted to note that for the record. I notice Katie Coleman is on, has joined us. Ms. Coleman, you're an SPS lawyer, am I correct?
Your Honor, Katie Coleman is with OPL.
Oh, pardon me. Ms. Coleman, could you speak for yourself, please?
Yes, Your Honor, it's still me for OPL.
Okay, when you turned off your picture, I thought you might be somebody else there.
Sorry about that.
I have you also in the pleadings as Catherine, so I have that written down here. I have to change my notes. Thank you. Anyhow, I do appreciate, even though Ms. Coleman turned off her video, I actually like the video. I prefer in-person hearings, and this is a Zoom proceeding, and having everyone's face on the Zoom screen is about as close as I can get to an in-person hearing via Zoom. So I prefer that you keep your video on if possible, and if it's practical. I think we're ready to begin testimony. Does anybody have anything else they think we should do before we start admitting testimony? No, good. Well, the applicant is SPS, and I'm not sure which one of you guys is going to present your case, but you can Will that be you, Mr. Walker, or that would be you, Mr. Santos? Mr. Santos? Please, well, for the record, say who you are and then call your witness, please.
Sure, Your Honor. Mark Santos for SPS. I've also got two exhibits that are in advance of the testimony, Your Honor, that we'd like to offer, specifically SPS's application and their notice of filing of the affidavits of publication. We mark our application as exhibit SPS Exhibit 1 and the affidavits of publication as SPS Exhibit 2. We typically offer those in these proceedings to show that we have complied with the statutory requirements in those cases. And so I would offer SPS Exhibit 1 and SPS Exhibit 2.
Yes, I know that's normal procedure in these cases. Both have been filed, of course, as pleadings. It was the initial pleading, and of course, the affidavit of publication. So their pleadings are in the record as a pleading. I have no problem with they also being labeled as exhibits and being admitted as exhibits. There's usually no objection, but I'll go around and ask. Mr. Marks, no objection?
No objection.
Oh, let's see. I'll go by my screen. Mr. Bogatko?
No objection, Mr. Hearing Examiner. Thank you.
Ms. Lynch?
No, sir.
Thank you. Mr. McMillan?
No objection from OPL, Your Honor.
And Ms. Coleman?
She's also with OPL.
Okay, so if there's no objection from any of the parties, the application labeled Exhibit 1 is now admitted into the record. It is evidence at this point. And the affidavit of publication is also admitted in the record as SPS number 2. So we have 2 exhibits in, and now you can proceed to call your witness if you like, Mr. Santos.
Yes, Your Honor. SPS calls William A. Grant.
Okay, is Mr. Grant here? Please.
I am here.
Where are you, Mr. Grant?
I'm sitting next to Mr. Santos.
Oh, geez, I'm sorry. I was looking for a different box. You guys sneak up on me sometimes. Okay, I have his direct testimony in my hand. I also have his rebuttal testimony in my hand. Do you plan on moving to admit both at this time?
We will, Your Honor. Does he need to be put under oath before I lay out that testimony, or when do you?
Absolutely.
propose?
Yeah, I'd like a good foundation, and the foundation could be under oath. Mr. Lee, would you mind swearing him in, please?
Please raise your right hand. You solemnly swear the testimony you're about to give in the matter now pending should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
And thank you, Mr. Lee. And please proceed, Mr. Santos.
So, Mr. Grant, you should have in front of you what has been previously marked as SPS Exhibits 3 and 4. SPS Exhibit 3 is a copy of your direct testimony that was filed in this case, and SPS Exhibit 4 is your rebuttal testimony. Do you recognize those documents?
I do.
Do you have any corrections or changes to make to any of those documents?
I do not.
If I were to ask you the questions that are contained in your direct and rebuttal testimonies in SPS Exhibits 3 and 4, would the answers to your questions be the same?
They would.
SPS offers SPS Exhibits 3 and 4, the direct and rebuttal testimony of William A. Grant.
Mr. Marks, any objection?
No objection.
Thank you. Just to keep the record clean, I'm going to go around and ask and prevent any kind of appeal issues. Mr. Bogatko, any objection?
No objection. Thank you.
Thank you, Mr. McMillan
No objection.
and Ms. Lynch.
No objection.
Okay, there's good foundation laid, no problem, and there's no objection. So obviously, exhibits number 3 and 4 are now evidence in the case. That's the direct testimony and the rebuttal testimony of Mr. William A. Grant. Mr. Grant, now we proceed to cross-examination, and we'll start with Mr. Marks on behalf of Sierra Club.
Thank you. Mr. Lennon and
Yes,
Mr.
sir.
Santos, is there any way that SPS can zoom in a little on the witness? It's like he's hiding in the corner.
Scoot up a little bit here. We can get him a little closer to the screen, Jason. See us a little bit better that way.
Oh, perfect. Thank you. Good morning, Mr. Grant. It's good to see you.
Good to see you.
Okay. Let's, I'm going to start with your direct testimony, and on page 9, where you're
I'm on page 10.
okay. And my questions here just generally relate to your description of the Harrington plant. Are you familiar with the term baseload plant?
I am.
Okay. And what does that term mean?
A baseload plant is a plant that is capable and usually considered to be a unit that could be placed into service and be a base loaded plant. In other words, it runs a lot of hours during the year. I don't know if there's an official cutoff term for base load versus a peaking plant, but it's usually assumed to be a plant that runs quite often.
Okay. Would you agree with me that baseload plants are characterized normally by relatively high capital costs but low fuel costs?
Well, it depends on the application and the other type of resources in the portfolio, but a lot of times baseload plants do have a lower cost, or they're more economic to run. The capital cost, sometimes yes and sometimes no.
Okay, so you would agree that a baseload plant is a plant that the utility intends to run a large number of hours a year because it's a low cost supply of energy.
That is normally the case, yes.
Okay, and so typically in the olden days, baseload plants were coal plants and nuclear plants typically, correct?
Back before we started the SPP market, as you well know, I was over the Transmission Control Center, and no, we had some baseload plants that were both natural gas and coal, and depending on where they were located in the system and the topology of the system at the time.
Okay. Would you agree that Harrington was designed to be a baseload plant?
I would agree that Harrington has been considered a baseload plant.
Okay. And in your testimony, you mentioned that Harrington was designed to be fueled by either coal or gas. Why was coal selected?
Coal was selected for diversity of the portfolio. Basically in the 80s, if you remember, and I'm probably dating myself a little bit, you had the Natural Gas Act of the 80s during President Carter's administration. And gas was considered to be a limited resource at that time. And so SPS had decisions to make and to diversify the portfolio. And our cheapest option at the time was to build some coal facilities.
Do you know if coal was cheaper at the time?
Coal was not a lot cheaper at the time because I think coal would have been probably about a $14, $13 resource at that time, but natural gas, depending on the efficiency of the unit, natural gas was running below $2 at the time. So it might have been a little bit more efficient, but it was not the primary need to diversify the coal at the time.
Let's move ahead from the 1980s to the past 5 years or so. On page 14,
Mr. Marks, lest I be confused, you were referring to page 9, but I didn't really understand exactly what part you had questioned this witness about. Where
he was giving the history of the plant, and I was asking questions about that.
okay, well,
Fill in some
okay.
details.
So you weren't finding any contradictory statements in his explanation compared to his overview on page 9, right?
No, and
Okay.
I'm trying to give the commission a complete record on some things that I think are material.
I'm sorry, I just wanted to make sure I was following your cross-examination. So please proceed again.
Okay. And so, Mr. Grant, when did you personally first learn that there was going to be a compliance issue if Harrington continued to burn coal?
My recollection, when we got the report from the monitoring stations out on the facility, I knew that there was monitoring stations, but as far as having a compliance is when we got the final report.
So the final report with how many years of monitoring?
If I'm not mistaken, then the monitor was required to be there for 3 years.
Okay. So no one in the company informed you about the results after year 1 or year 2, to your recollection?
I think there were some high-level discussions that we might be over the limit at times, but no, as far as knowing that we had to do something and that we were potentially in a non-attainment area, it was towards the end of that 3-year period.
So as I understand what you're saying, prior to the 3-year period ending, the company did know that non-attainment would be likely.
I think what I want to clarify what I said. Towards the end of the 3-year period, and after the 3-year period was over, when we started started conversations that we were potentially out of compliance with what the report was going to say, is when I first became aware of it.
Okay, so that's you personally.
Yes.
Do you recall when the company first requested a bid for the gas supply pipeline?
I personally do not. I know about the time frame when we decided to that was a good possibility for us, and we needed to get a good estimate of the pipeline. So it's about that time frame, but I do not have the specific date.
Okay. Do you have a date range, or you just can't recall at all?
I can't recall. If I had something to look at, I refresh my memory, but at this point in time, I cannot recall.
But I don't think I have that exhibit prepared, so we'll move on. Am I correct that one of the major points that you and the other company witnesses are making in your rebuttal testimony is that the only physically possible way for the company to obtain the capacity resources needed in 2025 to replace the Harrington coal plant is the company's proposed gas conversion?
For 20, no, I think if early in the case, the proposal from the Sierra Club was to shut down all 3 coal units. And we did not believe that we would have been able to supply enough capacity to meet that requirement. If you know anything about the SPS system, the load is growing, specifically in the New Mexico area. So, our resource plans show us, right now that we're still have some link, but that link is closing. So when I wrote the testimony, I was basically referring to shutting down all 3 units. However, the question you're asking me is, meeting the capacity requirements. There's a lot of other factors involved in why we believe this is the best decision.
So do you, in your rebuttal testimony, do you or don't you testify that the only physically possible way for the company to obtain the capacity resources needed in 2025 to maintain reliability is this proposed gas conversion, and that there are no other physically feasible options? Yes or no?
Mr. Marks, can you help us with where you are in his rebuttal testimony?
All right. Mr. Grant, do you need me to direct you to some specific point?
Yes, you're asking me a specific question, so it'd be nice to have that in front of me.
We have pages 3 and 4.
Okay, I'm there.
Mr. Marks, you're referring to the language, and I'll read it. Harrington remains necessary after 2024 for capacity and transmission voltage support. Is that what you're referring to?
Yes. And continuing, SPS cannot retire without corresponding replacement of these needs. But I believe if you
I guess that's the source of my confusion. He's addressing all units here, and I think your question specifically went to one unit, Mr. Marks.
No,
So that's where
my question did not go to one unit. My question was, is it not the company's position on rebuttal that it has no
only way to
it has no
maintain
physical it has no physically possible alternative to supply the capacity needed by Harrington other than this gas conversion? And I'm speaking of the 3 units.
It is my testimony that we do not have good options to replace that testimony, and would be very difficult, if even possible, to do so by that time period.
Okay. So very difficult, possibly impossible.
To replace the capacity, and you have to understand what I mean by capacity, because there are a lot of things that come into play. In SPP, you only get accredited capacity if you have firm transmission service. You can only connect to the generator if you can get a generator in the queue and get permission to connect. So yes, for all those factors, yes, that is my testimony.
Okay. And so without approval for the gas conversion that you're seeking in this CCN case, reliability would be in serious jeopardy, correct?
Reliability is a different issue than what you're asking me. You're asking me about capacity. We have other reliability issues as well, but capacity, if we retired all 3 coal units, we would be deficient of our capacity requirement.
Okay.
Yes.
And it's possible that for a summer peak that you wouldn't have sufficient resources to meet load.
We would not have, and I think, as Mr. Marks will know, we participated in a market. So, to not serve load would, depending on what the rest of the Southwest Power Pool footprint, we would not have enough resources, and we would be failing our reliability obligations if we retired all 3 units and did not replace them before the end of 24.
And if we can go back to your direct testimony, page 13. And line 13. You discussed the 2021 updated Harrington analysis, economic analysis, correct?
I do.
Okay, so in 2021, the company did an economic analysis of the gas conversion versus potential alternative resources, and that's the analysis that supports your filed case, correct?
Yes, it is.
Okay. And am I correct in understanding that the company cannot acquire the resources that were used in that model as alternatives if the commission was to reject the 3-unit conversion and require that they be retired?
I would think that Mr. Elsey is a better witness to answer that question as far as the details of the analysis.
I'm not asking you. I'm sorry. Did you have more to say?
No.
Okay, I'm not asking about the economic analysis. I'm saying that I'm not asking about the details of the modeling or the results, but you do know that Mr. Elsey modeled the 3-unit gas conversion versus an alternative in which the 3 units are retired and replacement resources were acquired, correct?
Yes, I'm aware of that.
Okay. And my question is, am I correct in understanding that if the commission decided to reject the CCNs and ordered that the plants be retired, that the company would not be able to acquire the resources that were modeled as alternatives?
Yeah, and the reason I think Mr. Elsey is a better witness to answer that question is I do not know what stage of the process these bid resources are in. I don't know if they have signed interconnection agreements. I don't know if they where they're at, if they have all their permits and everything else. So again, that would be a better question for Mr. Elsey.
What's Mr. Elsey's title?
He's a director of our resource planning.
Okay. But you did agree. Okay.
I'm sorry, the answer again, what you just said?
I'm sorry, Mr. Lee, is that for me or Mr. Grant?
Go ahead, Mr. Marks.
Okay. So, Mr. Grant, you agreed with me that the company has no plausible, or you agreed with me that it would be difficult to impossible for the company to acquire resources necessary to maintain its reliability standards and its requirements with the SPP if the gas conversion is rejected. Yet, you're not able to say whether the resources that Mr. Elsey modeled could be acquired, and those two things are inconsistent. Can you explain that, how those two things could be true? That you know that it's difficult to impossible to acquire any resources, but you're not sure if the specific resources that Mr. Elsey modeled could be acquired.
Yes, and so let me explain why I testified the way I did, and then the devil's in the details, which Mr. Elsey would know. My understanding is there was only one facility that already had a signed interconnection agreement with the Southwest Power Pool. And if you've been following the Southwest Power Pool interconnection agreements, they are still working on the 2017 interconnection study in SPP, and this is 2022. And we still don't have an answer of if any of those generators are going to stay in, or even if they do, what the cost is going to be to connect them. That's phase one. Phase two, in order to count towards our capacity requirement, even if one of these generators that were bid into the process were to qualify for our capacity, we would have to then ask for transmission service through the Southwest Power Pool Ag Study. And
we would have to ask.
We would have to request service through Southwest Power Pool's tariff through what's called their Ag Study to see if there's any transmission upgrades necessary to deliver the energy to our load. And that is a separate process than the generation interconnection study. So for those reasons, Mr. Marks, yes, my testimony, it would be very difficult, if not impossible. But as far as the details of what each resource and where they're at in the process, that would be a better question for Mr. Elsey.
For sure, but you would agree with me that the universe of all potential options, which, as you understand it, none of which are likely to be available in sufficient quantities to meet the needs in 2025. All potential options includes, by necessity, whatever specific alternatives Mr. Elsey modeled, correct?
That was the information we had in the model and the purpose for the RFI. So yes.
Okay. Mr. Grant, do you discuss in your direct testimony the known difficulties and obstacles to acquiring alternative resources to the Harrington gas conversion?
In my direct testimony?
Yes.
I think I testified it was difficult. I don't know that I got into the specific details that I just talked about today. And I don't remember seeing that when I reviewed my testimony in preparation for this case.
I don't think I've seen it, so I'm wondering if you can point me to it where you talked about the difficulties or the lack of options.
I did talk about the voltage support. I did talk about, I don't think I got into the generation interconnection queue. I do think we answered some discovery on it, if I'm not mistaken, if my mind is right. But again, as far as managing the RFIs and where these are at and the difficulties, I do think Mr. Elsey did address those.
All right, we'll move on. Page 15 of your direct testimony. Line 16. You say that the,
I'm sorry, Mr. Marks, I have 15. Oh, no, never mind, I was on my result. I was gonna say that was my verification.
wishful thinking that we're going to be there already.
I'm on line 50, page 15.
Okay. You testify that the converted Harrington plant will be capable of performing as a baseload, intermediate resource, or a peaking resource. With respect to its potential operation as a baseload resource, does it have low fuel costs?
What I've referred to in that line of my testimony is the capability of being there, and none of us have a crystal ball about what fuel and other fuel alternatives or anything's going to do. It has the capability of running 8760 if necessary. So it can run as a baseload unit. I didn't testify that economically it would. So what I basically said, this is a resource that has flexibility. It can run as a baseload unit, it can run as a intermediate unit, or it can run as a peaking unit, or it can run as a unit that provides ancillary services. So that phase of my testimony was not me testifying that it would run as a baseload unit. It had the capability of doing so.
Okay. And the specific heat rates for the converted units are information that the company has designated as a trade secret. So I won't try to put any of those numbers in, but I think it's not a trade secret that a steam cycle plant has a pretty inefficient heat rate compared to other alternatives. Would you agree?
I would agree that a steam resource with a reheat turbine, the heat rates are pretty much universal. And yeah, there are some other alternatives that would be cheaper than that as far as newer technologies, yes.
I mean, for example, combined cycle plants will have a much better heat rate, correct?
Combined cycle heat rates, I would say in the ballpark, anywhere from 25 to 30% more efficient.
Somebody whispering something? If so, please don't, just to keep the record clear.
And you mentioned has the capability of operating as a peaker. How does it compare to peakers, which are aeroderivative turbines?
It would have the characteristics of most steam units. In other words, you got to fire up the boiler and heat it up. So it's a little bit slower start. Some of the aeroderivatives can start within 10 to 30 minutes. It would probably take, if Harrington was hot, you could get it started in 2 hours. If it's cold, it would be a little bit longer than that. So it would have the operating characteristics of a regular steam driven steam turbine plant versus an aeroderivative that usually has a startup motor and you put gas to it and it starts up anywhere from 10 to 30 minutes.
Okay. Does it have the quick ramping flexibility that's desirable to follow variable renewables?
Yeah, because of the size of the unit, Harrington would probably, carry a ramp rate. Don't want to be specific, but greater than 5, in the range of 5 to 10 megawatts a minute.
Is that as flexible as a turbine?
Well, there's other factors in the turbines. Usually turbines can be, you can regulate real fast with turbines. However, a lot of times with turbines, aeroderivative turbines, you have tuning issues that would come in, and And so it depends on how the aeroderivative turbine is tuned. Some turbines have a lot of flexibility, but some of them with tuning issues cannot ramp that fast because of environmental issues.
Do you think if we were here in a CCN case where the company was seeking to have a LM 6000 approved, you'd be as no, I'll skip that.
Thank you, Mr. Marks.
We're not. Let's just move on. On
Was that
page
LM
17.
as in Mary? Was that LM as in Mary?
Yeah. Yes. Lawrence Mary 6000. And
Thank you.
on page 17. Let's go to page 18 here. Page 18, you're talking about voltage support. And is that one of the ancillary services that you were discussing earlier?
Yes, it is.
Okay. And can the Harrington units provide voltage support or other ancillary services when they're not running?
In its current state, no.
And so as a coal plant, as a coal-fired steam plant, it only provides ancillary services when they're hot and running?
Yes, the Harrington, whether it's coal or gas, can only provide ancillary services when they're operating at this point.
Okay. Is there some plan to change that?
One of the options, as you will know, because it's been in the previous case, that when as we get higher levels of renewables, rotating mass becomes an issue. We always will look at, when we do retire units, of converting those units into synchronous condensers, if you're familiar with that term.
Yes. So I mean, so with respect to the coal plant, it's correct that the company has or will be installing the synchronous condensers so that the facility can provide voltage support during the 6 months that the plant is not burning coal and not generating energy, correct?
They're already installed and operational.
Yeah. So theoretically, voltage support needs could be met with synchronous condensers installed at Harrington as well?
We'd have to look at it and do some planning. The TOC configuration allowed us to be able to put in a decoupling. So not all plants can be converted. It'd have to be a project that we would have to look at and analyze, but it's always an option that we would do when we retire the unit. Voltage support, however, being only one of the issues that I have testified to. There is a cost. There is a cost to doing that as well.
It sounds like the company has not analyzed whether it would be cost effective to provide ancillary services at the Harrington location using condensers and other non-generating technology. Is that correct?
I don't know if there's anybody in our company that's looked at that or whether Mr. Elsey looked at it or not, but I have not.
Okay. Do you know if the company assessed whether Harrington can provide adequate voltage support in the 1-unit retirement scenario?
We provided an analysis, but I don't know if it was the exact configuration of 2 of them being operating and 1 not. But one of the things it did show is that when Harrington was not running, at times there were some voltage and transmission issues.
And when you say when Harrington's not running, you mean all of the Harrington units are not running?
I would have to refamiliarize myself with that study that we did that is in the record, I believe.
Where would it be in the record?
I think it was in Mr. Elsey's. If not, it was also a discovery question.
Okay. On page 20. Lines 5 and 6, you discussed the possibility of installing up to 340 megawatts of solar at the location.
That is correct.
Okay. Does that mean that SPS could have 1,050 megawatts of gas generation at Harrington online, and then also 340 megawatts of solar at the same time?
340. Sorry, you said 430. It's actually 340 in the testimony.
Oh, I read 340. So should I re-ask the question?
No, I just wanted to clarify, lest there be any confusion, and he acknowledged the wrong number. So I'm sorry. Please continue. Well, can you restate the question, please, Mr. Marks?
Okay. Does this mean that SPS could have 1,050 megawatts of gas generation at Harrington online, plus another 340 megawatts of solar at the same time?
Yes, and let me explain that. That's called a net zero concept. We have interconnection rights at the Harrington units equal to their capabilities today. As long as we don't exceed that generation, we can complement that generation with renewables. And as long as we never exceed and inject more on the transmission system than what our interconnection rights are. So the answer to your question.
I'm sorry, as long as we never exceed, and you garbled for a moment.
As long as we never exceed the cap on our interconnection agreement, we can complement the generation there with renewables.
What is that cap?
The interconnection agreement, I believe, for depending on which unit you're talking about. If you're talking about Harrington 1, it's 340 megawatts.
What is it for the 3 units in aggregate?
1,050, 1,055 comes to mind.
Okay. So you could not then have all 3 units running on gas at full output and then also have solar at the same time?
No, it's one or the other, but I can have a combination of the assets up to the interconnection agreement.
Okay.
Yeah, and I think it's important to be on record. You can only do that when the anchor unit is still operational.
Online, on page 22, line 17 and 18, you say the conversion will provide SPS with more flexibility with respect to dispatching resources. What do you mean by flexibility?
Flexibility is, it takes a portfolio to operate a system, and also it takes locations. As you know, when our system was built out, generation was located at specific reasons, and the transmission location for a reason, and the transmission system was built up around those. So what I mean by more flexibility is, number one, the converting the gas units are a little bit traditionally more flexible as far as their operating parameters than the coal unit would be, because of the size of the coal handling equipment and all the other issues. But we have plants that can be called on to run for reliability, and they can operate. They have great ramp rates, as you mentioned before, but they also have good turndowns. We've done a lot of work to get those minimum loads on those units to a very low level, and then they can cycle and come on and off. And I believe we can cycle it off, bring it back on in a 4-hour time frame, if I remember the parameters right on that unit. So I meant by having flexibility, and then because those units are there, if we do complement that with renewable resources, we would have that flexibility as well. But it really goes back to, it can provide the voltage support. If we're heavily importing, it could provide that pushback on the system to minimize the flows on certain of our transmission lines. And it has a lot of flexibility as far as providing ancillary services and capacity.
When you were talking about the resources that could cycle on and off, were you talking about Harrington, or you were talking about other gas resources with different characteristics?
I'm talking about Harrington as well, but we have other units that do that in other locations of our system. And like I said, it really takes a portfolio to operate a system, because you never know when. There's always, the system is never intact. And that's one thing you get when you look at models. You always either have some maintenance going on, you might have a transmission line out, and location of generation in those cases matter.
So on the same page, line 6, you say Harrington units will continue to provide low-cost capacity, dispatchable energy, and transmission reliability. I think you've been talking about that here. I want to ask about the energy side of this. Are you aware that Ms. Glick in her direct testimony shows that in the company's own Harrington modeling, Unit 1 would have a maximum capacity factor of 0% after the gas conversion? In other words, it's never used.
Did you say Ms. Glick's testimony?
Yes.
Yes, I am aware that she said that.
Okay. Do you agree that this is what the results of the company's own modeling, on which its direct case is based, showed?
I agree that we ran a truly economic model, and economic models have very little flexibility on the heat rate. And I think Mr. Elsey can go into this in more detail. But from my standpoint and my expertise in my area is, this completely misses the times it would be called on for economics. I mean, not for economics, but for system reliability. It completely misses the times that they would be called on for the reliability of the system. And for example, the Harrington units, we offer them up as economics today, and they are mainly started for economics. However, there are times when the market will commit these units in what's called a reliability unit commitment. And that would still happen in the future as well. And that is not included in Ms. Glick's model.
Well, we're not talking about Ms. Glick's model. We're talking about the company's model.
Even in our company model, and the Encompass model is a true economic model that takes very factual heat rates, and if there's any minute difference, it'll always dispatch the cheapest one. So in the operating world, the market models do not necessarily always operate that way. So I do agree that that's what the models showed, but I do also disagree that in my experience as an operator, as running the control center and over our markets, that the actual dispatch will vary from that.
And then you agree that SPS's models in its direct test that underlay its direct testimony showed that Unit 2 ranges from a 0 capacity factor to a 1.9% capacity factor, depending on year?
I am aware that that specific economic analysis showed that, yes.
Okay. So there's some years in SPS's modeling when Unit 2 was not used, correct?
That's a question for Mr. Elsey, because I did not analyze all the different gaps. And I looked at the total percentage when I prepared my testimony.
Well, I'm pretty sure you understand this better than me. I was assuming that when there's a range from 0 to 1.9%, that means there's some years when it's 0. Am I correct in that assumption?
I think you're correct in your assumption as far as how that model works, but as I testified earlier, an economic model is a guide to help you make decisions, but there's a lot of things that aren't modeled, and I think I've already testified there's times when Harrington is dispatched by SPP just for reliability reasons that are not in your model.
Okay. And for Unit 3, you agree that the company's modeling showed the capacity factors range from 0 in some years to 3.9% as the highest in others?
I believe that's what the output of the models are showing, but again, I think Mr. Elson explained his models better than I can.
Okay, and I think you covered this, but I just want to make it clear. These were economic models, so pure economic models. So this resource was rarely selected because it's not very economic compared to other resources that are available. Is that correct?
I don't think I can make that statement because the Encompass model is so specific in what it picks dispatch units. When I don't know how much disparity there was between the next unit that was picked, if you understand what I'm saying. In other words, there might have been a 0.01% difference in the heat rates, and your Encompass model is always going to pick that unit to run, when in the real world that's not necessarily the case. So I think what you're hearing me say is an economic model is going to be, it's not that flexible unless you build that into your parameters. It picks the most economic models, and yes, our results did come in with numbers that low. I'm an operator. I think the units will run more than that's my testimony.
And is there any place in the company's direct case where it informed the commission of the 0 capacity factor for Unit 1 in the company's own Harrington modeling?
Again, I didn't testify or do anything on the modeling, so that would be a better question, better for Mr. Elsey.
Well, but you introduced the witnesses in your testimony, and you're the leader of this team. It's not a great number, 0%, 0 use in your own modeling. Did the company disclose that in its testimony? Yes or no?
Your Honor, I'm going to object to ask and answer. He's pointed Mr. Marks to Mr. Elsey, who is the modeling expert presented by the company, who is the right person to ask this question.
This is cross-examination, and I allow a lot of leeway in cross-examination. Sometimes the answer to the question isn't the most important part of the question, if you know what I mean, or the important part of the testimony. So, Mr. Marks, if you could keep this cross-examination moving, I would appreciate that. And for now, I'll overrule the objection and allow you to re-ask the question, and then we can move along with that.
And I think Mr. Grant has stated it doesn't appear in his testimony. We'll ask Mr. Elsey. I think the testimony speaks for itself.
Which part of the objection you're arguing, but okay then.
I'm going to move along.
Thank you, sir.
Page 23, line 7. You say a decision to retire Harrington without a replacement resource could result in rate shock due to the need to accelerate collection of the remaining balance. Mr. Grant, am I correct in understanding it's the company's position that any retirement of Harrington should result in accelerated collection of the remaining depreciation expenses?
I don't think, let's see. The purpose for that statement is that, SPS has made prudent decisions, and most of our decisions have been approved by the commission in previous cases. You run into a couple of things if you don't accelerate the depreciation, and because you're going to have to replace its generation as well. So that's what the purpose for this part of my testimony is. If you do accelerate the depreciation, I'm not an attorney, and I'm not about to tell the commission if they're going to accelerate the depreciation or not. But if they choose to do it that way, that would be rate shock. But the purpose of this was to understand that there would be depreciation. There also would be replacement cost. So yes, I do believe that that would be not a good thing for my customers.
This is a CCN case about a pipeline. I'm letting you go, Mr. Marks, and I'm just hearing a lot of stuff that's not related to a CCN case about a pipeline. I'm hearing rate case stuff. I'm hearing, shutting down, retiring this plant, and I'm hearing the alternative renewables come in, and all of this stuff is relevant. However, the most relevant is whether or not there should be the pipeline, because that's what this case is about, approving the cost for the pipeline. So I'm just trying to help maybe get more effective cross-examination.
Mr. Lennon,
Yes, sir.
I think each party is entitled to make its case, and I'm sorry,
I do too.
A case that's resonating with you. As Mr. Sidler testified, one of the criteria for granting a CCN is that it's the most that the proposed alternative is in the public interest because it's the most cost effective. It's Sierra Club's position that there were cost effective alternatives potentially, and they're lost and the company has backed the commission into a corner.
Tried to.
And that's maybe water under the bridge, but it's the context for this case that there are potentially more cost-effective alternatives. The company is acknowledging that there are no realistic alternatives, cost-effective or not, at this point because of the timing. And then as Mr. Smith has previewed for you, and we're getting to, is that there still is one way to at least save some of the bathwater here. And that is to at least not waste the money of converting one of these units, which never runs. And I'm sorry that my cross is not making that clear, but hopefully our briefing will.
Thank you, sir.
Let's move on to, and Mr. Lennon, you know, we are going to talk about these rate case things with respect to his rebuttal. And I just apologize if it doesn't seem relevant to you, but well, you know, you say the word apologize, but then you imply that it should be relevant to me, that it's not. You know, I can read between all the lines as well. So I appreciate that. And you know, I don't want to interject what I'm feeling here with into your case. I want you to be free to present your entire case as far as you want to develop it. That's fine. And you know, you have a right to do all the cross-examination you want. So please, you're welcome to proceed. I want you to be as effective as possible. Thank you, Mr. Lennon. And it's actually always pleasure appearing before you because of that. And I appreciate that you don't take offense. If we could go to page 5 of your rebuttal, Mr. Grant. And on page 5 and 6, I understand it to be your testimony that current retirement dates for Harrington result from agreements in various cases to extend the lives. Is that correct?
That is correct.
Okay. So is it also correct that your testimony means the company entered into various stipulations that included depreciation schedule extensions for the Harrington units?
Well, it's my testimony that we've had stipulations, but we've also had litigated cases as well.
Okay. Extending the depreciation schedules benefited customers in the short term by reducing the depreciation cost in the cost of service, correct?
Yes, that's usually the case.
Okay. Were there also benefits to shareholders?
Well, I think when you enter into stipulations and orders in the commission, I think the commission and the stakeholders in the case has found it mutually beneficial.
Okay. Is there any benefit to shareholders from extending the depreciation schedule for an asset?
Well, it really depends. If you're talking about recovering an asset over a longer period of time and earning on that, yeah, that's one benefit. But there's also benefits for not extending them as well.
Of course. So when the lives are extended, shareholders are able to recover more profits as their authorized return on the undepreciated balances than they would have if the plan said depreciated in accordance with their original lives, correct?
That is correct. When it's been determined that's the best interest for our customers, yes.
Okay. Good. And page 6, line 16, you ask yourself a question about Ms. Glick's suggestion that SPS should have more thoroughly considered replacing Harrington with a new gas-fired facility. What part of Ms. Glick's testimony were you referring to there?
The fact that she had facilities in her model as some of her model assumptions. And she had turbines. I don't know if she identified them as gas turbines, but I mean, they were the traditional gas turbine. But they were in her model.
Would you? Would you agree with me? She included in her model resources that perform like gas turbines to be added after 2030, but did not specify gas turbines.
I don't necessarily, I mean, I do agree with you that she didn't necessarily identify the fuel, but even with that, there would have been whatever the fuel was going to be would have required assets as well.
But she didn't expressly recommend a specific facility, specific gas-fired plant to be constructed to replace Harrington, did she?
Not to my knowledge, but that might be a better question for Ben. I think she had generic placeholders.
On pages 8 and 9, you discuss Ms. Glick's testimony about the LMP, whether Harrington has been an economic use unit in the past with respect to the LMPs.
That's correct.
Okay.
Is that L and P or L?
L as in Larry, Mary, Paul.
Thank you.
You allege that Ms. Glick has been mistaken in her prior testimony about the economics of Harrington. Are you referring to case number 19-00170 UT?
As Mr. Marks knows, because I've been in front of him before, I'm not the person that memorizes case numbers, but I believe that's correct.
That would be the last rate case?
Yes.
Okay.
Besides the one that's still pending.
I'm sorry. Is it correct that that case 19-00170 was resolved by a stipulation in which Sierra Club joined?
Yes.
Okay. And because that case was resolved by a stipulation, were Ms. Glick's claims ever adjudicated in that case?
They were rebutted, but they were not adjudicated.
Okay. Do you recall that prior to the stipulation, Ms. Glick was critical of SPS for self-committing its coal plants in the SPP?
I do.
Does self-committing mean that the utility commits the plant to run at certain times instead of letting it be dispatched only when it is the most economical resource?
That's what self-commit means, yes.
Okay. Do you recall that SPS changed its commitment practices for its coal plants in or around 2019?
I don't know exactly when the time frame. We've been working gradually ever since we entered into the market to change. We've made some great strides at different times. If I remember in 2019, we made improvements to the turnaround time that greatly improved the amount of times it could cycle. But we've been making, we continue to make improvements to the flexibility of our units.
Okay.
And I don't know if that was all, there was not a specific time that a specific improvement increased our flexibility. We've been working on it since 2014. If that helps or confuses the matter.
Well, I didn't ask so much about the flexibility of the unit, but whether you changed your operational practices to reduce or eliminate self-commitment and let the units be dispatched, follow the market.
Yeah, so let me explain why my previous answer was important. SPP is a day-ahead market clearing only. And if we didn't self-commit before we made some of the improvements that I'm talking about, the market would have never seen the unit to commit, and whether it was the most economical asset or not, if it had just been turned down or some other parameters. So when SPS changed its operating parameters to where, regardless of the condition it would be in, the day-ahead market would recognize it, that started allowing us not to self-commit as much or even at all, unless we needed a environmental test or some other test that we had to do on the border. I hope that helps clarify my answer.
Okay. Sure. Can you take a look at Sierra Club Exhibit 10, please? And I'll direct you to page 6 of 6 on our header on the upper right.
Okay, I'm there.
Okay. So we're looking at 3 tables that show annual data from 2015 through 2020 for each of the 3 Harrington units.
Yes.
Okay. And in column B, we've got capacity factors.
That is correct.
Okay. Do you agree that this exhibit shows material decreases in the capacity factors between 2015 and through 2018 versus 2019 and 2020?
Okay, can you repeat that question again, please?
Sure. Do you agree that the data shows material decreases in the capacity factors for the period 2015 through 2018 on one hand, and then 2019 and 2020 on the other?
Yes, I agree, and that's not in conflict with my previous statements.
Okay. And you were a sponsor of this discovery response?
Yes.
Okay. Mr. Lennon, I'd move admission of Exhibit 10.
Yes, I'm looking at it right this minute. I appreciate it. Just give me a minute. Exhibit 10 is a, well, you're admitting it for the purpose of the chart at the bottom. However, the actual document is more than just the chart at the bottom. And the rest of the document is characterized as a general objection. Well, yeah, it's characterized as a general objection, which of course has not been ruled upon. Let's see if there's any objection to admission of the entire document, unless you want to admit only the part you've referred to. How do you want to do that?
Mr. Lennon, I only need that one page, but since the document's already prepared in this form,
Yeah.
I think logistically it'd be easier if there's no objection to it, to taking it in its entirety.
Yeah, I just, I understand what you're saying. And if you understand what I'm saying, when I'm going to pull this and review it later, I'm going to be looking at an objection. You know, rather than the part of it that concerns you and that you've cross-examined this witness. So I think I can figure that out now that I've reviewed the whole thing. And even if we admit it in its present form, where only the part you've crossed about is on page, well, the pages aren't numbered. Yes, they are. Yeah.
And Examiner Lennon, if I could be heard.
Well, I was about to ask if there's going to be any objection to the admission. So yeah, let's start with you, Mr. Santos, on behalf of SPS. What's your objection or your comment?
We don't have an objection to the whole document coming in. It is a discovery response, and the general objection that you're referring to is a portion of that discovery response. So from an optional completeness standpoint, to make sure the record's full and fair and complete, I'm fine with it all coming in. I don't think we should just admit one page of it.
Okay, well, I understand your position. It explains to me and anybody else that might be reviewing the record that there was an objection, that it was only a general objection, not specific objection. And so I get it and I'm inclined. Let's see if anybody else has any issues with it. Mr. McMillan,
No objection.
Ms. Lynch,
No objection.
and Mr. Bagatgo.
No objection, Mr. Hearing Examiner. Thank you.
You guys are really good with that stuff. Thank you very much. And the entire document labeled as Sierra Club Exhibit 10 is thereby admitted into evidence. Let me give me just a moment, because now we've gone into where we've skipped from Exhibit 4. Oh, sorry, that's the SPS evidence. I'm getting confused. So this is number 10. We skipped 1 through 9 at this point. Admitted into the record, Sierra Club Exhibit number 10. Sorry to be so overly thorough about this stuff, but I'm like that. Thank you, Mr. Marks. Please proceed.
Okay. Page 11 of your rebuttal, where you're concerning recovery. Okay. Does SPS believe it would be confiscatory to deny it the ability to
I'm
recover?
sorry, believe it would be,
Confiscatory
thank you.
to deny it the ability to recover the undepreciated plant balances at Harrington if the plants are retired earlier than their current useful lives?
Well, Mr. Marks, I'm going to prove that I'm not an attorney. Can you define compensatory for me?
Unfairly taking the company or the shareholders' property right.
Okay, so in that context, can you repeat the question, please?
Yeah. Do you believe it would be confiscatory to deny SPS the ability to recover the undepreciated plant balances at Harrington if the plants are retired earlier than their current useful lives?
Yes, I do think it would be unfair for several reasons. Number one, that plant has actually operated well beyond its original CCN, which was a 35-year time period. The second part of it is that we have extended, but that was mutually beneficial to the company and the customers. And we have any depreciation still left on the books has been to the benefit of the company, and we have prudently operated this plant. So yes, I do think it would be wrong to deny us recovery.
Okay, and so that undepreciated balance is investments that the shareholders made during the construction, or actually during the life of the plant, that they have yet to have the opportunity to recover, correct?
That's correct. That's why there's still an undepreciated balance.
Okay. Okay. What if the commission permitted full return of the remaining investment, but denied return on the investment, denied a profit on the remaining investment? Would that still be confiscatory?
I believe it would, for still the same reasons I mentioned before. The plant's been operated prudently. It's served well beyond its useful life, and it still continues to do so. So yes, we do believe that it would be punitive to deny the company recovery on.
So even if the shareholders got back their investments, it would be punitive if they weren't also able to earn a profit?
That's the same question, and he didn't quite clearly answer it. I understand that. That's the same question.
Yeah.
And he didn't have a good answer to it.
Okay.
Did you understand that question, sir? He was not talking about the principle of the depreciated figure, but the interest on the depreciated figure, so to speak.
Yeah, so I thank you, Examiner. I did understand the question, and like I
Thank you, sir.
said, the company made this investment prudently and has depreciated over the life of the project. And yes, a company, when they make an investment like this, makes an investment to serve the best interests of their customers, but we're also making that investment to earn that return on our investment.
Thank you.
Okay. But isn't it true that the shareholders have already received more total return on the Harrington investment than they would have if the plants had retired as originally scheduled in the last decade?
That would be completely ignoring, in my mind, the cost of carrying the capital and everything else, and making a general statement that, hey, you invested X amount of dollars, completely ignoring the other investment that's happened over the life of the project and the carrying cost and the cost of avoided other places where we could have invested that money. So no, I understand what you're saying, but I do not agree with the premise of your question.
Well, it sounds like you agree that they have already received more total return, but you're saying there's some offsetting costs to them. Is that correct?
I have not done the analysis on the other impact and how much we've actually returned. I do know that it has been extended past its life, so I can understand where you might be in theory saying we return more. I don't know that for a fact, number one, but even if that was the case, there's other things to consider, like the alternatives we could have had, the other investments we could have made and everything else. So number one, I don't know the answer to your base question of have we earned more, because the 35 years would have been up in 2015, I believe. Maybe earlier than that, 2010, somewhere in that range. So I don't know the math of whether we have recovered our original investment plus any other approved capital investments since that time. I don't know the answer to that. But the rest of my statement was, by extending it, just because you earn more than that money, there's also other factors to consider.
Well, is it? Yeah, I haven't run the numbers, but isn't it mathematically the case that they had to recover more return already? Since, I mean, return is the undepreciated balance each year times the rate of return, and they've been getting it for an extra 5 or 10 years. That they wouldn't have gotten if they retired sooner, correct? It would have gone to zero.
We were returning less of that capital investment than we otherwise. I don't know the math on it, Mr. Marks. So my answer to the question is, I don't know. It's plausible, but I don't know.
Okay, that's a good enough answer for me. Did any SPS witness rebut Ms. Glick's claim that the savings to ratepayers from allowing full return of the remaining plant balances, but denying return on investment?
Sorry, Mr. Marks, you broke up just for a second there. Can you re-ask the question?
Oh.
Hey, can I just ask a question real quickly, Examiner Lennon?
Yes,
You
sir.
referenced earlier us potentially taking breaks every hour or so.
Exactly. You're reading my mind, actually. I was trying to find an opportune moment to interrupt Mr. Marks' cross-examination. And I think this is a good time. And thank you for interrupting. Mr. Marks, how much more cross-examination do you have of this witness? Are we 1/3 through? 2/3?
Just in terms of pages, I had 5 pages and I'm on page 5, but at the top of it, so 20%, 20% of my cross is remaining, and I thought it would go quicker. Okay. Probably about 20, it's got to take at least 20 minutes at the pace we're going, so it'd be a good time to either break for a break or for lunch.
Well, it's almost, it's 2 minutes to noon or so. I usually like to take lunch breaks at the end of a witness testimony, but we're really due for a 5-minute break. Why don't we take 5 minutes now and then come back and conclude his cross by you, and we'll find out who else has cross of this witness, and then we'll take a lunch break. Yeah, it sounds good to me. So let's recess for 5. We'll be back at call it 12:04. Thank you. We're on recess. Okay, we're still off the record, Mr. Lee, not yet. We'll wait till everybody looks like they're present. And thank you, Mr. Marks. I understand your position. I'm also, it's interesting, I'm kind of trained to hear not what people say, but what they mean, which is a really interesting way of looking at communication. And, you know, I heard from this witness, we're off the record, by the way, still waiting for Mr. McMillan. And I see Miss Glick was tuning in. Okay, there's Mr. McMillan. Not to waste any time, let's get back on the record. Mr. Lee, are you ready?
Yes, sir.
Thank you, everyone. And it's 12:05. We are back on the record, just about 1 minute, just about on time. So we appreciate that. Next thing we're going to do is hear the rest of the cross-examination. Hopefully it's only going to take 20 minutes or so, and then we're going to hear if there's further cross-examination. If there isn't, we'll release this witness. If there is further cross-examination, we are going to take a lunch break. Yes, Mr. Mark.
Examiner Leonard, I just want to make sure. I just want to make sure we'll have an opportunity to do some short redirect. I think I might have a few clarifying questions following that cross, if that's okay with you.
We'll either do it. Yeah, I shouldn't have said we'll excuse this witness. What I meant is it would be a good opportune time. It'd be an opportune time to take a lunch break. You know, I think a good opportune time is an advantageous redundancy. Okay. Let's continue, Mr. Marks, please.
Okay, Mr. Grant, did you anywhere in your rebuttal rebut Ms. Glick's claim that the savings to ratepayers from allowing full return of the remaining plant balances, but denying a return on the investments is $92 million?
I don't believe we did. I think I addressed it on a very high level. I did not monetize that in my testimony, no.
Okay, and no other SPS witness did?
Not that I'm aware of.
Okay. In the company's analysis of the one-unit retirement scenario, it assumed that the undepreciated balances would be recovered in 3 years. Is that correct?
It's the coal assets that would be in 3 years, not the plant itself.
So
I believe, are you talking about, I guess I'm confused with you, which scenario? If you're talking about in our current case, we are depreciating the coal assets And in the analysis, I'm not aware of which depreciation, if it was total plan or not, that Mr. Elsie used.
Yeah, this may turn out to be LC questions, but one of the scenarios that Mr. LC modeled was retiring one of the Harrington units. I think that'd be unit 1, converting the other 2, and it'll be Sierra Club's argument that that's, the company's own analysis showed that was most economic, but you're aware that that's one of the scenarios he modeled, retiring one unit. I guess it would be December 31 to 2024, correct? And just converting 2 of them.
I believe that's one of the scenarios he modeled. That's correct.
Okay. Do you know in that scenario, what happens to the undepreciated plant balances from unit 1 after it's retired?
Are you asking in the models, or are you asking me what the company's position would be?
Are they different?
I don't know what he used in the models.
Okay. What would the company's position be if unit 1 was retired December 31st, 2024? How should the
we would ask for recovery in that case. Now, it would be determined in a rate case how long of a recovery period that would be. Don't know at this point in time what our litigation position would be as far as the time frame.
Okay.
Recovery of what? Unappreciated depreciation only on unit 1, right? It would be carved out. Is that your response?
Yeah.
Yes, the recovery of what?
Of the undepreciated assets of the unit that was retired.
Okay, got it. Thank you.
My information is that the undepreciated balance for unit 1 as of the end of last year is $58.7 million. Do you know, is that correct?
I don't have that in front of me and don't know if that's correct, but that sounds in the ballpark, but I don't have that exact knowledge.
Okay. And you talked about, well, let's see. Is New Mexico about 30% of the total for SPS?
The allocation between Texas and New Mexico.
Well, I believe it's about 30% of the allocation right now, including the wholesale loads. So there would be a FERC Texas and a New Mexico allocation involved in that.
Okay. So New Mexico is about 30% of the total?
At the current time, that's correct, I believe.
Okay.
Approximately.
So if my number, what you think is in the ballpark of 58.7 million, 30% of that, we're going to be somewhere around $18 million.
If that's 30% of the number you provided earlier, I trust you, man.
Okay. So that's what would be at issue if there was one unit retired approximately. And well,
That was a 2021 year end.
I'm sorry, Judge.
I said, I just want to make sure we're clear. That was the figure for the end of 2021 was in the ballpark of 58.7, which 30% is just under 18 million. But that doesn't say what it's going to be at the end of 2024, for example. We would need to know the rate. And that would be the number of years, and then we could probably figure it out. But I want to make sure we're not misleading anybody with the numbers.
Thank you. Now, Mr. Grant, you mentioned that, and this is, I guess, a hypothetical, and the company does not have a definite position on how many years it ought to that balance should be recovered if it was required to retire one of the units. There's a trade-off. Would you agree there's a trade-off? A longer time, less rate shock, but it costs more?
Mr. Marks, when you say trade-off, there's always gives and takes in any decision that you make on that. But there's also, okay, do I have to replace the generation by a certain time? What are the other impacts of that decision? And yeah, all that would be considered in what I would call a base rate proceeding.
Okay. And you're not sure at this time how many years Mr. Elsey modeled it in his analysis?
I am not.
Okay. You agree that extending the period for recovering the undepreciated balances in a retirement would reduce the short-term impact to rates?
Always extending depreciation of an asset would impact the short-term impact of rates, but there's other factors to consider when you do that.
Okay. And you're not sure what you would agree with me that I'm not agree, but you can confirm that Mr. Elsey, when he modeled any of the retirement scenarios, he always modeled full return of the undepreciated balances as well as return on investment for as long as that took, correct?
That would be my assumption, yes.
Okay, but you don't know the time period that he modeled for any of that? Okay, I think we'll hold the remaining questions for him then. But before we leave this completely, you would agree that differing recovery periods are possible depending on the various factors at play, and there's no legal requirement for one particular period.
Objection calls for a legal conclusion.
Could you re-ask the question, please, Mr. Marks, so I can listen more carefully?
Okay. Would you agree that various options are possible for the number of years in which to recover the plant balance of a retired unit? I'm lost here. Could Mr. Lennon, would it be okay if Mr. Lee repeated my question?
I think it would be okay. Mr. Lee, would you please?
Before we leave this completely, you would agree that differing recovery periods are possible depending on the various factors at play, and there's no legal requirement for one particular period.
I continue to object to the legal requirement piece of that
Yeah,
puzzle.
exactly. It was a bifurcated question, and the second part seems to be a legal question, if not a legal conclusion. So I'd overrule the first part and sustain the second part of the question. So it would be whether there's alternatives rather than legal requirements. So if you want to ask him just that part and have an answer to just the first part, I'm okay with that. Mr. Marks, do you want him to answer just the first part without the legal requirement part?
Well, I can. I think he may have already answered it, but
so,
Mr. Grant, to confirm, you agree that differing retirement periods or recovery periods are possible depending on the relevant factors at play.
I believe that is under discretion of the commission, so yes.
Oh, excellent. Thank you for that answer. I have nothing further.
thank you, Mr. Marks, and I appreciate your hard work and diligent advocacy for sure. And I do mean that sincerely. So let's move on. Well, I'll give you guys an option. Let's see, Mr. McMillan, do you have any cross-examination of this witness?
I do not, Your Honor.
Ms. Lynch, do you have any cross-examination of this witness?
No, sir.
Mr. Bagatko, any cross-examination of this witness?
You know what? I did have just a few questions for Mr. Grant.
Okay, how long will it take?
I imagine less than, I would hope, 10 minutes.
So 20 minutes, huh?
Well, less than 10.
Okay, so go
Unless you want
ahead.
me to go.
Less than 10, go ahead, do your cross.
Good afternoon, Mr. Grant. How are you?
I'm great. How are you?
Just fine, thank you. Am I coming through clearly?
What?
All right, I would direct your attention to SPS Exhibit 3, which consists of your direct testimony. And specifically, let me get there. There we go, on page 2. There on lines 6 through 10. One of the things you say you're responsible for is overseeing the activities of the SPS regulatory department to ensure that SPS meets the regulatory requirements of the New Mexico Public Regulation Commission and the Texas Public Utility Commission, as well as FERC. Did I recite that correctly, Mr. Grant?
You did.
When you talk about the PUCT, the Texas Public Utility Commission, do your duties include participating in those PUCT cases as a subject matter expert witness?
That's correct.
Are you aware of a CCN proceeding at the PUCT involving, I gather, the same subject matter that we're talking about in this case?
I am aware of one issue on depreciation. Is that what you're talking about?
Well, let me put it this way. Are you seeking a CCN from the PUCT in Texas to change the fuel at the Harrington generation station, much in the way that you're seeking one from New Mexico?
I'm sorry, I misunderstood your question. Yes, we are.
Okay. Can you give us an update on where that case is procedurally?
Yes, we're still getting discovery questions. If I'm not mistaken, the hearing will actually be at the end of April.
Okay. And do you have a case number for that proceeding there before the PUCT?
Right off the top of my head, I don't, and I'm sorry, I'm not good at case numbers.
Fair enough. I can look it up myself. Thank you for that.
Allow
I
me
would
to ask-
direct you. I'm sorry, go ahead.
You allow me to ask my attorney, he probably has the number.
Well, if that's okay with Mr. Hearing Examiner, I would like to get the number on the record if possible.
I remember seeing it somewhere in the testimony somewhere, so it's in there somewhere, sure. Mr. Santos, do you have the number for the Texas case?
It is the PUC case docket number is 52485.
Thank you, sir. So go ahead, Mr. Bagatko.
Thank you, Mr. Grant. As I said before, I'm going to try to keep this brief. Just a couple more questions. I would direct your attention to SPS Exhibit 4, which is your rebuttal testimony.
Okay.
And specifically, I would start at the bottom of page 12 and work through some things I see there on page 13. I'll give you a moment to flip to it.
Okay.
All right. And for clarity and the benefit of folks who aren't familiar with some of these terms, look at page 12, line 18 there towards the right, and you see the phrase needed capacity.
I do.
And you have testified earlier today about capacity in terms of what SPS proposes in this case today, correct?
That is correct.
All right. When you use the word capacity, as you used it here today in this proceeding, what do you mean exactly?
Sure, and thank you for that. That is planning capacity, which is a requirement that you forecast your load, and you are required to bring resources to meet that load, plus a 12% reserve margin, a minimum of a 12% reserve margin. And what that allows to do is that it's based on a loss of load expectation study. So that's the minimum requirements to meet the industry standard of an outage once in 10 years. So it is a requirement in the Southwest Power Pool that we have 12%, a minimum of 12% planning reserve margins above our forecasted load.
Thank you for that, Mr. Grant. And then similarly, on page 13, up at the top, line 1, I see the phrase voltage support. Would you please, in a fashion similar to what we just did with regard to capacity, explain what you mean in terms of voltage support as I see it in your testimony and as you have discussed it here today at this proceeding?
Sure. We have NERC requirements to have our system to where we plan that if we lose a key element, whether that be a generator or whether that be a transmission line, that we have to maintain certain voltage levels. And if we do have an instance on the system, we have to recover that voltage in a 30-minute time period. So having the ability to maintain voltage within a specific range, plus the ability to recover voltage in a 30-minute time frame under N minus our normal system -1 contingency, is a NERC requirement. And that's what I mean by providing voltage support. Also, a lot of the new renewable systems that we are putting on are inverter based. So this also provides a lot of rotating mass and dynamic stability for transient voltages on our system.
When you talk about rotating mass, is that what was contemplated or inclusive of what you talked about in terms of synchronous condensers earlier?
A synchronous condenser will provide that rotating mass for voltage support, but a generator also provides, it provides the same function as far as how the exciter works, but it also provides that.
Exciter, I'm sorry, exciter works? The exciter works?
Is that what you said?
The exciter
works. Go ahead.
Yeah. So a generator also provides power flow, which is also it helps unload lines, which creates voltage drop. But a synchronous condenser is a rotating mass that helps, but they're not exactly equal.
All right, thank you for that. Let's move down, same page 13 of SPS Exhibit 4, go to line 10, if you would. Are you there?
Yes.
And there on line 10, I see that you use the following words, firm and fully reliable service. Do you see that, Mr. Grant?
I do.
What do you mean there when you say firm and fully reliable service?
What I mean by that is our customers have a certain service that they expect, and that's to have power every time they want to turn on the switch or every time they want to use our power. So one of the things that this testimony is addressing is that we have successfully not only incorporated and well ahead of the Energy Transition Act, we are exceeding that, but we're doing it in an economic, reliable manner. In other words, we're doing it to where we have addressed the voltage issues, we have addressed the line loading issues, we have addressed the upgrades necessary to provide reliable service so that anything can happen on our system, and under normal planning conditions, the customer can be assured their lights stay on.
So if I understand you correctly, is it fair to infer then that SPS has an obligation to provide firm and fully reliable service to its customers?
Yes, and we take that obligation very serious.
And is that obligation in any way diminished or lessened by anything that you see in the ETA, the Energy Transition Act?
As you get more saturated in renewable energies and more inverter-based generation, that will be a challenge, specifically the last portions of the ETA when we start getting above 80% saturation and carbon-free. And the reason I'm stating that is because I believe there needs to be newer technology developed in the future of, and I think Mr. Marks referred to it earlier, we are turning rotating mass with a different fuel, or we get carbon capture. That technology is out there, but it's not a viable technology at this point. But yes, the ETA will be a challenge, but I do believe that there's people are working on solutions, but with the technology we have today, yes.
Mr. Grant, do you understand that a CCN that you may obtain pursuant to the auspices of Section 62-9-1 includes and entails such an obligation to serve SPS's customers? Is that a fair statement?
It is.
Now let's go back up to lines 4 and 5 of page 13 there in your rebuttal. Are you there, Mr. Grant?
I am.
Now this rebuttal was filed on February 1st, 2022, correct?
That sounds correct, yes.
And you see there in lines 4 and 5 of your rebuttal, you say, no other option is more cost effective than the conversion of Harrington. Did I recite that correctly?
Yes, you did.
And when you say conversion of Harrington, you are, of course, referring to the switch from coal as a fuel source to natural gas as a fuel source, correct?
That's correct.
Does your conclusion regarding cost effectiveness there, as we see it on lines 4 and 5, remain the same, or do you have any updates to provide in the approximately 2 weeks since you filed this rebuttal testimony?
Objection. This sounds like friendly cross.
Very much so. And I was kind of waiting for an objection because I don't like to actively sua sponte roll on those. So Mr. Bogatko, thank you for all your excellent questions, which might have clarified, but they certainly do sound like friendly cross-examination. So sustained.
All right, fair enough. Thank you, Mr. Hearing Examiner. Thank you, Mr. Marks. Well, then I'll conclude with this. And it may fall within the ambit of friendly cross again. If it does, I'm sure you'll chime in.
I won't. I'll wait for an objection. But okay.
Mr. Grant, is the analysis that SPS conducted in connection with the fuel change for the Harrington generation station purely focused on economic outcomes, or were there other considerations?
Same objection.
All right, fair enough. I think I can get that from the rest. I won't belabor the point anymore, and I thank everybody for their time.
Question was withdrawn. Okay, thank you. Did everyone have an opportunity to cross? I think so. So if there's going to be some redirect, let's talk about how long that'll take, because it's, excuse me, somebody wants to sell me health insurance or something. Pardon me, that you need not put that in the record, Mr. Lee. My phone just rang. What was I going to say? If we can find out how long you think your redirect would take, and of course there, in theory, could be within the scope of the redirect recross, whether we should take a lunch break now. It's about 12:30. How long do you think it's going to take, Mr. Santos?
Examiner Lennon, I mean, my preference would be to go ahead and take the break, given how long we've been going. My guess is 15, 20 minutes. And if there's recross, we are starting to stretch out that period a little bit. And we've been going for a good bit.
I agree. There's something to be said for continuity in examination of a witness, but in this case, it just feels like we should be taking a break now. So we will. Let's talk about how long of a break we're going to take. I don't know if you guys have food with you, if you have to run out somewhere. Who likes a half hour? Who likes an hour, or anything in between? What do you think, Mr. Santos? What do you like?
I generally like an hour, but I'm not in charge of most of the questioning today. So,
Mr. Marks, is an hour okay with you?
Either 45 minutes or an hour.
I don't think that was one of the options, Mr. Marks.
You said in between. That's exactly in between 1/2 hour and 1 hour.
You're right. It is exactly in between. I stand corrected. Mr. Bagatko, Mr. Marks has chosen 45 minutes. What do you like?
Mr. Hearing Examiner, I'd prefer a full hour, please, to get us some lunch and then to chase down some chickens and cats that need herding.
You know, I've heard that in some other case once. You know, if you're out there on the ranch lands, errant livestock is a real reality. Miss Lynch, are you okay with an hour?
Yes, I'm fine with any option.
I'm collaborative, if nothing. Mr. McMillan, hour good?
That's good to me.
And Mr. Smith, good?
I'll abstain.
You abstain. No commitment from Mr. Smith of the Sierra Club. I think he just deferred to Mr. Marks, but he did that very obtusely. It's 12:35 on my machine, so let's reconvene at 1:35. Thank you all. We're on lunch recess. Hi, Mr. Lee, hanging in there?
Yes, sir.
Thank you, Mr. Lee. You moved, Miss Lynch.
Maybe that's the camera.
No, it's, when people log out and then log back in, they move on my screen here.
Oh, okay.
You picked a
Well-
good box. That's a good one.
Yes.
All right. Mr. McMillan, please blink every once in a while so they know you're still there and alive. Good to see you moving. You don't do a lot of movement on your screen. All right, there's Mr. Bogatko. There's the famous Mr. Jason Marks. And Josh Smith, where is he? Oh my.
He abstained.
Did he really say he wasn't coming back? I don't think so. I mean, he's got Mr. Marks covering business, so they're like double teamers.
Yeah.
That's an old trick. That's a really old trick. Miss Lynch, are you listening to music in them headphones, or is that really so you can hear us?
It's
Both?
actually so I can hear the proceeding. But and no, I can't simultaneously turn my ZZ Top on.
Okay. Well, I was half being facetious, but I think I have a ZZ Top record over here on my shelf somewhere. Oh God, I just disclosed that I still call them records. Anyhow, I'm stalling so we can get Josh Smith to light up his screen there.
Mr. Hearing Examiner,
Yes, sir. Who's that?
Is it-
John.
is it Tres Hombres? Is that what you got in there?
Take a look. I think it's a best hits album. Okay, we're all present, so I'm going to, unless somebody has a better idea, I'm going to ask Mr. Lee if we go back on the record. Are we ready to go back? Okay, thank you. Mr. Lee, back on the record, please. So this is Robert Lennon again. There has been a break because we took a 1-hour lunch break. It is now approximately 1:38 in the afternoon. Same date, February 15, 2022. This is a continuation of case number 21-00200. That's 21200 UT of the PRC case numbers. We're just getting ready for the redirect testimony from the SPS witness. So are we ready to proceed, Mr. Santos?
We are, Your Honor.
Okay, sir, you're still under oath, even though we took a lunch break. Can't get off that easily. So please continue to answer those questions the correct way. Go ahead, Mr. Santos, he's your witness.
So, Mr. Grant, I want to go back and touch on a few of the subjects that Mr. Marks addressed with you. And I want to start with the discussion that was being had about dispatch and a capacity factor. Do you remember that discussion?
I do.
Okay. And with respect to dispatch, generally speaking, when can you dispatch solar resources?
Solar resources are primarily when the sun's shining during daytime hours.
And the same question with respect to wind resources.
Again, when the wind is blowing, but wind has a tendency to operate more in the overnight and stuff, but so we get wind during the daytime too at times, but whenever the wind's blowing, it's intermittent.
Okay, and so assuming if the commission approves the Harrington conversion, when will you be able to dispatch Harrington?
Objection. What part of my cross does this relate to?
It's going to go to the capacity factor. These are foundational questions, Examiner Lennon.
Yeah, I'll overrule the objection, but thank you, Mr. Marks.
Well,
That's been rolled upon, so if you have a no objection, I'll be glad to hear it. None? Okay, next, please continue. I understood he was defining terms so he could get somewhere, but go ahead, sir, Mr. Santos.
So I'll ask that last question again, Mr. Grant. So assuming the Harrington conversion is approved, when will Harrington be able to operate?
Whenever it's dispatched. So anytime it's dispatched, any time of the day, it can run.
Okay, and in some of the economic modeling, we were seeing and talking about that capacity factor, right? And how it might be, I think I heard 1% or even or lower than 3% at one time. Can you explain why the modeling might speak to a low capacity factor and why that capacity factor might actually be different than the way the plant actually ends up operating in real life?
Sure. As I said, an economic model is exactly that. It's going to be a purest solution to the heat rate curves, even if there's just a very slight difference. When in the operating world, very seldom do we ever have a system that's intact. We always have an element out of service. We always have something else. And we always have voltage issues that are not captured by an economic model. We always have, depending on other people's generation, different flows on the system. So we get dispatched for reliability reasons. For example, we had a winter storm in 2020, which was in my testimony. Harrington was dispatched for that storm. Winter Storm Uri, Harrington was dispatched for that storm. So whenever you have a system need, you're able to bring that resource on and operate, or that's not always the case with renewables.
And I think I heard you say this in response to one of Mr. Mark's questions, but is it the company's expectation that the actual capacity factors after conversion for Harrington will be higher than what was modeled in the stress tests that Mr. Elsey did in the models?
Objection. The use of the word stress test. That's not in Mr. Grant's. Mr. Grant didn't testify, call it that.
Sustain, I didn't hear that word either, Mr. Santos. Is there a more accurate word that you could use?
I'll rephrase.
Thank you.
So is it the company's expectations that the actual capacity factors for Harrington will be greater than the capacity factors reflected in its model?
Yes, absolutely. And based on my operating experience, the real world separates from the economic world very quickly. And although the economic models might be a guide, the real world situations, the capacity factors will be higher.
And I believe Mr. Marks asked some questions and with respect to Sierra Club Exhibit 10 that had capacity factors in, I believe, the 2015.
I'm sorry, because at 10?
Let me try that again, Mr. Lee. I believe Mr. Marks asked some questions about Sierra Club Exhibit 10 and certain capacity factors on the last page of that exhibit between 2015 and 2020.
You believe correctly. What's the question?
With respect to those capacity factors on the exhibit, is there anything else impacting those? Is there anything impacting those factors from your perspective that's not reflected on the exhibit?
Yes, absolutely. like I testified, we made a lot of changes to and gave more flexibility. However, I think the biggest impact for those last 2 years was the low gas prices and even negative gas prices at times. So, we were because of the oil fracking in southeastern New Mexico, we were getting sub $1, sub $2 gas, and in those cases, the gas units that we had were more economical to run than the Harrington units were.
And so I'm just trying to make sure there's no confusion, because I heard some discussion about the timing of self-committing and not self-committing units. Is the driving factor for those 2019 changes that self-commitment versus non-self-commitment, or is it the gas prices?
I believe the drop in 2019 and 2020 were more related to the low gas prices than they were changes in operation.
We also had some testimony about the location of generation resources and how that impacts the system. How is Harrington's geographic location relevant to how SPP and SPS might need to dispatch the resource at times?
Sure. Geographically, Harrington is right by our largest load center as far as urban load. And it's also located where some of our tie lines are coming into our system. So it's a very strategically located plant for reliability reasons, for voltage, and also control on overload flows on our transmission system.
Does Harrington's location help bring any other renewable resources to New Mexico customers, assuming those renewable resources are functioning?
Absolutely. We have.
Objection, what part of the cross is this about?
We spent a good bit of time on voltage support here, and that's what this absolutely goes to is, and Mr. Grant spoke to Harrington's location. So this is voltage support and that piece of the puzzle.
Okay, both Mr. Santos and Mr. Marks, I'd prefer if you didn't have a conversation when an objection is made. Thank you. Continue.
So I think my original question was, does Harrington help bring any renewable resources to the New Mexico piece of the puzzle?
Yes, and my reason for saying that is we have quite a bit of our resources on the north part of our system, and the rotating mass and the support that Harrington would give would support the operation. Because if you don't have that support where the wind is, when wind does come down, not only are you not replacing it with generation in that area, you're changing the flows on the transmission system. They have to be accounted for.
Can you give an example of when SPP might commit a unit for reliability purposes?
Sure. I'm going to answer that question a couple different ways, but for example, Winter Storm Uri, when they saw that front coming in and they declared an emergency operation, they ordered all generation online, including Harrington. We also had a winter storm in 2020 where we had a lot of ice on our import capabilities, and we were solely dependent on what we could do within the SPS area. The other time that SPP would do that is in the operations world. We always take the topology of the system and do a day-ahead assessment plus a real-time assessment, where we're always, every 5 minutes, we're calculating the impact of a line tripping or a generator tripping. And if they see something that needs to be addressed, they would dispatch a unit in those conditions for reliability.
With respect to Winter Storm Uri, did any systems across the country experience what happens when you don't have enough power for reliability purposes?
Sure. The ERCOT grid, for example, experienced, not only did they experience rotating blackouts, but they were so deficient that they weren't rotating anymore. They had customers that were out for days at a time instead of 30-minute blocks that rotating outages are supposed to be.
Now, you also got some kind of depreciation related questions. Do you know what depreciation expense is?
Yes.
But what is it?
Depreciation is you recover an asset over a period of time. So as much as you recover each year, what's left is the undepreciated part. So each year you're depreciated. It's kind of like a car loan. I pay for I might take a 10-year loan, but I pay for a share of it in the first year, a share of it in the second year. So what's depreciated is what I paid for during that time.
Okay. And when are depreciation decisions typically made for a utility?
When we ask to build or install an asset.
Okay. And does the commission is the commission considering any depreciation related issues in this case?
No.
Do you know whether or not there are any specific accounting rules that may be relevant to that depreciation decision when it is time for the commission to consider it?
Sustained. I thought that was beyond his field of expertise. I really do, about specific accounting rules. Yeah,
I
sustained.
asked him if he knew. So either he knows or he doesn't.
Well, I'll let you ask him again. Mr. Marks, you have an objection?
Yeah, he testified in his direct that he didn't know of anything that prevented. I wish I had Mr. Lee's transcript in front of me, but he already testified that he didn't know anything that would prevent differing depreciation periods.
Okay.
And the only point I think that is relevant here, Examiner Lennon, is that there are other rules there that we're not talking about here. And I think he's qualified to say that.
Excuse me just a second. Let me think for a minute. Well, I'd like you to be perhaps a little more specific in your questions. You asked him about depreciation, for example, and his response was a definition of depreciation, which is frankly only used in the power industry rather than a general accountant's definition of depreciation. And then you ask him basically an accounting question. And frankly, I was not seeing a real reliable answer coming my way. So that's one of the reasons I sustained the objection, because I didn't think he has the expertise in accounting, other than perhaps his specific expertise within the energy field. I already sustained the objection, so if you want to ask another question or some close question, and we'll give Mr. Marks an opportunity to object if he wants to and argue, and then we'll roll upon it. So go ahead, if you want to ask another question, please do.
Let me ask it this way. Mr. Grant, is this a rate case?
It is not.
Is this an abandonment case?
No, it's not.
Is this a case involving the IRP process for SPS?
No, it is not.
We heard Mr. Marks also ask some questions about whether the retire one scenario was the most economic scenario under the company's, both the company's and Ms. Glick's analysis. Do you remember those questions?
I do.
Can you speak, well, one, why is it that the most economic decision might not be the best decision in any case when it comes to the Harrington units?
Well, as I testified to, there's more things to consider than just a pure economic model. It's location of the unit, the contribution that unit makes to the system, the a lot of times when you retire generation, you have to do a transmission study? Do you have to replace transmission? But yeah, there's a lot. It's contribution to the whole topology of the system that an economic model will not capture.
And along those lines, do you know what the incremental cost of keeping all 3 units is versus retiring one and only keeping 2?
Yes, it's my understanding that the majority of the cost in this filing is the pipeline cost. And we have to have a big enough pipeline for 2 units if we retire one, which is the same size of pipeline that would facilitate 3 units. So the incremental cost is just the burner work on 1 unit. And I think that's been estimated to be around.
I'm sorry, the incremental cost is?
The burner, the burner work at the boiler. And my understanding is that incremental cost is about $2 million.
So it's only $2 million more to keep 3 as opposed to keeping 2.
Yes, because the pipeline has to be built, and that's where most of the costs are incurred.
And by keeping that 3rd unit, we get another 340 megawatts of capacity if we need it.
That's correct, and you get the flexibility of a lot of other options you have, as I testified to earlier as well.
Now, does keeping all 3 units online preclude at all the adding of renewables to the system at Harrington or otherwise at a later date?
It does not. Matter of fact, I think it actually enhances the ability, because when you do a study and you replace something, you replace it in the models that SPP would consider. They have the low profile, but if you enhance it to where you can add renewables at the same location, then you have that stability to where it's modeled like the generation is there at all times. So it actually enhances the ability to add renewables at that location.
That's all my redirect. Examiner Lennon, I'll pass the witness.
Thank you, sir. Strictly within the scope, thank you, Mr. Marks, of the redirect, could you, do you have any cross-examination, recross?
I do. And could Mr. Santos and Mr. Grant look at what we labeled as confidential Exhibit 9 and look at, it's page 25 of the PDF.
I'd like a minute too to get that up on my screen, if you don't mind.
Yeah, it says page 21 of 24 in the report I can see, but it's actually, yeah.
It wouldn't
It
happen.
may take us, no, I don't have it right in front of me. It may take us a second to get our hands on the confidential portion of that of Exhibit 9. We haven't addressed Exhibit 9 yet.
No.
Mr. Marks, you wouldn't happen to know the date that was sent to me in the email, would you?
I think all the exhibits would have been Friday, except for Exhibit 25. So
Okay,
Friday.
thanks.
Are you sure that it's 25 of 25?
No, it says page 21 of 24 on your header.
We do have that.
Okay. And there's a heading that says recommendations, and there is a sentence that starts 3 lines down.
I'm there.
Okay, Mr. Santos, would there be a confidentiality objection if I asked Mr. Grant to read that sentence?
Let me read the sentence. Can I have a second off the record to confer with our folks on how?
Absolutely, absolutely. And turn off your sound, of course. Forget that. Yeah, take a second or more.
Thank you.
And Mr. Lennon, were you able to find that exhibit? Because I could email it to you. No.
No, actually, I'm not able to find it. I do remember the confidential exhibits coming in. It's probably my mistake. I probably moved it to another file. Or let me see if I left it on my desktop. But if you,
Mr. Lennon,
Yeah.
on behalf of Sierra Club Josh Smith, the email would have come directly from me. So if you have the ability to search for a sender.
Yeah, I find Sierra Club number 9, 1 megabyte, and you sent it from Josh rather than from Lauren, and it was sent. Yeah, I actually saw that just a moment ago, but I wasn't sure that was it because I was looking for one from Lauren. So yeah, I think I have that in front of me. Thank you so much, Josh. Appreciate that. And we're off the record right now.
Yeah. I just emailed you one just only to you, but it's just that exhibit. If you can't find it.
Okay, you guys are good.
Oh.
What a world we live in, you know? It's crazy. I have to push the check for new mail button or else it only updates every 5 minutes or so, Mr. Marks.
Oh, it's still going out.
Oh, you scare me when you say that.
Okay. Should be, okay, it's gone from me now.
Okay. Yeah. You know, I really crave the days when you could hand somebody a piece of paper.
Yeah. You know, I'm not.
It's 28 pages long, right? Exhibit 9, Sierra Club Exhibit 9.
I believe that's correct, Your Honor.
Okay, just to make sure I wasn't looking at the wrong one.
Examiner Lennon,
Yes, sir.
we are, as long as Mr. Marks kind of restricts his questions to the generation location information in that paragraph, we're okay with him asking questions on it and removing the confidentiality on that portion of the record.
Okay, Mr. Marks, can you comply with that request?
I think so. So if we could go back on the record, I directed him to that specific sentence, and I would get him to, when we go back on the record, just identify this.
We are on the record.
This document. Okay.
Sometimes when somebody says, if we can go back on the record, we're back on the record. So, you know, anything you might say after that is part of the record. So I understand that you can agree with the restriction in your question. So to allow Mr. Santos to agree that the sentence is no longer confidential, contingent upon you excluding that limited language. So with that caveat, or I think I said that correctly, let's proceed. Mr. Marks, go ahead.
Okay. Okay, Mr. Grant, Exhibit 9 that you've been looking at, that's a study done by Sps'S transmission group in, I think, June of 2019, correct?
That is correct.
And it was an analysis of the transmission impacts of different Harrington alternatives, correct?
That is correct. Yes.
Okay. And can you read the sentence that I've directed you to, which is the third line under the recommendations?
In addition, the megawatt capacity from Harrington Generation Station should be replaced and relocated to the southwest part of the SPS transmission system to serve the growing load pocket in the area.
Okay. And were you aware of this study?
Yes, I am.
Okay, but you still testified that, or maybe I misunderstood your testimony on redirect, that Harrington was ideally located to provide transmission benefits, and this appears to be saying transmission people think it should be the resource should be somewhere else. Can you explain that?
Yes, sir, I can. Number one, my testimony was that Harrington is critically located to the north part of my system. What they were recognizing here in this study is that we have a huge load growth in the south western part of our system. That would be Lee and Eddy County in New Mexico. And with all things, this is a transmission planning. So if I'm a transmission planner, I love to have generation down close to where the load is growing. That's just good, prudent planning. However, real life comes into example there too, because we did propose at one time, and not to the state, because when we went to talk about an environmental permit, we were going to put a generator down by Loving, New Mexico, but we were told because of the location, a close location to Carlsbad Caverns National Park, that we could not put any generation or that type of generation in southeastern New Mexico. So even though a transmission planner recognized that, yeah, it'd be nice to have generation in southeastern New Mexico, it would be very difficult to get a permit down there.
Okay. But your transmission group did not recommend that in the case that more generation be added and Harrington was no longer there, that the generation be added at the Harrington location, did they?
Well, I think you're taking one part of the study and not talking about the other issues they identified early in the study, but this recommendation was based on the fact that if you're going to retire Harrington, it would be nice to replace it with a synchronous condenser number one, which is the sentence before that, and then locate generation in southwestern New Mexico. So no, it was not their recommendation to shut Harrington down if you read the whole report, but this study was based on the fact that what would you recommend if you shut Harrington down, and that was a recommendation.
Well, I thought I was limited to that one sentence, but you did talk about the rest of the report, and that's just not what the report I think that mischaracterizes the report. And I'm not sure how to handle that.
Well, we have,
because I don't want to get
no objection. We have no objection to this report being entered into the record as long as it's treated confidentially, and Examiner Lennon can judge for his own as to whether or not this discussion's been a true discussion.
Well, you're moving to admit it, Mr. Marks, to prove that it wasn't?
Yes, I will.
Okay,
yes,
so
I will.
no objection from SPS. I'm going to presume that the other parties haven't. Well, I won't presume anything. Is there any objections from any other parties? It would be in confidentially. Okay, so it's going to be in confidentially. It's there. This isn't. Is there a retracted version of this thing anywhere? Well,
not to my knowledge, Mr. Lennon.
So
probably not.
In order to maintain the confidentiality, I'm not going to be able to allow this to be part of the record, which the public would have access to. I don't think I can then, without a retracted version, preserving the confidential parts, I don't think I can accept the entire document as I can't maintain its confidentiality. I mean, I've had things done under seal, which is the way they do it in the district court, where just the first page is admitted and it's marked remainder under seal, something like that. But otherwise, what comes in here is public record, and then it would no longer be confidential in my opinion. So that's a problem.
Mr. Lennon,
Yes, sir.
could we,
Confer?
well, or could we leave this as an open issue and allow the company to assess what would be involved and revisit this either later today or tomorrow?
Yeah, absolutely. As you know, I'm not supposed to rule on cases except from the evidence. So I'm not going to read the rest of this thing to determine if his testimony is consistent with what the rest of it says, unless it's admitted. I might, glance on things as they come in, like your emails come in. I just want to see what they are, to see what I do with these emails. But I can tell you, I have not read this 28-page exhibit, so I don't know yet, and I'm not going to read it until it becomes evidence. So yeah, we can deal with it later or tomorrow, or we could reach some agreement between counsel, or we could redact parts. All you need is a big black pen. At least that's all you used to need. And we can maybe admit it that way. I understand your purpose, Ms. Marks, is to impeach the veracity, well, if not of the witness, the reliability of his testimony essentially was the purpose you wanted to admit it. And that's a relatively limited purpose, so.
I think I had broader purposes than that, but I think to keep our hearing moving along, this is something that they could look at offline, and I'm pretty comfortable that if we don't get to a resolution today, that we can get this solved by Thursday, by tomorrow.
I understand you guys are going to confer, and I appreciate that. So maybe this will be another topic for your conference.
Okay. So just a couple more lines of recross. You talked about how Harrington was dispatched during Winter Storm Uri. Is my understanding correct that there were issues with gas supplies to the gas-fired power plants during Winter Storm Uri, which made coal plants like Harrington particularly valuable?
During Winter Storm Uri, coal did produce about 50% of the power during that winter storm.
Okay. So, and there were issues with gas supplies, correct?
Yes, there were.
Okay. So, at least in that particular scenario, well, I think the point is clear. I don't need to ask the question. Do you know, you said that the modeling Mr. Elsey did was purely economic, and only, if a resource was 1 penny more expensive, it doesn't come on, and it did not, and that modeling doesn't take into consideration potential outages and affecting the system, correct?
That is my understanding, yes.
So that's your understanding. Do you know that inputs to the Encompass modeling include forced outage rates for each resource that's in the model?
For generation, yes.
Okay. So doesn't the modeling take into consideration that various resources will be unavailable from time to time at unpredictable times?
It has the equivalent forced outage rating in the model. What I was testifying to is that it did not have a lot of the transmission topology changes in the model.
Okay, so you agree then that the model does simulate the fact that other generation may go offline, creating a need for a less economic unit.
My understanding is that you can input equivalent forced outages in them, and I do not know what parameters were used, but yes, the model can do that.
And it would have that impact. It would simulate that lower cost resources are not available at a particular time, so a higher cost resource could get selected.
Completely ignoring the transmission topology, yes.
Okay. And so when SPS's own modeling found a 0% capacity factor for unit 1, it wasn't because it didn't consider the unavailability, that it wasn't because it assumed that other generation would always be available.
Objection calls for speculation. You didn't run the model.
I'll allow the question. It's cross-examination, and sometimes you can put facts in cross-examination to achieve some sort of objective. So you can answer the question, sir, if you remember it, please.
Mr. Marks, would you please ask that question again?
I'll ask a foundation question. Do you know if the results of Mr. Elsie's modeling, the capacity factors, take into consideration that there were times when generation wouldn't be available and still Harrington Unit 1 was never dispatched?
It is my understanding that the model has the capability of using the equivalent forced outages. What was actually used, I don't know.
Okay. So I think so. You don't know.
I do not know what was actually in the modeling runs. That would be a question better.
Okay. I think that's it.
Thank you, Mr. Marks. Okay, anyone, other parties, if you'd like, if you have some recross within the scope of the redirect, let's start with Mr. Bagatko. Do you have any recross rather?
No recross necessary, Mr. Hearing Examiner, but thank you for asking.
Thank you. How about Mr. McMillan?
No cross, Your Honor.
Ms. Lynch? Okay, I don't see her unless she can hear us. Well, she didn't come up to bat, so she doesn't get to bat. Mr. Smith, I take it that Mr. Marks covered your bases close, good enough, right?
Yes, thank you.
Parties only kind of get one shot at it anyhow, but I thought I'd just ask you since you were there. Okay, well, I did have a question, because I'm allowed to not really cross-examine, or I'm just allowed to question when there's something that I can't figure out. And I'm looking at this Sierra Club exhibit number 10, which was admitted. And then on the final page, there was testimony about this chart that has Harrington Unit 1, 2, and 3. And then there was specific testimony about the obvious change in trend from 2018 to 2019 and continuing into 2020 for the capacity factor net. And, it's pretty obvious that the numbers were declining and slightly or somewhat stable until you reach 2019, and the numbers are about 2/3 of the previous numbers. And the explanation was that fuel prices for gas had dramatically decreased. Is my understanding correct about that, Mr. Grant?
Yes, I think I testified that we were also making improvements on the dispatch. That was a small part of it. But I believe that fuel prices was a bigger part of that decreased capacity factor.
Well, I was setting up a question, and the question is, I'm looking at Harrington Unit number 3, and I'm looking at the difference between 2018 and 2019, and it doesn't show a similar reduction of approximately 30% or 33% or any percent whatsoever. In fact, it seems to go up a little bit. And it seems to me that third unit would have the same fuel. So why didn't the Unit 3 suddenly have a lower capacity factor net as a result of reduced fuel cost?
Well, this goes back to some of my testimony about the reliability and the location of the generator. So at times, it's the most economic solution to a constrained economic dispatch issue. So the market was calling on a unit to run there, but only one unit maybe at the time. So therefore, that one unit wasn't cycling, so it ran and had a higher capacity factor where the other ones were able to cycle off. We cycle our coal units off and on, but evidently number 3 stayed on longer those years.
It stayed on longer. Is that your testimony?
It had a higher capacity factor, so yes.
Yeah.
That's what.
Well, okay, I got you. I'll ask a dumb question because I really don't know the answer, but I want to know the answer, so I'm not worried. I mean, how do you choose to run either 1, 1 and 2, 1 and 3, 2 and 3, or just 3?
Well, we are in a fully integrated day-ahead market through the Southwest Power Pool.
I understand that.
So we no longer dispatch our units. We don't make the economic decisions. We offer them in with all the parameters, the startup time, the minimum downtime, the minimum uptime, the ramp rates. Everything that's a parameter to the unit is in the market model, and SPP will determine whether they need 1, 2, or 3. At times we've had no units running there. At times we've had all 3 units running there. It depends on the best, most economic market solution, considering the constraints on the system.
So why would the pool decide to run only unit 3 rather than to run unit 3, 2, and 1, or just 2, or just 1?
Because it does a day-ahead dispatch. If Harrington 3 was already on,
I see.
Instead of dispatching a different unit, it would keep that unit on.
Okay, I get it. That makes sense to me. All right, well, sorry to ask you what was probably to you a simple question, but it was rolling around in the back of my head and I wanted to put it to sleep. Okay, anyhow, that's my only question for you, Mr. Grant. So if anybody has a question within the scope of what I just asked, now would be the time to ask it. Let's ask Mr. Santos first. Do you have any illumination you want to provide?
No follow-up, Your Honor.
Mr. Marks, any follow-up?
Solely for your benefit, Mr. Lennon.
Yeah.
Mr. Grant, isn't it the case that according to the data in Exhibit 10, Unit 3 has the best heat rate?
Well, if I'm not mistaken, those heat rates are affected by how many times it's cycled and no load gas. So I would have to verify that the heat rate on this graph was the actual tested heat rate that we use in the market dispatch, which may be different. If this was taken off the FERC Form 1, it actually includes no load gas as well. So I would have to verify that.
Okay, not worth belaboring. Thank you.
Thank you, Mr. Marks. Anything from any other parties? Nothing. Oh, excuse me, who's that?
Oh, I'm sorry, that was Mr. McMillan. No, Your Honor.
Okay, thank you, Mr. McMillan. Mr. Bagatko, anything?
Nothing further for Mr. Grant, but thank you, Mr. Hearing Examiner, and thank you for your testimony today, Mr. Grant.
Yeah, and thank you, Mr. McGotko. You know, I would like to thank you also, Mr. Grant. I learned and I thought you were an effective witness, and even provided information on cross-examination through Mr. Marks. So I really appreciate that. Are you ready to call your next witness, Mr. Santos?
We are, Your Honor.
But can we excuse Mr. Grant? We're not going to recall him, are we?
SPS doesn't have a plan to recall Mr. Grant. So as long as the rest of the parties are okay with him being excused, we're okay with him being excused.
Good question. Anybody have a problem with it? Let's let him go. Okay, Mr. Grant, thank you for being here. Have a great day. Next witness.
Yes, Your Honor. SPS is going to call Mark Rifle next, and he's on his way to my location right now.
Okay.
Correct.
Hi, Mr. Lytle. Mr. Lee, would you please swear in Mr. Lytle?
Mr. Lytle, would you raise your right hand, please?
Mr. Lytle, I'm Mr. Lennon. Mr. Lytle, please.
You solemnly swear the testimony you're about to give in the matter not pending should be the truth, the whole truth, nothing but the truth?
Yes, sir.
Your witness. Counsel, please identify him.
Mr. Lytle, will you just state your name for the record?
Mark Little?
Mr. Lytle, you should have in front of you what has previously been marked as SPS Exhibit 9, your direct testimony that was filed in this case, and also SPS Exhibit 10, your rebuttal testimony that was filed in this case. Do you recognize those documents?
Yes, sir.
Any corrections or changes to make to either SPS Exhibit 9 or SPS Exhibit 10?
No, sir.
If I were to ask you the questions that are contained in SPS Exhibits 9 and 10, would your answers be the same to them?
Yes, sir.
SPS offers SPS Exhibits 9 and 10.
Hold on just a second. Is there any objection to these direct or rebuttal testimony? No. Mr. Santos, did you ever send me that email with your proposed exhibit list?
I will double check on that. You should have gotten it, but I need to talk with the person who was responsible for sending it to you.
Yeah. Well, I don't see it, but that's okay. It's not really high priority. I was just wondering how we skip, looks like we skipped SPS 4, 5, 6, 7, and 8 or so.
We do. We'll pick those up. If it's okay with your honor, you'll be seeing those here with a couple of the other witnesses as they appear.
Okay, so the direct testimony is labeled as SPS number 9. Did you have it already pre-labeled?
Yes, your honor.
Okay, and the rebuttal is 10. Let's see if there's any objection. Any objection to admission of these documents? Okay, hearing no objection. Direct testimony, Mark Lytle. SPS number 9 is admitted as evidence. Rebuttal testimony, also Mr. Lytle, dated February 1, 2022, labeled SPS Exhibit number 10, is also admitted into the record. Is he ready for cross-examination, sir?
We're ready to tender him, whether he's ready or not, your honor.
Yes, sir.
He's got his water. Mr. Marks is smiling. I think that's good. Mr. Marks, he's your witness for now.
I'm smiling because it's Mr. Smith gets to do this one.
Oh,
Okay.
no kidding. Oh, good. We get to see all of you, Mr. Smith. I didn't know when to interrupt you to tell you to move your camera down, but there's all of you. He's all yours, Mr. Smith. Have fun.
All right, thank you, Hearing Examiner Lennon. Josh Smith on behalf of Sierra Club. Thank you very much. Thank you, Mr. Lytle, for coming along this afternoon. Am I pronouncing that right, Lytle?
Yes, sir.
Okay, great. You have your direct testimony in front of you, I believe. If you could flip for me to page 11. And in the first question and answer here, you discussed the start date, timeline, and completion date for the Harrington conversion projects. And you see at lines 6, 7, and 8, you state unit conversions will occur sequentially, with the final unit conversion completing in spring 2025.
I'm sorry, will occur sequentially, and please continue.
With the final unit conversion completing in spring 2025.
Thank you.
So that date, that spring 2025, is after the date on which SPS has agreed to cease burning coal at all 3 units. Is that right?
Yes, sir.
And even though presumably one or more units will be out during this period of time between the end of 2024 and spring 2025. Is that right?
Yes, our plans are to shut Unit 3 down January 1, midnight, January 1, midnight, December 31st. We're not going to violate our agreed order.
Right.
Start that outage. It has a regular scheduled outage that was going to be planned for that year. We're going to do that work in association with the conversion. So it's going to go from January into, I forget the exact dates, but it's going to go into, we call that the spring overhaul season.
Okay. And you state on lines 8 and 9 that it's not going to have any issues with SPS meeting its requirements. I want to confirm that this means that it's not going to have any reliability impacts to shut one of those units off for that period of time. Is that right?
Yes, sir. We have an overhaul scheduling department that works with SPP. We have to get outages approved in advance. They work with SPP. We have certain requirements. We can only have outages out so many megawatts out to meet their planning guidelines. So they will work with SPP to make sure we don't violate any of those particular guidelines that we have to meet.
I want to just make sure I got the answer right there. So that includes reliability requirements. You're not going to violate any system reliability requirements by having that unit off. Is that right?
That's correct.
And you're not going to violate any reserve margin requirements during that period of time. Is that right?
That will be up to them. They'll have to determine, that's part of their requirements. They have to do that evaluation.
Okay,
Well,
so you're not using requirements in that term, then you don't know. When you say
no, I don't think. Yeah, we put the request in and they make that approval, and I'm not sure what happens behind the scenes on that.
Okay. I'd like to move.
Who's they? SPP, correct?
Yes, sir. Pardon me for not being clear on that.
Well, I'm sorry, I needed a little clarification. Sorry, Mr. Smith, for interrupting you. Please continue.
Thank you, Hearing Examiner Lennon. I'm going to move to your rebuttal testimony if you want to get that in front of you. And if you could turn to page 5 of your rebuttal, please. You there?
Yes, sir.
Great. So and you reviewed Ms. Glick's testimony in this matter, is that correct?
Yes.
And one of her critiques of SPS's analysis here, in this case, was what she describes as implausibly low capital costs assumptions. Is that right?
Yes, sir.
In your rebuttal here at page 5, lines 7 and 8, you state that the Harrington estimate of $3.75 million annually after the conversion is based on actual experience operating natural gas generation assets similar in nature to a converted Harrington plant. Is that right?
Yes, sir.
And you also describe putting together a 5-year capital budget plan starting on line 15. Is that right?
Yes.
Are you aware that during discovery in this case, SPS was asked for the basis for that $3.75 million assessment?
Yes,
And do you recall that SPS was asked to provide all documentation supporting that $3.75 million assessment? Do you recall that?
yes,
SPS didn't provide any supporting documentation, did they?
because no, we did not.
Okay, thank you. I want to skip back just a minute here and talk about what you've called your experience operating natural gas generating assets similar in nature to a converted Harrington unit. Are you referring to the Jones Unit 2 gas plant when you say similar in nature? Is that what you're referring to?
I'm referring to all of our gas facilities. We have 11 gas-fired boilers. All of them are similar in design. They were all designed with internal engineers, SPS engineers. All of them have similar boiler design, similar boiler feed pump manufacturers. So those designs were carried from our earliest model units through Harrington and even on into Toll, the last of our fossil units.
Okay. Thanks for that. Is it possible, Mr. Santos, to bring up what we pre-marked as Sierra Club Exhibit 19?
When you say bring up, I have a hard copy that Mr. Otto can look at. I'm not prepared to share my screen if that's where you're headed.
I'm sorry, I'm maybe a little too used to these Zoom interactions.
We do have a hard copy of Sierra Club Exhibit 19 here with us.
Okay. Mr. Lytle, does this document look familiar to you?
Yes, sir.
And is this a discovery response that you sponsored in this case?
Yes.
And does the response and the attached exhibit appear to be a true and correct copy of the discovery response you provided?
Yes.
Hearing examiner Lennon, I'd like to move this exhibit into evidence.
Well, I've got it in front of me. If you just give me a minute to figure out what it is, I would appreciate that. Or at least try to figure out what it is, or else I'm going to ask for some more foundation than just a reference to a response. So give me a second to see if it's relevant to the case. Well, you asked for the SPS's actual capital expenditures for its steam gas plants incurred each year between 2000 and 2020, including the total amounts by year for each facility. And that's kind of what it looks like. Mr. Smith, could you just tell me, like in a sentence, why that's relevant to this case?
Yeah, Mr. Lytle just testified that the capital cost estimates that the company used for its modeling are based on their experience with all of their steam gas units in the fleet, and he indicated, I believe, that those units are similar in size and technology to what Harrington would operate as a gas unit.
An accurate sample for the model to predict the Harrington, right? That's what he claimed, essentially. Okay. I guess I don't need to put a spin on it with my language. I see a whole lot of dollar figure numbers and a whole bunch of plants over a whole bunch of years. Well, it could be relevant. So does anybody have any objection to the mission of this document? Okay. Hearing no objection. Exhibit number 19, which is a response to a discovery interrogatory question number SC 6-5, including the response, which is on a pleading, in a full pleading form with an objection, general objection. And then it's quite a few pages of charts. Let me see, it goes all the way through to page 9 of 9 and page 6 of 6 of the responsive charts. No, there being no objection, it's now admitted. How are we going to label this one? We already have it labeled as Sierra's number 19, right?
That's
Once
correct.
again, we're playing out of order games, but I'm going to leave it labeled. And even though we haven't admitted a whole bunch of them, we're going to admit number 19. Sorry for beating that horse until he was very dead. Now you can ask questions about the horse.
Mr. Lytle, you testified that the Harrington units, once converted, are going to be operated, and I believe you indicated operated as assets that are similar in nature. And you described the other steam and gas units in the company's fleet. Is that correct?
Yes.
And so this document here, these capital addition values, and in particular, the second to last column, if one were to evaluate, look at these, let me back up and rephrase. If one were interested in putting together an estimate of costs to operate the converted Harrington units, would it be relevant to look at these data points for annual capital expenditures expected at the plant?
Yeah, and if you do that, over time, if you look at all these data points over this, it's actually 21 years. It ends up, we spend about less than $1 million per unit during that time period. However, there are, if you look on here, there are some, each one of the units has some large numbers spent on it for specific things that have kind of once in a lifetime events. A lot of them have a $5 and $6 million year in there. Most of those are go back to controls retrofits where we completely changed out all the controls on the units. That was a once in a lifetime event that we have already been passed. So if you take those out, that number would actually drop significantly below that. Harrington has already had those events, those controls retrofits. These plants, all these units here are much older than Harrington. So taking all that into account, the numbers we have out there, our 5-year budget, we go out and we create that 5-year budget. I actually take projects that have been identified. I go out there and look at 5 years. The last 2 years of the budget, when this document was created, when I came up with those numbers, were actual projects and contingency out there for those last 2 years. That's what we provided to Ben to use in his modeling. That's what we are. That's what we know today as our best guess. That's what we're going. It aligns with what we have here in this document to some extent. We think it might be, we may be a little liberal there with it. We may be a little bit conservative, but that's where we're forecasting it now. And that's what we're justifying to our board of directors each year when we go in with our 5-year budget.
Okay. When you say once in a lifetime events, you'll note here, however, there's several of these. Maybe you'd refer to them as once in a lifetime events, but there are several entries under several of these plants that are in excess of $3.75 million. Isn't that right?
There are some units that have, because those have been extended. Some of these units we are going on in excess of 60 years. We're past 60 years extensions. So we're putting in, having to do significant rotors, replace entire boiler sections.
Replace entire boiler sections?
Yes, sir.
Thank you.
So, we're not only to end of life, we're past end of life. We're trying to manage those past. We're anticipating Harrington not going that far and having to get into that realm of operation. Harrington, having been one of our most significant facilities in the past, we've had to maintain it at a high level. We have flywheel there to be able to operate into the future. But eventually, we're going to be, our goal is, our corporate goals and our company goals for SPS are we're transitioning to renewables. And Harrington, the building block for us to get there, it's a transition facility, and that's what our hope is to not invest much money into it in the future. That's our hope in trying to manage it and keep it as reliable as we can. But our hope is to get to our carbon goal corporation as soon as we can.
Thank you. You noted that several of these other gas units are beyond sort of, I guess, what their original anticipated lifespan would be. Harrington is as well, right?
Well, these other ones have met, they were typically 35-year lifespans. Many of these are past 60. We're trying to get to, I think 60 years on Harrington is what we have as our retirement dates that are published that we're trying to get to. We're just trying to get to where.
But initially, Harrington's the end of its useful life was going to be somewhere around 2010 or thereabouts, I believe Mr. Grant said.
Yeah, originally, I don't know what those were.
Are you asking if Mr. Grant said it or if that was the case?
I'm asking if he knows that if that's the case.
Okay.
I don't know what the original.
I have been. We are past. Sorry, I didn't mean to talk over you. Go ahead.
I do not know what original lives of the units. I know since in my 30 years, it's always been the 50 or 60 year life is what's been anticipated them being able to make it to.
Okay, if the unit is past its initial useful life, would you generally expect it to have more capital and upkeep costs on an annual basis?
Yeah, once we get past that 60-year mark, we're going to have to spend a lot of money to keep it going. Yes, I would agree with that.
Great, thank you. I want to talk a little bit about the assumed capacity factor for the converted Harrington units. At page 8 of your rebuttal, we can flip there. Pages 5 and or lines 5 and 6 there. You indicate that it's a matter of simple logic that a plant running at 10% of the time should endure less wear and tear than the same plant running 50% of the time. When the Harrington units are converted, they're going to operate more like peakers than baseload units. Is that correct?
Yeah, it's actually, we're doing that today. Those units are, we're actually running them on coal today as peakers. They're in the market, and when they're called upon, they start up. They have a short down. They only have to be down 4 hours before they can be called on again. So if they shut them down at midnight, they can have them to be back on at 4 o'clock. So our operations crew out there is doing an outstanding job of really bottling up the boiler, keeping it ready. They're actually keeping the turbine spinning and hot in the event they're coming back up. If they're not called upon that day, they bottle up the boiler so that they're ready to go the next day. So the response time of them coming back up is really has really increased, and it's made them more valuable to the system. Harrington recognizes their existence depends on flexibility and their ability to fill those voids when renewables aren't going to be around. Combustion turbines are excellent to do that for us, except they're very expensive and very hard to permit and get interconnects and get utility commissions and all the customers and all
Your
the
Honor, can I
interveners.
interrupt here and object? He's going a little far afield now. I appreciate the explanation.
Well, I'd rather hear him out, Mr. Smith. I mean, I'd just rather hear him finish his statement. Could you continue, sir? You mentioned flexibility to fill the needs of the systems. And what was the rest?
They are really working to fill that void because fossil generation, although there is a need for it, we're going to continue to have a need for it. But I was here a year ago defending our build out of Sagamore, and I want to be here in another year or two defending the need for our next wind farm or solar farm, because that's the future for us.
So, when I prep witnesses to testify, I would tell them answer the question, only the question, and nothing but the question, and wait 3 seconds before you answer it so that I can object on cross-examination. So, Mr. Smith, sometimes you open a door and the guy walks right through it, and sometimes he hits a wall on the other end, and sometimes he doesn't. But I understand your situation, Mr. Smith, and I would ask the witness to answer just the question that's asked, and let the lawyer do all the work, sir.
Okay, I apologize.
Go ahead, Mr. Smith.
So as a peaking unit, as peaking units, the Harrington units you would expect to be starting and stopping more frequently. Would you generally agree that cycling a generation unit can increase its capital and operations and maintenance costs?
I would have vehemently, I don't know if I said that word right, but I would have agreed with that 100% a few years ago that we're going to kill our units doing that. I think today we just opened the Harrington unit, saw the turbine, saw the valve, saw the boiler after being cycled for 3 years, really since 2017. The damage, we saw no excessive damage. So it appears what we're doing is working. In general, that statement I would say was true, but I think the way we're managing it, say that it's happening yet. Maybe the jury's still out on that. But everything points to we're not seeing it yet.
Oops. Okay, but historically, you would expect cycling to incur more capital and O&M costs at a particular generation unit. Is that right?
I think that would be, industry would have said that, yes, sir.
Okay. Now, you would agree that SPS's assumed 3.75 million annual capital cost for the converted Harrington units was developed to be consistent with the operational assumptions in Mr. Elzey's modeling. Is that right?
His modeling, as Mr. Grant said, doesn't really reflect what I would call real world. I think we anticipate higher capacity factors than zero because of what we see. We see economic modeling telling us what we're going to have, the units are going to run next year, and then the actual real performance of the units is higher every time, every year. So my work in developing that is anticipating more, but not near to where we are today, what you see today. So I anticipate all units running more than what Ben's model is saying, but not what we are today.
Okay. A couple follow-up questions there. There's nowhere in your direct testimony where you indicated that you believed that the Harrington units are going to operate more often than the company's modeling projects. Is there?
No, I don't make that statement.
You didn't make that statement, or you don't make that statement?
I do not make that statement in my testimony. No, sir.
Thank you.
But when Mr. Elzey put together the modeling that he's conducted for this particular proceeding, he came to you and asked for assumptions about capital expenditures that could be expected, right?
Yes, my capital expenditures were an input to the modeling that he then ran. And so I had to make some assumptions. A gas plant, assume gas prices were some number, and that those would be dispatched similar to our other facilities. So that gave me an idea of what I should be putting in there. So then you could look at historical and look at those areas or those projects out there that we have identified that need to be performed. And that's where I came up with my numbers to provide him. So I fed him information for his models that then predicted zero. He didn't predict zero and come back to me to figure out what the models, what I should be, And plus I have to, when putting together a capital budget, I have to, if it's not going to run, I would not put any capital budget in. And that would be, I have to provide a reasonable capital budget that I can defend to the board. So if the unit is there and it's available and it's in our SPP market, it can be dispatched. If it's called on to run, we have to run it. So it's that would not be reasonable for me to put zero capital in for a particular unit either.
Okay. If the units do end up running more frequently than the company anticipated, would you expect the capital cost to be higher?
If the units do run more and it's significantly more, some of the capital is based on throughput or hours based or, some of those things. Now we are trying to transition to maintenance based on technology. So we just don't open something up because it's time to, we want to measure something to drive our maintenance, but we're not there in every case. So more hours of runtime could lead to more capital and O&M costs. O&M costs can be driven up. Chemical usage and those type of things are directly related to runtime.
Okay. Thank you. I want to ask a couple of questions about the pipeline construction and gas supply. Again, if you could flip back, I'm sorry, to your direct testimony at page 8. Are you there?
Yes, sir.
Okay. On page 8 at line 16, you note that currently the current pipeline that serves Harrington can provide about 37,000 decatherms per day. But on the next page, the converted Harrington units are going to need approximately 7 times that, 265,000 decatherms per day. Is that right?
Yes, sir.
But you don't have any firm contracts in place for that gas right now, do you?
No, we do have firm contracts with several for our gas supply. Our gas supply is actually one of our sister companies in Colorado. The gas company of Public Service Company of Colorado acquires our gas for us for all our gas facilities. They have firm gas supplies, contracts with several suppliers, and they can move that gas around to multiple, any of our facilities. And exactly how they do that and how that works out, I'm not real familiar with, but that's what I've been told. What we will do is add the Harrington to those existing contracts or expand those contracts if and when this gets approved and we go forward. We have not signed anything expanding those at this point until this is approved. We don't want to, it's really not prudent to do that at this point.
Okay. And just to clarify, yes or no question, you don't currently have any firm gas contracts for the Harrington units?
I think he answered
We have firm.
that question. So I'll sustain that objection.
During the I want to back up and talk a little bit about, let's talk a little bit more about this gas issue. During the winter 2021 storm event, SPS's supply of natural gas was disrupted, wasn't it?
I think Mr. Grant answered that. He could do a better job answering that. I'm not directly in operations. And I think he answered to the affirmative there, but anything past that, I'm not too familiar with.
Okay. Are you aware that SPS requested special emergency recovery provisions from the New Mexico Commission related to gas fuel cost spikes?
No, sir. I don't know that. I don't know that.
Okay. Did SPS didn't incorporate any future extreme weather events in any part of its analysis, did it?
In this analysis, that would be a question from Mr. Elsey, but I don't know.
That's all I have, Mr. Lytle. Thanks for indulging me.
You're very welcome. Thank you.
And thank you, Mr. Smith. Let's see, how about Mr. Bogatko? Do you have any questions?
No questions from Mr. Lytle, but we thank him for his attendance here today.
Mr. McMillan
No questions.
and Ms. Lynch?
I do have a follow-up question.
Please.
I'd like to just revisit the conversation you had with Mr. Smith about the Colorado Gas Company contracts.
Go ahead.
Yes.
Great. Nice to meet you, Mr. Lytle. And I'm here on behalf of the Coalition for Clean and Affordable Energy. So if I heard correctly, you stated that the Colorado Gas Company holds SPS gas contracts, correct?
There's a grouping that is in Colorado that it's actually in the fuels group that acquires the gas for our power plants down here in SPS.
Okay. And you said that that company also moves the gas to the gas plants?
They actually we have firm contracts with several gas companies, and then we have contracts with transportation on pipelines. So they work to get the gas to where we need it each day. And how they do that, and if I go any further than that, I don't know exactly how they do that each day, but I know that they are the ones that work to get us fuel at our gas facilities.
All right. So if we're looking at transportation of gas to facilities, does SPS take into account efficiency of that transportation?
I couldn't answer that.
So, do you have any idea of where the gas originates that will be used potentially at Harrington?
I have an idea, but I couldn't speak. I couldn't speak to with any accuracy, probably.
Okay,
In general, the cost is associated with the distance. So the closer it is, the better it is for us.
But SPS doesn't calculate the actual distance between where the fuel originates and where it gets used.
I don't know that answer.
Okay, that's the extent of my cross right now.
Okay, thank you.
Thank you.
Any redirect based on that cross-examination, sir, Mr. Santos?
Just a couple of questions, Your Honor.
Yeah.
Mr. Lytle, do you remember the questions that Mr. Smith asked about getting a discovery request and what we provided in response to that discovery request?
Oh, on the basis of how we determine the budget.
The 3.79 million. It has, with respect to all discovery requests, has the company attempted to answer every discovery request fully and in good faith?
Yes, we did. What we provided in the verbiage in how we develop our 5-year budget was responsive to that question. And I believe we pointed them back to that. And that's how we develop a 5-year budget. And that the experience and actual budget that we were developing is how we came up with that 3.75. There was no external engineering firm that came in and helped us develop it or anything like that. It was internal knowledge of with a lot of experience that helped put that together, and that we were responsive to our intent is to be responsive to every question.
No further questions, Your Honor.
Thank you very much. Any recross within that very, very limited scope? None. Okay, excellent. Actually, I have no further questions. So maybe we release this witness, Mr. Santos, and everybody. Is there any reason that we're going to recall this witness? Nope, I didn't think so. So, sir, thank you for your testimony, and thank you for your testimony today on the cross-examination. Appreciate it. Have a great day. All right, how about if we take 5 minutes and come back in 5? I will look at my clock. It's 3:10. We'll come back at 3:15 and call the next witness. Is that okay, Mr. Santos?
Your Honor.
Okay, see you back in 5. I apologize to everybody. I see that I'm a couple minutes late. Sorry about that. So is our next witness Mr. West? Is that Mr. West? Hi, Mr. West. How are you?
Hello, sir. How are you?
Good. I'm the only guy that's not really on either side here today. And of course, there's Mr. Lee. Okay, we'd like to swear you in, Mr. West. Mr. Lee, would you please do the honors?
Would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter not pending should be the truth, the whole truth, and nothing but the truth.
Yes, sir, I do.
Okay, if you would identify him for the record, then begin your examination, Mr. Santos.
Yes, Your Honor. Mr. West, will you state your name for the record?
Jeffrey L. West.
All right, Mr. West, you should have in front of you what have already been marked as SPS Exhibits 5, which is your direct testimony filed in this case, and SPS Exhibit 6, your rebuttal testimony filed in this case. Do you recognize those documents?
Yes, sir, I do.
Any changes or corrections to make to either of those documents?
No, sir.
If I were to ask you the questions that are contained in SPS Exhibits 5 and SPS Exhibit 6, would your answers remain the same?
Yes, sir.
SPS offers SPS Exhibit 5, the direct testimony of Jeffrey L. West, and SPS Exhibit 6, the rebuttal testimony of Jeffrey L. West.
Thank you, sir. Appreciate your efficiency. Let's see if anybody has any objection. Mr. Marks or Mr. Smith? No, none from either counsel for Sierra Club. Mr. Bagatko?
No objection, Mr. Hearing Examiner. Thank you.
Thank you, Mr. Bagatko. Ms. Lynch?
No, sir.
And last but certainly not least, Mr. McMillan. With us,
No, Your Honor.
No, Your Honor is a good answer. Okay, there being no objection, there's not much for me to decide. So the direct testimony of Mr. West and the rebuttal testimony of Mr. West dated February 1, 2022. Well, the direct testimony is a different date, but the rebuttal is February 1, 2022. Those are admitted as evidence. They are admitted as SPS Exhibit number 5 for the direct and SPS Exhibit number 6 for the rebuttal. Thank you. Please proceed. Oh, who? Pardon me. Go ahead, Mr. Santos.
We would tender Mr. West for cross-examination.
Thank you, sir. I wasn't positive where we were in the proceedings. I was actually thinking two things at one time, and that's always very dangerous. Okay, Mr. Marks, is this going to be yours or Mr. Smith?
Mr. Smith.
You want to arm wrestle about that? Because you seemed to be disappointed last time around.
We can rock, paper, scissors over
There you go. Sorry, I try to inject just a little bit of lightness. It's now 3:20 p.m. and we might need a little bit of levity to proceed. Mr. Smith, with apologies, he's your witness.
Okay. Thank you, Your Honor. Good morning, or good afternoon it is now, Mr. West. My name is Joshua Smith on behalf of Sierra Club. You are the director, senior director of environmental services for SPS, is that right?
Actually, I'm the Senior Director of Environmental Services for Xcel Energy, which includes all of the operating companies, which SPS is one of those.
Okay. And so you're ultimately responsible for all environmental compliance issues relating to Xcel's generation fleet, is that right?
Yes, sir.
And so it's fair to assume you keep up to date on environmental regulations that affect that fleet, right?
Yes, sir.
And that includes regulations under the Clean Air Act?
That is correct. Yes, sir.
And guidance issued by EPA, the U.S. Environmental Protection Agency, under the Act?
Yes, sir, as it applies to the Act.
And in your role, you keep track of actual compliance with Clean Air Act requirements, is that right?
Yes, sir.
And is it fair to say you oversee compliance plans when they come up?
Yes, sir.
And you're ultimately responsible for keeping track of whether SPS is complying with pertinent regulations. Is that right?
Yes, sir.
And this would include overseeing the implementation of any required pollution controls. Is that right?
Yes, sir.
And monitoring whether a generation facility is complying with its permit,
Yes, sir.
and whether the facility is complying with national standards relating to the generation asset. Is that right?
Yes, sir, as they are applicable in the appropriate state or jurisdiction.
And I believe you indicate in your direct testimony that you are responsible for reporting on compliance and tracking day-to-day compliance issues. Is that right?
Yes, sir.
And in your role, you communicate presumably fairly regularly with regulatory entities about environmental compliance. Is that right?
Yes, sir.
I do want to talk a little bit about compliance with the sulfur dioxide National Ambient Air Quality Standard at Harrington. You're familiar with what that is, correct?
Yes, sir.
And EPA issued a updated standard in 2010 addressing short-term impacts for sulfur dioxide. Is that right?
Yes, sir.
And the standard is set at 75 parts per billion, correct?
Yes, sir.
And that, under the Clean Air Act, is the standard, the maximum concentration at which EPA is determined is requisite to protect the public health. Is that correct?
Yes, in an area, a defined area.
And I think, as you noted, pages 10 and 11 of your direct, short-term exposure to SO2, sulfur dioxide, is linked to a number of health problems. Is that correct?
That is correct. Yes, sir.
EPA, in issuing the 75 parts per billion standard, actually found that exposure for periods of time as little as 5 minutes can cause serious public health impacts. Isn't that right?
That I could not answer. No, sir.
Now, on page 5 of your direct testimony, find myself, thank you. I appreciate your patience. At page 5, you discuss how regulatory compliance with the standard is determined. You see that there?
Yes, sir.
And if I may summarize, in essence, compliance with the standard is determined by taking the 3-year average of the 4th highest hourly reading or hourly emission value or concentration in a particular area. Is that fair?
Well, to clarify, the 99th percentile of the highest daily maximum for a year is used as the concentration for that year for 3 consecutive years, and then averaged for the SO2 max concentration.
Averaged for
I'm sorry, Mr. Lee.
Average for the next SO2 concentration?
For the NAAQS, NAAQS concentration.
And the 99th percentile translates into the 4th highest hourly reading for the year. Isn't that right?
That is correct. Yes, sir. It's the 4th highest daily max for the year.
Okay. Thanks for that clarification. And so for Harrington, there is a air quality monitor that's located outside the perimeter of the plant that's determining hourly readings of sulfur dioxide. Is that correct?
There is a monitor outside of the plant. It is not specifically for Harrington. It is for Potter County to determine attainment with this standard.
And that monitor became operational at the end of 2016, right?
Yes, sir.
At page 6 of your direct testimony, let me know when you're there. I don't want to jump ahead.
I'm here, sir.
Okay. You note that the monitored emissions for the period of 2017 through 2019, by the end of 2019, it became clear that air quality at the monitor location was not meeting the 75 parts per billion standard. Is that right?
Yes, sir.
When exactly, so let me back up and just clarify. One of your jobs is to evaluate and monitor and report on compliance with standards like the SO2 max. Is that correct?
Yes, sir.
And so when did it come to your attention that there would be a compliance problem at the monitor, at this particular monitor outside of the Harrington power plant?
In the 2019 timeframe, as we entered the last year of monitoring, that's when, as we monitored those air concentrations at the monitor, we determined that there could be a compliance issue at the monitor.
Well, you were aware before the end of 2019 that there was a compliance problem, right?
Well, there was a potential. We had not finished the 3-year monitoring period at that particular time in accordance with the National Ambient Air Quality Standards.
But in your role reviewing compliance with the standard, you're aware that in 2017, hourly readings at the monitor were routinely higher than 100 parts per billion.
There were times, yes, but once again, I would remind you that the standard is an average of the 99th percentile of the highest daily maximum. So in 2017, you cannot make that determination.
And in 2018, there were again routine exceedances of the 75 parts per billion standard. Isn't that right?
Yes, sir.
Are you aware that for 2017, the fourth highest daily reading or hourly reading would have been about 116 parts per billion?
Not without having the monitor data in front of me, no, sir.
Okay. Well, let's go to that if we can. Can you do you have Sierra Club Exhibit 25, Mr. Santos?
Once again, Counselor, if you would just give me a minute to pull it up.
Is this the exhibit that we got yesterday?
It is. This was an exhibit that I inadvertently omitted from the Friday package that we sent around.
I just will note, I'm not sure how your pagination prints out. The way it prints out here is a little difficult. Ours printed out 120 pages, but I'll let your exhibit. So it may take some.
Thank you.
I'll let you handle it.
Thanks.
I don't have it on my screen yet. Mr. Smith, that's one that you sent me directly under your, not cover, but under your email, right?
This one, I believe, is a public document and was sent by Ms. Hogru, Ms. Lauren Hogru. Should have been yesterday morning.
Okay. Yeah, bear with me. I get a lot of this kind of stuff, and there wouldn't be enough hours in the day for me to read all of them. Okay, I got something from her, which is Exhibit 23 yesterday. I only have one piece of mail from her. It has Sierra Club number 9, Sierra Club number 23, and Sierra Club number 2. Let me see what else. Wait a minute, something else there from the afternoon. Yes. Okay, pardon me. It came at 3:01 in the afternoon. It's almost 24 hours ago. Labeled number 25. And if you give me just one brief second, I'll get that on my screen. Oh, I remember this one. I didn't read all those little tiny numbers, but I did get scared when I saw that they were little tiny numbers. So if you could direct me to the important little tiny numbers, I would love for you to ask this witness about those important ones.
Yeah, I'll try to do that. And I apologize that it is a little wonky to view on a screen as well. But this is the way that the data is presented. Mr. West, do you have what's marked Sierra Club Exhibit 25 in front of you?
Yes, sir.
Does this look familiar to you? Is this?
Yes, sir. From what I see, this is the hourly monitoring data from the monitor near Harrington Station.
Okay. And so if you'll indulge me here, and I'll try not to belabor this, but I'd like to walk through this with you and show the hearing examiner some of the important or relevant readings here. And so we've discussed the relevant standard is 75 parts per billion. And this particular document has the hourly readings for every day of every month over a period of time. Is that what it looks like to you? If you flip through it?
Yes. Yes, sir.
And so this document, the first page here is January 2017. This is right about the first full month of monitoring that was conducted at that particular location. Is that right?
Yes, sir. The first official month of the 3-year monitoring period.
Okay. Okay. Excellent. So we'll try to go through this pretty quickly but I do want to kind of walk through and do a little bit of a back of the envelope analysis and talk with you about this. So we talked about the way the standard is evaluated on a 3-year average. And we take, and you, as you pointed out, you take the fourth highest daily hourly value, and you average those over the 3 years. And so I want to just draw your attention to that first month there. You see down at the bottom row 24, there's a reading that is 84.9. And that means 84.9 parts per billion. Isn't that right?
Yes, sir.
So right now we'll go through and we'll highlight some of the exceedances, and we'll try to figure out if we can roughly what the yearly value might have been. Does that sound okay?
Yes, sir.
Okay. And so if we continue to flip to the next page, February 2017, on line 9 at hour 2100, we have a reading that's 96.9. You see that?
Yes, sir.
On the following page, in the following month, March 2017, on the 15th day, that's 15th line, that's the 15th day of the month. Is that correct?
Yes, sir.
You see an hourly value of 110 parts per billion. Is that correct?
Yes, sir.
And on the next day, at hour 00, there's an 82.7. We'll try to go through these quickly. I'm sorry, I don't want to bore you too much, but there will be a point, I hope. Flip to the next month, April of 2017 was okay, right? The highest there was 74.2. Keep going to May 2017. Again, no exceedances of the limit in that month. Come to June 2017, the next page, page 11 of 120 of Sierra Club proposed exhibit 25. At day 21, there's a 114.5 number. Do you see that one?
Yes, sir.
I'm going to just write these numbers down and we can kind of come back to it. Flipping ahead to the next page on July 2017. Again, in this month, no exceedances. We go to July or August 2017. Again, we don't see any exceedances in that month. In September 2017, on page 17 of the document, line 7, we have 141.1 parts per billion. On line 8, there's 120.2 parts per billion. On line 19, there's 104.5. 22, there's 87.8. These are all readings above the standard. Isn't that right?
Yes, sir.
In October of 17, we have 99.2 on line 7. And we have an exceedance on line 12. We'll write it down, but that one's only 77. And for November 2017, we don't have any exceedances in that month either. And then in December of 2017, we have 116.0 at line 25. That's the 25th day of the month. And we also have a line, we also have a 114.3 on the first line or the first day of the month. So I've just written down, and I don't know if you've been writing them down as well, but we've been tagging or flagging some of the exceedances of the standard. And so based on some of the highest values we were able to identify, we would, if we were going to determine compliance, we would identify the 4th highest of these values. Is that correct?
I don't know how you wrote the numbers down because there was a couple days you referenced several exceedances of the standard. You only used the one highest for that particular day. So if there was, I believe, a day where you referenced 3 exceedances, you would only use the highest for that day. You would not use your 3 in determining your 99th percentile.
I don't believe I referenced any in the same day, but if you can identify any within the same day in the first year there, please let me know.
You did back on, it was the day that referenced 140, I believe. You referenced several other on that same day. And I unfortunately don't know what day that was, but you started with 140, I believe it was, and then referenced several others the same day.
So in September 2017, on the 7th day of the month, there was a 141.1 reading.
Yes, and then you referenced.
And then the next day,
referenced 120.2,
which is
and
the
then
next
you
day.
also referenced 104.5 and 87.8. You referenced 4 of those on that one day, where on that day, your correct number to use would be 141.1.
Actually, so that in this chart here, the way these are tabulated, the days are along what would be, I think, the y-axis.
Oh, correction. I understand exactly where you're going. Yeah, you're right. Correct, Josh.
And so just as a kind of, again, back of the envelope exercise to determine what our 4th high would be for this month. As I look at this, as I look at these numbers here, the 116 number is the 4th high, but it's going to be somewhere in the 1-teens somewhere. We had a 141, a 120, a 114, a 116, a 114.3, a 110. So somewhere in that 110 to 120 range. I believe it's the 116 range. Would you accept that?
Yes.
Okay. promise not to belabor this too much, but I do one more effort here. So we take this is our first year. 116 is the number for the first year, we'll say. Let's go to the second year, January 2018. On the first month there, page 25 of the exhibit, we have an exceedance on the 26th day. That's 125.3. Write that one down.
Mr. Smith, could you just proffer a one-sentence brief explanation how this is relevant to burning gas instead of coal?
This is relevant to when SPS knew that there was a compliance problem at Harrington and that it would have to either retire, convert, or replace the units. And this is relevant to, we touched on this a little bit at the outset, Your Honor. One of the reasons that replacing Harrington with new generation becomes difficult, and this is according to Mr. Elzey, who we'll talk to a little later, is that there's just not enough time to add new resources. There's not enough time, in our view, because SPS waited until 2021 before evaluating the issue in earnest.
They knew in 2017, that's what you're attempting to show, and they should have done something then?
Well, what I'm attempting to show is that no later than 2018, anybody that was watching the monitor would have known that it was going to violate.
Okay, I'm sorry to interrupt you, Mr. Smith. I appreciate your proffer.
Moving along, we'll try to take this pretty quickly here. In February 2018, there's a 77.8 reading on the 8th day. Moving along to March 2018, and I apologize that the formatting gets different here. It is from the same source, but March 2018 on page 29, there's an 81.4 reading.
95.5 on the 15th, isn't there?
That's correct. Thank you,
Sure.
Your Honor, for identifying that one. 95.5. Moving along to April. Again, we're back to the other funny format. Apologies. In April of 2018, on the 29th day, we see a 93.8 reading. In May of that year, on the 7th day, we have a 114.2. On the 11th day, we have a 109.2. On the 12th day, 100.7. And another exceedance on the 18th day at 78.9. Now, we can stop this exercise now pretty soon here. Let me go through 2 more months, and I hope get to where I want to get. In June, we have on the 8th day 105 reading. On the 15th day, 130.9. On the 26th day, a 209.1. That's 3 times the limit, right, Mr. West?
Close, yes.
Yeah, pretty close. The next day, there's 166.5 reading. So pausing here for a moment, in June 2018, already our 4th high at this particular monitor is, by my calculation here, 114.2. Does that sound fair? Does that sound like about right to you?
Yes.
So taking our 114 plus, let's just pretend for a moment that Harrington had 0 emissions for the remainder of the 3-year period. And so there's 0, we'll say for the sake of this exercise, that for the entire period of 2019, the final year of the 3-year period, the high was 0. If we take the fourth high from each of these years, 114.2 plus 116 plus 0, that equals 230.2. To get the average for the period, we divide by 3. And already in June 2018, if you were watching the monitor, you would see that the minimum design value for the 3-year period would be 76.7 parts per billion. Is that a fair assessment?
Yes, sir.
And I won't bore everybody with additional, going through these additional numbers, but there are many more exceedances throughout the 2019 period, isn't there, Mr. West?
At the monitor, yes, sir.
And in fact, at the end of the 2017 to 2019 period, the design value ended up being in excess of 100 parts per billion. Is that right?
Yes, sir.
Okay. So just summarizing, don't mean to repeat myself, but by June of 2018, Excel had information that the monitor was going to be violating the limit. Is that correct?
The monitor was in excess of the standard. Yes, sir.
Okay. Thank you. I want to go back to your direct testimony at page 6. On page 6, you start to describe the so-called non-attainment process for under the Clean Air Act. And I'm summarizing, or I'm paraphrasing here. I think you say, when an area is designated as non-attainment, a state implementation plan must be developed. This includes statutory deadlines for compliance. This plan is generally referred to as a non-attainment SIP, isn't that right?
Referred to
Yes, sir.
as a non-attainment.
SIP, State Implementation Plan.
Thank you.
I'm sorry, Mr. West, I missed your answer. Is that your understanding?
Yes, sir.
But EPA has not designated the area around Harrington, Potter County as being in non-attainment, has it?
No, sir.
And so Texas was never required to put together a non-attainment SIP, right?
No.
And the area to this day is still technically designated as being called unclassifiable. Is that right?
Yes, sir.
And so the Clean Air Act requirements and deadlines for non-attainment areas don't actually apply to Potter County, do they?
No, sir, they do. The reason that the area was not designated non-attainment was because of our conversion to gas, because EPA was required to make designations for that area by December of 2020.
And EPA had made a designation for that area in 2016, correct?
As non-attainment unclassifiable, correct? Or excuse me, attainment unclassifiable.
And they have not redesignated the area, is that correct?
No, sir.
So so I want to draw your attention to page 7 of your testimony at lines 9 through 11. And again, you're here, I don't want to put words in your mouth, but you're talking about non-attainment SIPs still, right? In the lines that precede this, is that correct?
I'm talking about what's involved with non-attainment if an area is designated non-attainment.
Okay.
And then the previous conversation references the process with which a state develops a SIP to comply for non-attainment.
Okay. And so at line 9 through 11, you state this order, capital, will be included in the SIP submitted to EPA by the state to document compliance with the standard. Is that, you see that?
Yes, sir.
This order, presumably you're referring to the agreed order that SPS entered into with TCQ, is that right?
Yes, sir. The contents of the order.
Smith, help me again with the relevancy to issues in this case. I just don't see it, and I want to make sure I follow you completely.
The relevance here, Your Honor, goes to one of the issues I talked about at the outset, and it really gets to the question that you had, and I believe you might have interrupted my opening statement at the outset when you asked whether we were going to submit evidence about communications and the agreement that the company SPS entered into with TCQ and how that process played out. And so what I'm getting at here is getting to that agreement and whether this particular order was required by EPA under the Clean Air Act.
I appreciate that. I hope that you'll just give me some more evidence to hang my hat on why that would be relevant to the issues in this case in the state of New Mexico concerning approval of the pipeline project. So I'm trying to telegraph to you that I need a little more evidence that it's easier for me to understand and then I can put in my RD because you know, you're getting far afield. You did a nice statistical demonstration. I'm one of the few guys you'll ever meet that actually likes statistics. Right now, I understand there's this Texas thing happening, but I'm in Santa Fe, a block from the Capitol building. You know, I'm going to make a recommendation to the state of New Mexico, PRC. What agreement there is in Texas, I mean, I'm not saying it's not important, but it's perhaps not quite as important as you might think it is. You're in Oakland, California, and we're two different states, two very different states. And what Texas does is important, certainly is, and I certainly look at it and we look at it, but it's definitely not determinative, if probative. So I'm looking for at least to be of some value for resolution of the issues in this case. And I haven't really heard it yet. So I'm not trying to beat you up. I'm trying to do just the opposite by telegraphing to you that I need to hear a little bit more clearly defined connection for my simple mind, please.
Okay. Message received. I'll move along. So in response to the monitoring data that from this particular monitor outside of the Harrington facility, SPS conducted an economic analysis in about the third quarter of 2019. Is that correct?
Yes, sir.
And SPS approached TCQ with its plan to comply with the standard out at Harrington. Is that correct?
Yes, sir.
So the agreed order that came out of that process was SPS's decision to convert all 3 units to gas. Is that correct?
Partially. And I'll elaborate on that. The decision to convert all 3 units to gas was a decision that we made based upon cost effectiveness and reliability. But the decision to make some type of switch at Harrington was directed by the current results of the monitor for the NAC standard and outreach originally to us from TCQ in early 2020 in reference to the results of the monitor.
So the economic analysis you did though in 2019 evaluated a couple of different options. Is that right?
My understanding, but Mr. Elzey is the one that conducted that analysis.
Okay. In any case, you took the conversion plan to TCQ and negotiated a compliance date. Is that correct?
That's correct.
There was no public stakeholder process for that agreed order, was there?
Yes, there was. There was a public hearing, TCQ Commissioners hearing in October of 2020, where that agreed order was presented to the public and comment was secured, and it was officially ruled on by the commission as approved.
Okay, let's talk about that a little bit. You attached to your direct testimony the agreed order itself, but I want to take a look at Sierra Club Exhibit 6. Can you bring that up, or can you grab that, Mr. Santos? Let me know if you've got it. Do you have it?
I have it, sir.
Okay, I'm sorry. I'm trying to manage a tiny screen and couldn't quite tell what you were doing. Does this document look familiar to you?
Yes, sir.
And so this is the Texas Commission on Environmental Quality agenda item involving this particular agreed order. Is that right?
Yes, sir.
And it's dated agenda request October 21, 2020. And that was the date that of the hearing that you referred to, isn't that right?
Yes, sir.
That was a public meeting, is that right?
Yes, sir.
Okay. I want you to go, can you flip to page 3 of the document?
Okay.
Down about 3/4 of the way down, there's a subsection that says stakeholder meetings. Can you read what that says?
It says none.
Okay, thanks. And so again, we agreed that this particular agenda request was on the 21st. And then I want you to go back to your exhibit, the exhibit to your direct testimony.
Sir, I'm not finished looking at the Texas Commission, and I stress Texas Commission on Environmental Air Quality paper. I'm trying to find out who wrote it. I'm trying to find out any type of foundation whatsoever for this document, which you apparently rely upon, at least to some extent. I can't even figure out who signed this thing or what was the purpose of this document. Could you please enlighten me just a little bit? I'm not talking to the witness. I'm talking to counsel cross-examining the witness.
Okay. This is a interoffice memorandum that the TCQ, the Texas Commission on Environmental Quality, puts together to present to its 3 commissioners that typically vote to ratify or reject environmental compliance plans put together by TCQ. That's maybe a generalization, but that's in essence what it is.
Well, thank you for that. And what I call it is admissible hearsay. Hearsay is, of course, admissible, and I give it the weight which is appropriate. And I'll just put a period after that declaration and let you continue.
Well, I would then offer it to be admitted, Your Honor.
Okay, well, fine. You've only talked about the beginning of the document. There's a whole bunch more that continues on. So are you moving to admit the entire thing or just up to the part which you've already talked about, which is the internal communication within that? It looks like some sort of Texas agency. Which part? The whole thing?
Well, beginning on pages 5 through 11, this is
Okay.
a duplicate of the agreed order that Mr. West attaches to his direct testimony, JLW-1.
But that's the part we didn't even talk about yet. You didn't elicit any testimony about that
Not-
second part. You go in
Not
there?
yet. Not yet, but I guess what I was trying to answer your threshold question, which is, do I want the whole thing? I don't need 5 through 11 because it's already in the record, but I attached it to this so that Mr. West would be able to identify the document in total.
All right, well, I'll just make a few comments. It's not signed. It's not dated. The first part is not even indicated who wrote it. Looks like 7 copies were sent to the chief clerk, but nobody signed it. Nobody says who wrote it. You know, it's a very limited value. Here it is. It's from somebody named Aaron E. Chancellor, Deputy Director, Office of Legal Services. And secondly, Tanya Baer, Deputy Director, Office of Air, whatever that is. And they work in the Texas Commission of Environmental Quality. And I presume that it's inter-office memoranda. So frankly, I need to know that it's of some sort of probative value to the issues in this case, and I don't see them. I'll give you another opportunity, Mr. Smith, to explain why this has any probative value at all.
Your Honor, if I might also weigh in a little bit here,
Sure.
The company really, in terms of letting Mr. Smith, have a full opportunity to ask questions, I haven't objected thus far, but I quite frankly don't see how he lays a foundation for this exhibit, given the draft nature and nothing on the exhibit that makes it self-authenticating. So I would just say that I haven't objected to foundation yet in terms of his offering it, but I don't know how he's going to get there.
Well, it sounded a lot like an objection to me. I'm going to consider it as such. There's been a motion to admit it. I mean, I'm looking at it. I will consider it as evidence unless it's admitted. I obviously can see it with my own eyes, but I'm not going to consider it as evidence. I'm still looking at it to figure out what value this has to the issues in this case.
Well, but maybe if I just ask a couple more questions, it'll get there.
Please. Thank you, Mr. Smith. Go ahead.
Okay. So, Mr. West, I think we stopped talking. You had read the section there that said stakeholder meetings, none. I want you to turn back to your attachment JLW-1 that's attached to your direct testimony. And in particular, I'd like to direct you to page 7 of 7. Mr. West, what is this document? Just so the record is clear.
I'm sorry, Mr. Smith, we're trying to find it. Okay, did you say?
This is the agreed order, which was in the exhibit that was just seen on the screen. That's the question. It is, right?
This is the one that's actually signed. I quite frankly haven't had a chance to compare the one that's marked draft in Sierra Club's exhibit with the one that is actually signed.
Thank you, Counselor. So it looks like it to me, except for as, of course, it's executed, which gives it substantially more weight, to say the least. So let's go ahead, Mr. Smith.
And the point what I'd like to point out, Mr. West, on the signature page here, Mr. Hudson, who signed on behalf of Southwestern Public Service Company, signed the document on September 18th. Isn't that right?
Yes, sir.
And that was more than a month before the public meeting you described.
Yes, sir.
And so, as a logical matter, the public input at the public hearing had no bearing on SPS's entry into the agreed order. Is that right?
That's incorrect. This agreed order was not approved in totality until October 27th of 2020, as noted by Mr. John Neerman's approval from the Texas Commission on Environmental Quality.
But that has no bearing on SPS's adoption of SPS's agreement to the agreed order. Is that right?
That is correct.
Okay. Let's move on. Actually, Your Honor, I would like to come back to the admissibility of the document. I would offer the interoffice memorandum as an exhibit, and I can talk about how I think it comes in. I think Mr. West was able to identify the document. He's familiar with it. He had seen it. I think that's sufficient to authenticate the document.
Well,
additionally,
let me ask him a question. Sir, Mr. Witness, you recognize, of course, the second part of this Sierra Club Exhibit 6 as the unexecuted, quote, agreed order, unquote. Is that correct?
Yes, sir.
But the first part of it, which is entitled Agenda Item Request within the Texas Commission on Environmental Quality, do you recognize that document as well?
Yes, sir. It is publicly available on TCEQ's website.
And you've seen it, right?
Yes, sir. Yes, sir.
Okay. If you know, do you know who wrote this? Is it
Yes,
just,
sir. If you will flip to page number 2, it's the second page after the agenda item request.
right?
This came from Aaron Chancellor, the deputy director. That's who it's referenced on the front. That's my only assumption. I did not write it. This is a TCEQ memo, and it is used to document what will be discussed on the upcoming hearing. So the commissioners will post an agenda of an upcoming hearing, and these are documents associated with that.
Well, we do something similar here, so I'm kind of familiar with that, but I'm wondering what's the source of this information under stakeholder meetings, colon, capital NONE period, none. Where'd that come from?
That I do not know. And I will tell you that the agenda for the commissioners' meetings that are posted on the website they have more information than I see listed here.
And I just think that's part of the problem with this document.
I can't.
Examiner Lenham. I think, well, Mr. West can sit here and say, it looks like a document that I'm used to seeing. He can't authenticate the hearsay within the hearsay of this document. And to your point, there are statements in here that are that only the person who wrote it, Ms. Chancellor, probably has the ability to lay the foundation for.
Mm-hmm. Well, I'll tell you what, as you guys know, this is an administrative hearing. This is not a judicial trial, although sometimes they feel like it. An objection as to hearsay might be sustained in a judicial hearing or trial on the merits. One of my duties as hearing examiner is to assess the value of any piece of evidence. And I'm often put in the situation where I have to assess the value of hearsay evidence, because hearsay is admissible at these hearings. So I'm not going to exclude it because it's hearsay, but I take it one step further and I try to figure out what value does it have? Does it have generally? Is it probative to any of the issues in the case? And if it is, in other words, if it's relevant for short, I let it in. And then when I review these things, I review them more carefully after they're in, and I decide whether or not I'm going to rely upon it. And if so, to what extent or not at all. So that being said, and I think this is another one of them horses we've beat up quite enough at this point. The motion is to admit Sierra Club number 6. And I'm going to, with all those caveats and understandings concerning hearsay and foundations and stuff like that, and this being an administrative hearing, I'm going to admit, or I'm going to grant Sierra Club's motion and admit Sierra Club exhibit number 6 for what it's worth. And I don't mean that in a derogatory sense. I just mean that as a matter of fact. So Sierra Club exhibit number 6 is in the record. Thank you. Next, Mr. Smith.
Thank you, Your Honor. I want to talk a little bit more about the negotiation of this administrative order. The process of negotiating this administrative order was a fairly amicable one. Would you agree, Mr. West?
Yes, sir.
And would you characterize TCQ's approach as a flexible one?
I would characterize their approach as we provided them an alternative to meet a potential compliance issue in the area, and they were receptive to that.
In that process, do you recall TCQ at one point responding to the company's proposal and asking if the company wanted to maintain flexibility so that it wouldn't have to resume, quote, full gas?
Yes.
And what was SPS's response to that proposal?
In an effort to continue the approval of the agreed order, we agreed to their proposed comment.
But the final agreed order does include a provision for full gas conversion, does it not?
Yes.
So in other words, SPS decided not to take that provision out. Is that right?
Yes, sir.
Okay. I want to just talk about what compliance looks like under the administrative order. Under this order, SPS has agreed to cease burning coal by the end of 2024, correct?
Yes, sir.
So the company cannot, under this order, change its mind and decide to install pollution controls. Is that right?
Yes, sir. That is correct.
But the company could cease operating one or more units and comply with the order. Is that right?
Yes, sir.
Okay. Thank you. I want to move now to your rebuttal testimony, if we can. Let me find it myself. Give me one moment. You spend a fair bit of your rebuttal testimony responding to Ms. Glick's testimony regarding potential environmental compliance risk under the regional haze rule for the Harrington units. Is that correct?
Yes, sir.
And it's your view that regional haze is not a risk for the Harrington units. Is that correct?
Yes, sir.
Let's just back up and talk a little bit about what the haze program is, just for the hearing examiner and the public's benefit. The Clean Air Act's Regional Haze Program addresses air quality in certain national parks and wilderness areas. Isn't that right?
Yes, sir.
And it requires states to develop state implementation plans. Isn't that correct?
Yes, sir.
And those state implementation plans under the Clean Air Act and the Regional Haze Rule are required to include emission limitations that make reasonable progress towards natural visibility in those places. Is that a fair statement?
As applicable or as necessary, correct.
Now, if a state fails to submit a regional haze plan, or if EPA disapproves the plan, EPA has an obligation to step in with its own federal plan. Is that right?
Yes, sir.
And under the Clean Air Act, haze causing pollutants include, or pollutants of concern rather, include sulfur dioxide. Is that correct?
Yes, sir.
And nitrogen oxides. Is that right?
Yes, sir.
And general particulate matter as well, correct?
Yes, sir.
Now, the largest sources of these kind of pollutants are, generally speaking, large industrial sources like power plants. Is that correct?
They can be, yes, sir.
Harrington doesn't currently have any formal pollution controls for sulfur dioxide or nitrogen oxide. Is that right?
That is correct.
And in general, for a large coal power plant like Harrington, which lacks controls, states and EPA might require the source to evaluate and in some cases impose pollution controls like flue gas desulfurization. Is that correct?
Based upon their emission profile and to appropriate regulations and programs, yes.
And for large sources of nitrogen oxides, states might require what are called selective catalytic reduction systems, or SCR, it's sometimes referred to. Is that correct?
Yes, sir. That's one option.
That's one option. There are other options, selective non-catalytic reduction systems, that right?
Yes, sir.
In general, though, selective catalytic reduction is more effective at removing pollution from the exhaust of a power plant. Is that correct?
In general, yes, sir.
And they're also more expensive, right?
Yes, sir.
Now, when Harrington is converted to burn gas, it's not going to be emitting very much sulfur dioxide. Is that correct?
Yes, sir.
But it will still be emitting nitrogen oxides. Is that right?
Yes, sir.
Okay. Now, as you note on page 6 of your testimony, let's see, about line 8, the regional haze rule requires states to submit plans every 10 years. Is that right?
Yes, sir.
And again, every one of these plans, every successive plan is supposed to include emission limitations as necessary to make reasonable progress towards natural visibility. Is that right?
Yes, sir.
The first of these plans was due back in 2007. Isn't that right?
Yes, sir.
EPA disapproved Texas's initial plan. Is that right?
Yes, sir.
And it actually has implemented 2 different federal plans, or issued 2 different federal plans addressing those first round. If I refer to it as the first round, does that make sense to you?
Yes, sir, it does.
Okay. So EPA has actually issued 2 different federal plans addressing those first round obligations, right?
Yes, sir.
And both of those are still pending litigation, are they not?
The one for BART, best available retrofit technology, has been finalized. EPA has referenced that they will reconsider, but they have not taken any action on that. The other regional haze plan is still in litigation.
Okay. And so when you say reconsider, EPA could withdraw the earlier plan and impose a new one. Is that correct?
It is possible, but being that we're in the second round of that, it is highly improbable.
The BART plan that you referenced, did that generally require Harrington to reduce any nitrogen oxide emissions?
No, the federal implementation plan implementing BART was a Texas-only SO2 trading program proposed as a BART alternative.
And
I'm sorry, Texas only SO2.
Trading program.
And in the other plan that you referred to, the one that's still under litigation, that plan doesn't have any nitrogen oxide emission reductions either, does it?
No, as a matter of fact, that plan doesn't even address Harrington. It addresses another facility we have.
But between the two plans that EPA put together that are, that are still in various states of litigation or consideration, there's been no reductions of sulfur or nitrogen oxides from Texas sources. Is that correct?
That is correct, because they were not needed because the state continued to demonstrate that they met their glide path.
Okay, what is the glide path? You refer to that in your rebuttal. Tell me a little bit about, can you explain that?
Yeah, the glide path is essentially, when you talk about regional haze, this is visibility sustainability from 2005 levels out to 2064 at these 156 designated areas. The state are responsible every 10 years to demonstrate reasonable further progress towards that goal of 2064. So the glide path is the application to how they will meet that standard in 2064. So they have to demonstrate every 10 years how they are maintaining that glide path, or what their intention is if they are not.
And you state at page 6 of your rebuttal, I think line 12, currently Texas is meeting the glide path for compliance and accordingly will not require any further controls at Harrington. Is that accurate?
Yes, sir.
But EPA has not approved that conclusion. Is that correct?
Texas has finalized their state implementation plan and submitted it to EPA. It has not been formally approved by EPA.
And in fact, EPA has repeatedly stated that being on this so-called glide path that you described is not a safe harbor for considering and imposing pollution controls.
Mr. Smith, I'm going to just stop you for a second. Once again, I'm going to ask you for a proffer how the EPA case, how the Texas case, how this has any effect on the issues in my case here in the state of New Mexico.
Ms. Glick provided testimony evaluating the potential risk under the regional haze rule of additional pollution controls at Harrington. And if Harrington is required to install additional pollution controls, continued operation on gas is uneconomic. In
Thank you.
response, okay.
I hope you pull all of that stuff together in your case, and I presume that you will. But I'm only at this part of the case right now. I wasn't getting it. I didn't see the connection. So thank you for giving me a little roadmap there. Go ahead, continue.
And so I'll state, I don't think you answered the question, so I'll state it again. EPA has in fact stated that being on this so-called glide path is not a safe harbor from considering or imposing cost-effective controls. Isn't that correct?
That is not entirely correct. They have stated that you may not use that as the sole document for your compliance with regional haze and the planning periods associated with that, but it is clearly defined in the rule.
Okay. Can I ask you, Mr. Santos, to pull Sierra Club Exhibit 3.
I have it, sir.
Do you recognize this document, Mr. West?
Yes, sir, I do.
What is it?
This is guidance for preparing and implementing regional haze and preparing state implementation plans.
And it's issued, it was issued by a person named Peter Surrogatis, is that correct?
Yes, sir.
And he's one of the directors of EPA's Air Division, is that correct?
I do not know his title.
Okay. Will you go to page 15 of the document? You see section 5.4 there.
Yes, sir.
What does that say?
That says that uniform rate of progress is not a safe harbor.
Okay. And that indicates, again, that EPA doesn't believe that being on the glide path is a safe harbor from additional controls under the regional haze rule. Is that correct?
That is correct, but if you will read later in the statement, it referenced that in relation to what's called a four-factor analysis. And so these are supposed to be used in totality, not in singularity.
And so if using, and so let's back up a minute. The four-factor analysis is an analysis that states typically supposed to conduct to determine whether there are cost-effective pollution controls available at a particular source. Is that correct?
Yeah, well, the four-factor analysis brings in basically four scenarios that you would look at, and that is the cost effectiveness of the control, the time it takes to implement the control, any environmental impacts or non-air related issues with the control, and the remaining useful life of the facility. Those four factors are used to determine the four-factor analysis and the applicability for any control scenario at a power plant in the Harrington case.
So, but if a state or EPA determines that controls are reasonable using the four-factor analysis, the fact that the state is on the glide path does not insulate the source from installing controls. Is that correct?
That is not true in its entirety. And remember that this document you provided is guidance.
Okay.
It is not technical rule. And so once again, I would state that these are supposed to be used in totality and not singularity. And so that's why this is important in this context.
Okay. Well, so let's talk about the actual rule then. Can you pull up Exhibit 4, Mr. Santos, please?
I have it, sir.
And do you recognize what this document is?
Yes, sir.
Can you describe it briefly?
This is titled The Protection of Visibility Amendments to Requirements for State Plans.
And this is EPA's rule. Isn't that right?
Yes, sir.
So these are amendments that EPA issued in 2017, just for clarification, correct?
Yes, sir.
I want you to turn to page 16 of the document. And I want to draw your attention to the second column in the second to last paragraph. And the last sentence, or not the last sentence, the second to last sentence of the second to last paragraph. And read that statement, please.
Does it start with if a state's RPG? Or what does it start with?
Starts with the URP. Do you see that sentence?
Okay. Yeah.
I don't see
That's a partial sentence. That's a partial sentence. Do you want me to start with the partial sentence? Because the sentence that includes starts with what I just stated.
Excuse me, pardon me, which page of the Adobe file are we on? 16 of 52?
We are, exactly.
Okay, and where am I on that page? Remind me again.
In the second column,
Yes, sir.
the second to last paragraph.
Okay. I see a whole bunch of yellow highlighting. Is that somebody put that there? CFR didn't come out with a yellow highlighting, right?
No, it didn't. I highlighted that, Your Honor, and I should have removed it from the exhibit before I submitted it.
Okay, so
Is
where's
it the
the
sentence?
In
Go ahead.
the sentence about midway through the paragraph, there's a sentence that says the URP is not a safe harbor. Do you see that?
I see that it is right after the highlighting, correct?
It's the last sentence of the highlighting.
Oh, okay. I'll read the sentence that you have directed me as far as I know to read.
Okay.
The URP is not a safe harbor. However, and states may not subsequently reject control measures that they have already determined are reasonable.
So this is the EPA regulation itself, which is consistent with the guidance document we just talked about, right?
Yes, sir.
And so regardless of whether Texas determines that the affected class 1 areas are on the glide path,
I'm
that's
sorry,
not going to be,
affecting class 1 areas.
I apologize. Regardless of whether Texas determines that the affected areas, the affected national parks are on the glide path, reasonable controls might still be required at sources that impact visibility in those places. Is that correct?
Okay. Well, impact visibility at some of these designated areas above any materiality thresholds that are deemed appropriate. That goes to the reasonability of that.
Yeah. And so if those controls are deemed reasonable under those 4 factors, and let me make clear, the URP here, you know, familiar with that term? That,
yes, uniform rate of progress.
and that's the same thing as the glide path, right?
Yes, sir.
So in essence, the regulation, I'm just trying to summarize it. The regulation makes clear that if controls are deemed reasonable under that 4-factor analysis, the URP or the glide path don't provide a safe harbor for controls. Is that correct?
Well, that 4-factor analysis will determine if there's an impact on the first stage of the 5-factor analysis on whether that unit should be even considered or not. So like I said, you are looking at one small caveat of an entire program that is meant to be used in totality.
But I just want to be clear here. In your testimony, your rebuttal testimony, you said that currently Texas is on the glide path and therefore essentially no controls will be required. But that's not the case, correct?
No, that is correct. There are many other factors associated with that other than just Texas being on the glide path.
The fact, though, that Texas is on the glide path doesn't preclude EPA from imposing additional controls at Harrington. Is that correct?
It does not preclude, but it makes it highly improbable.
In your experience, has EPA approved any state plan? Or let me back up. Has EPA approved any of the so-called round 2 plans? Do you know?
For Texas or for where?
Any state.
No, I can't speak for all of those. I can only speak in this case to Texas, and those have not been approved.
Okay. I'll move on.
But before you move on, I just want to make sure I understand this clearly. What you present with this exhibit is 52 pages of the Federal Register, and you're referring to one of the pages, which is, entitled 3,000 and some. This page is page 3093 of the register. This is for the year January of 2017. It's January. The one sentence out of that multitude of pages is that the URP is not a safe harbor, however, and states may not subsequently reject control measures that they have already determined are reasonable, which is interesting language in itself. But then I read the beginning of that paragraph, and once again, I'm trying to read in context. The beginning of that paragraph is in regards to the commenter's first suggestion. So obviously there's a commenter. And so I start paging back, looking for some context with which to construe that one parsed sentence. And, I'm back to cooperative federalism. And under that, I'm finding clarifications. And I'm going back and I'm looking for the change to the regulation. Would you care to direct me to the change to which that one parsed sentence refers, please?
Your Honor, Mr. Hearing Examiner,
Sure.
I'm not asking you to interpret EPA's regulations.
Yeah. I have to have context if I've got something like that. It's got to be read in context of the whole. I'm not going to pull one line out of 3,000 and some pages, if you will. And I'm not saying it was 3,000, but I need to know how many they are and where it refers to.
Well, the document is an impeachment exhibit. I'm not offering it for the truth of the matter included in the document. I'm offering it to impeach Mr. West's opinion that Harrington has no environmental compliance or no regional haze risk because the state is supposedly on the glide path. And that's what this paragraph says. The document is a public document. It's judicially noticeable. It's clearly comes right out of the Federal Register. I don't think there's any reasonable objection to the authenticity of the document.
Sir, I'm not claiming that there is. I'm asking you to help me make a sound recommendation based on an evaluation of evidence or not evidence, a document you're using. I know what the Federal Register is. I know that your exhibit is 52 pages long, 3 columns wide, 8.5 by 11 paper. I've held the register in my hand, of course, but out of that, you have parsed, using my word, one sentence consisted of just a few words, and you're using it to cross-examine this witness. All I'm asking you is for the context in which those very few words exist. And I'm asking you to illuminate a little bit for me so I don't have to read these 52 pages to understand that context and thereby to apply it to the cross-examination you're using to impeach the veracity of the testimony from this witness. Because, it's just not there in the evidence you've presented. This isn't admitted into evidence, number one. Number two, you didn't present the environment in which this very short sentence exists in your cross-examination of this witness. And I'm looking for it, and I don't have time to find it before you move on to the next thing. And since it's not evidence, it is law. I take administrative notice of law. I don't know if this has been superseded. This is a 2017 federal regulation. It's just not enough here for me to give it any value. And once again, I'm not trying to pick on you or be beneficial to any party here. I don't take a side. I simply don't. I just want to telegraph to you the problems I'm having with this method of cross-examination based on this. I didn't count them, but maybe 10 words out of 50 some pages of single space Federal Register. You're welcome to proffer it to me if that'll help me to find it easily. What's the nature of this language? Why does it exist?
So, pardon me, I'm sorry, Your Honor. I missed that. Could you repeat the question? Within which context does this one paragraph, this one sentence within a paragraph, which was referring to a commenter's comment, why should it be important to me, the response to this commenter's comment
in 2017 to a modification of Part 51 and Part 52 of 48 CFR.
Okay. But may I offer
Please.
two potential solutions to work through this and maybe move things along? But I put this together so that there would be a full regulation to look at, and there wouldn't be any concerns about me selectively excerpting anything. But if you look at, if you go up in that second column there, up to the first full paragraph in that section, this, and I won't bother to read it to you now, but this whole column really does address the same exact argument that Mr. West is making now. And this was a commenter in the regulatory process that suggested that if a class 1 area is on this glide path or is meeting its so-called reasonable progress goals, which is another concept to determine visibility, that they shouldn't have to install additional controls. There should be some mechanism that sort of allows them out of consideration for additional controls. And as the EPA explains, the EPA goes on, we disagree. And then I highlighted what I believe to be the most relevant piece here. And I would suggest you go back and take a look at just this column here when you have a minute to read through it. And secondarily, this is something that we would certainly try to explain in our post-hearing briefing to make it intelligible and coherent for you. But I just wanted to get on the record and trying to do this without reading the whole 1,000-page or 3,000-page document, like you said, that this is EPA's position on this particular issue. It doesn't matter if you're on the glide path.
Mr. Smith, can I just get some clarification? You said you highlighted, and I think what I heard from Examiner Lennon was looking for full context here. There is some highlighting on this page. I also see highlighting on page 21 and page 48 that appeared to be you highlighting the opposite kind of thinking that EPA was also laying out, and or kind of the clarification that Mr. West was trying to make here. So Examiner Lennon, I think the highlighting that Mr. Smith has already done for you a little bit shows kind of some of the context that Mr. West was trying to explain here that go beyond the single sentence that Mr. Smith was relying on.
Okay, well, I'll do with it what I do with it. No one's asking me to take exactly administrative notice of a 2017 amendment to a federal law or a federal regulation. If someone's going to do that, I'm going to need some sort of shepherdizing to show me there's been no changes and the interpretive decisions that have applied that, it's going to have to go a little further than the paragraph underneath the highlighting. So, and you can, both sides could argue it. If you found other languages in this particular section you think is important, draw it out. I'm not the sharpest pencil in the box, but I'm not the dullest pencil either. And sometimes I need a little direction to get from one dot to the next. And I'm not too proud to ask for the direction. Okay, so anyhow, Mr. Smith, do you have further examination?
I have a couple more questions for Mr. West, and then
Go for it.
Thank you. Mr. West, so we spent a little while here beating the horse on the glide path. Let's move on to a different horse. You also state at page 6 of your rebuttal, if I draw your attention to lines 16 through 19, that importantly, the units are scheduled for retirement in 2036, 2038, 2040. And those retirements can coincide with the end of the next phase of reasonable progress under the regional haze rule. And there is no known scenario where controls would be required due to their retirement dates. You see that?
Yes, sir.
So first of all, just as a point of clarification, this phase, the phase that we're currently in for the regional haze rule is not complete, right?
Yes, sir. Well, it is complete for the state of Texas, awaiting EPA approval.
And EPA will disapprove the plan if it doesn't comply with the Clean Air Act, its regulations, and its guidance. Isn't that right?
I don't know whether EPA will disapprove it or not.
EPA, okay, moving on. But so EPA has also addressed this retirement issue, hasn't it?
I'm not sure what you mean, sir.
So if a state opts not to require controls on a particular source due to a planned retirement or a reduction in utilization, EPA has required that those plans be enforceable, federally enforceable within the SIP. Have they not?
Yes, they have.
Thank you. So going back one step, just a couple additional questions. If EPA were to disapprove Texas's plan that they've just submitted, we talked about for this planning period, EPA would be required to impose its own federal plan within 2 years. Isn't that right?
Yes, sir.
And if EPA in that process finds that there are controls at Harrington that satisfy those factors, EPA could require additional pollution controls for Harrington. Isn't that right?
They would have to complete their 4-factor analysis. They would have to propose a rule based upon their findings. They would notice and comment that rule, and then they would have to finalize that in a final rule. And the results of that will be determined through that process.
And the results of that, though, could be imposition of new controls at Harrington for nitrogen oxides. Isn't that right?
Anything is possible, but highly improbable.
That's all I have. Thanks, Mr. West.
Thank you, Mr. West, and thank you, Mr. Smith. Okay, let's hear from the other parties. They may have some examination of the witness. Mr. McMillan, anything?
No, Your Honor.
Mr. Bagato, anything?
Mr. Hearing Examiner, thank you, but I think I'll let Mr. West be.
You'll let him what?
I don't have any questions for Mr. West. Thank you.
Thank you, sir. Ms. Lynch, thank you for turning on your video. You have any questions?
No, sir.
Redirect, sir?
Very briefly, Your Honor.
Sure.
Mr. West, do you recall the series of questions that Mr. Smith had about kind of what the company knew about what emissions were looking like in the 2018 to 2019 timeframe at Harrington?
Yes, sir.
And so why doesn't the company know really until 2019 whether or not you're going to have a NAAQS issue that is something you kind of have to take action on at Harrington?
Because Mr. Smith is asserting that that monitor is a Harrington-specific monitor when it is not. The National Ambient Air Quality Standards are standards for a specific area, usually annotated by a county. So there were potential exceedances at that monitor, which was representative of the area, which is accumulation of all the sources in that area. Once that modeling is complete, then there is an analysis conducted by the state in preparing and completing their non-attainment plan, if it is deemed non-attainment, where they do source-specific analysis requiring controls or amendments. So in that particular moment, we do not know that we are the absolute cause of any exceedances at that particular monitor because it is based upon an area.
So as the EPA is doing that monitoring, you don't know whether or not it's just Harrington or there are other sources that are impacting that SO2 value that is being detected by the monitor.
Yeah, that is correct. And it is a TCQ monitor.
And I also want to ask you some questions about, and I just want to make sure this is clear. Can the company operate any of its coal assets, Harrington 1, 2, or 3, after December 31st, 2024?
No, the Harrington assets cannot run on coal after December 31st, 2024, in accordance with the order and the amended permits for the facility.
And with respect to regional haze, I heard you caveat some of your answers with Mr. Smith on as applicable and as necessary. Why are you careful with that language?
Because the state or EPA, in the case of a federal implementation plan, is required to conduct this 4-factor analysis to determine the reasonability of any control on there. They are then supposed to relate that in relation to a visibility impairment threshold at any of these 156 areas. So there are many factors that come into play. And furthermore, in the document that Mr. Smith provided, in the sentences right above there, it references that if a state is determined that there's reasonably no controls there and they meet their URP or RPG, they have met their obligation.
Okay, and so is there any known scenario as we sit here today where if Harrington is converted, we're looking at NOx controls on those units?
No, I don't believe we would ever see any reasonable analysis require those controls due to the requirements of a 4-factor analysis.
Those are all my questions, Examiner.
Okay, since you asked some redirect, only within the scope of those redirect questions, is there any recross? Mr. Smith?
Yeah, just a couple very brief questions. You stated on redirect when you were talking about SO2 emissions, and I believe you said something to the effect of it wasn't clear what the cause of the emission, who caused the violations. Do you recall that statement?
No, what I said is we were unaware of what were the sources associated with any type of potential exceedances of that standard.
Okay. In attachment JLW1 to your direct testimony, at page 3 of the document, this is the signed agreed order that SPS agreed to. I want to draw your attention to paragraph 11. And in that paragraph, this is just a factual statement, sort of a recital. The company and TCEQ agree that Harrington Power Station is emitting, quote, the majority of SO2 in the area, contributing to the exceedance of the NAC standards. Isn't that right?
I'm sorry, I need to get your reference again, Mr. Smith. What exhibit and what I was unable to get.
Exhibit JLW-1. I'm looking at page 3 of the agreed order.
Okay. Paragraph 11 on that page that starts with on March 5th.
Yeah. So can you maybe just read the second sentence beginning with TCQ Region 1?
TCQ Region 1 informed the company that Harrington Station Power Plant is emitting the majority of SO2 in the area, contributing to the exceedance of this NAC standard.
Thank you.
Your Honor, for optional completeness purposes, I'm going to ask that Mr. Smith allow Mr. West to read the entire paragraph.
Yeah, I just read the entire paragraph, but I'd like it to be in the record. So if with respect to Mr. Smith, respectfully is what I meant to say, Mr. Smith, I'm going to ask him to do exactly that. So go ahead. Well taken. Go ahead, witness. Would you please read the entire paragraph number 11?
On March 5th of 2020, TCEQ Region 1 provided the company information indicating an alleged violation of NAC's requirements and referral to enforcement. TCEQ Region 1 informed the company that the Harrington Station Power Plant is emitting the majority of SO2 in the area, contributing to the exceedance of this NAC standard. The company enters into this agreement to support attainment and maintenance of the NAC standard and avoid a designation of the area to non-attainment.
Thank you, sir. And thank you, Mr. Smith. I'm actually, thanks to Sierra Club Exhibit number 25, I'm looking at March of 2020, to which it refers, and I'm looking at March 5th. I'm just going to leave it there. I'm looking right at it. So go ahead, Mr. Smith. You have any other questions?
I do. I have one other question. You indicated that there is no known scenario where Harrington Station is going to require controls under the regional haze rule. Do you recall that on redirect?
Yes, sir.
It's equally uncertain whether Harrington will avoid controls under the regional haze rule, isn't it?
No, it is not.
Explain that to me.
If you'll look at the proposed comments that we provided when Harrington was covered under the BART ruling, we performed an analysis in consequence to EPA's analysis, showed the inadequacy of their analysis, the use of an outdated model, incorrect meteorological data, and we used the correct information with the correct modeling, determined that we had no visibility impacts to any of those affected areas, and that was with the use of coal and SO2. When we convert to gas, that will be much lower and there will be no impact to those facilities. They were, the largest area we had an impact was 0.31 decibels. Everything else was less than a 10.
You're right. I'm going to move to strike that.
I'm sorry. 0.31.
Witness, please.
Decibel, DECIVIEW.
Okay, thank you. And there was an objection, please. Who stated who made the objection?
Your Honor, I'm going to move to strike this. This testimony about a BART analysis is not related to the question I asked and is not in the record. There's no evidence of this analysis anywhere in the record or in any document that the company provided through discovery in this matter.
Okay, well, I'm going to give
I'm going to disagree 100%, Your Honor. He asked the question why, and Mr. West gave an answer to his knowledge.
Well, I'll give it the weight that's appropriate, and we'll see what damage it does, if any. So thank you, Mr. Smith. That's overruled. I mean, I'm just going to leave it there. Next, do you have anything else, Mr. Smith?
Can I ask one final follow-up?
Absolutely, sir, please.
That analysis that you just referenced, Mr. West, you referenced that as part of the BART rulemaking that we discussed earlier. Is that correct?
Yes, sir.
And that rulemaking addressed SO2 pollution. Is that correct?
Correct.
It did not address nitrogen oxide pollution, did it?
No, sir.
Thank you. That's it.
Thank you, Mr. Smith. Okay, not only Mr. Smith, does anyone else have any questions based within the scope of the redirect? No, I don't see any takers here. Good, thank you for the nod, the negative nod, Mr. McMillan. I didn't hear from Mr. Bogotko. He speaks up, and so does Ms. Lynch. So there's no further questions. There's not going to be any redirect. With your permission, folks, it's 5:00 something, but I'd like to just ask a couple questions. And my questions they're definitely not in the spirit of direct examination or cross-examination. They're really just simple because I have a few questions. And I really don't like when questions roll around in my head unanswered. And this witness seems like he could help me understand a few things. So I'm going to ask him just a few things. If you do have an objection to my question, you're welcome to object, and we'll do what we can with it. Anyhow, so let me ask you a few questions, sir. I understand this concept of exceedances. It's a very interesting word. That being said, actually, my question, referring to Sierra Club Exhibit number 25, which I don't think has been admitted into the evidence, at least not yet. I call it the little numbers exhibit or proposed exhibit because it has a whole lot of little numbers which are hard to read. But I've looked at a whole lot of those little numbers, and some of the numbers were negative numbers. And I'm going to ask this witness to please help me understand how there can be a negative chemical. So how can there be less than 0 sulfur dioxide?
Yeah, Your Honor, when you look at the left side of what you need to concentrate on is the 4th to last column, which is the max. And that is the maximum concentration for that particular hour. What is happening in these other type scenarios is the monitor is continuing to calibrate and to adjust for the emissions that it is taking in. And then it spits out a number at the end of that hour. So if we look at page number 1 of 120, which is January of 17, and we look at day 1, we would stretch over to 57.0. And what that is telling you that's the max. And then it just highlights what hour that occurred in that day, saying it was the 19-day. So it only picks the highest one in that particular day. So that this has to do with monitor calibration, monitor testing. There's a very complex process that has to go to make sure that monitor maintains certified, qualified data.
Okay. Yeah, I see that. And I'm a little bit familiar with these kind of things as they relate to some monitoring of other types of gases and things. I was looking at it as the constant monitoring through the day because it gives midnight, 1 a.m., 2 a.m., 3 a.m. And suddenly we get the real big fat number at 1900 hours at 57.0. Immediately prior to that, we have 10.4. And immediately thereafter, we have 2.7. And I mean, I'm trying to reconcile how are these calibration numbers when I see a 45.2 and a 10.4 and a 2.7, then I see a whole bunch of negative numbers even. I mean, your explanation tells me how to read it, but it doesn't help me to understand the data, how it's collected. You understand what I'm saying?
Yeah, I do, Your Honor, and I can't speak to the education of that particular monitor and that information. All I know is that those are normally associated with calibrations throughout the day, and what we are concerned with is the maximum daily hour that comes out of that.
Okay, and this is, of course, for sulfur dioxide, correct?
Yes, sir, it is. This is a sulfur dioxide monitor.
Was there also a monitor for nitrous oxide?
That I do not know offhand, Your Honor. There is not one at this particular location, but there may be one in Texas around this area, but I am not aware of that or could answer that right now.
Okay, I heard the word meteorological or atmospheric, and I'm wondering if the weather doesn't have at least some effect on this type of data. Does it?
It's a factor that is included in the modeling that I referenced earlier that you do to determine reasonability of a control. What you're doing is you are first determining what your emission impact is. And there are lots of impacts that go into that. Wind speed, direction, meteorological data, non-specific sources, specific, it's a very complicated process. And so meteorological data has definite impact on that, because if the monitor is only going to grab the emissions in the ongoing wind direction and wind changes.
Okay. A couple other things that are floating around I want to resolve. A majority, of course, means more than 50%, right? You agree with me on that? So I'm looking at that word majority, which is in paragraph 11 on page 3 of JLW-1. You might remember you were cross-examined on that. You know, I tried to read it in context, but I first construe the literal meaning. And the literal meaning just means more than half. Is that how you construe that? And more importantly, is that how the drafter of this document, which may have been you, meant when they used the word majority, more than 50%?
We drafted this document in concert with TCEQ, And the sole purpose of majority means we would be the largest emitter of SO2 in that area. That's what we mean by that as far as sources.
Well, that's a slightly different concept, isn't it?
Yes, sir. It doesn't necessarily mean we're greater than 50%. It just means of all sources, we would be the largest emitter.
So if there were 98 other 1%ers and you were a 2%er, you would be the majority.
Under that context, yes, sir.
Okay, I'm not trying to be tricky here, but I looked at that word and I looked at that word again and I had a question about it. So you were the major emitter. Okay, so let's have and I don't mean to be be a smart aleck about this, but I'm looking at the page, same exhibit, page 4, the order, this is essentially a consent order. And I know lawyers are familiar with a consent order, but the parties kind of come up to the terms of the consent order. And this says, unequivocally, the company will make the appropriate modifications to 3 units at the facility or facilities to cease coal operations and resume full operation utilizing natural gas by January 1, 2025. Apologize to Mr. Lee for reading quickly. With all respect, isn't that a bit presumptuous as to approval from the state of New Mexico?
No, to secure the approval with the TCQ and EPA to avert the non-attainment designation, these were the conditions with which we had to comply to provide the compliance with that NAAQS standard. And as indicated earlier, to be included for any type of application or designation or anything, there has to be some enforceable order in place for them to allow it to occur. Because if not, a company can change their mind at any time.
Where's that language? I'm looking for that qualifying language.
It's not in here. That is just compliance with the SO2 NAAQS standard that we talked about earlier. This would document our compliance of the NAAQS standard.
Well, I just looked at the 4 corners of the document and I'm wondering, I expected to see something that said something to the effect of condition upon approval by the New Mexico PRC. And I don't see it. Where is it?
That is not in there. And if we had included that in there, we would not have been allowed to avoid the non-attainment designation because EPA wouldn't have been able to use it as an enforceable action and therefore would have designated the area as non-attainment in December of 2020.
Well, I think I understood what you just said. So I'll just let that lie there. Let me see if I had any other questions that kind of bothered me. Pardon me, indulgence, please, of counsel, just a moment. Got some really easy questions. I don't want Mr. Bogatko to be the one that can ask all the easy questions. I'm going to try to ask a couple easy ones. If this conversion to gas takes place, will there be more or less CO2 emitted from these 3 plants?
There will be less. In my testimony, I referenced we expect to see about a 70% reduction in CO2.
Okay, now we don't have, thank you. I presume that something to that effect would be your answer. Now concerning NO, I guess I'll ask it a different way just to make it more entertaining. Is are NO emissions higher or lower for a coal plant in general versus a gas plant in general, and for this plant specifically, if you know?
Yes, NOx emissions are higher for a coal plant than they are a gas plant, and that would be applicable in this scenario as well. So that you have reduced NOx emissions by burning gas as opposed to coal.
Would you care to put a number on that?
Approximately 30% reduced.
Just a moment, please. Okay, I think that was all of my questions to rest my mind. Now, since I asked some questions, I'll give everybody an opportunity to respond or not to respond, to ask questions of this witness within the scope of my questions. So Mr. Santos, on behalf of SPS, do you have any follow-up questions to mine?
No, Your Honor.
Thank you, Mr. Marks.
Oh,
I'm sorry, Mr. Smith.
Yeah, thank you, Your Honor. Josh Smith on behalf of Sierra Club. Just two follow-up items.
Sure.
Number one, you mentioned that Sierra Club Exhibit 25 hadn't been offered, and I inadvertently omitted that step. I would like to offer that into the record.
Okay, let me ask you a question. Is your witness going to refer to this document in her testimony? Or does she?
No.
Okay, she doesn't. Well, let's see if anybody has an objection to it. I mean, I don't know that you've laid a foundation for it. And I asked you within the scope, and it certainly was within the scope. Any objection from SPS?
Your Honor, you referenced the foundation objection. One of those didn't work for me before, so I'm not sure I'm going to make another one here. But other than that, no objection.
I kind of look for relevancy. And by the way, I don't hide the football in these proceedings. You guys might have figured that out, if you know what I mean by that metaphor. And, you know, I just look for relevancy. That's the biggie with me. As for whether it has a, yeah, I like foundation. I like relevancy, of course. And then after that, I just give it the weight which it's due. Mr. Marks, of course, you have no objection. Ms. Lynch, any objection?
No.
Mr. Bogatko, any objection to Sierra Club exhibit number 25, which is all that data from this sensor?
No objection.
Mr. McMillan, any objection?
No objection, Your Honor.
Okay, and SPS, you weren't real clear. Do you object to it or you don't object to it?
Your Honor, no objection.
Who said
Well,
that?
He said no
That was-
objection.
That was Mr. Santos, Mr. Lee.
Yes, I'm sorry, Mr. Santos. Well, you know, I would say thank you to all you guys because there's no objection, so there's really nothing for me to rule upon. And that makes it a little bit safer for appeal purposes. So Sierra Club exhibit number 25 is admitted, there being no objection. It'll be accorded the weight which is appropriate. I don't know what weight there's going to be by the end of the hearing. It could be more, could be less. So I don't really attach any particular weight to any particular exhibit at any particular time, except for when I'm evaluating the entire case at the end. So other witnesses might want to refer to it. Other witnesses, you know, might illuminate the meaningfulness of this exhibit. So that's all I got to say about that. It's been admitted into evidence. So it's now 5:18. I think it's a good time for us to knock off for the day to recess. Does anybody have any objection to that? No. Okay. Any comment? Yes, sir. Mr. Marks.
So are we done with Mr. West then?
I don't know. I was about to ask that. Or Mr. West, well, excuse me, Counselor for Mr. West. I don't usually address the witnesses directly. Counselor, is there any further testimony from Mr. West?
Not from us, Your Honor.
Okay, so he could, I guess, could be called on rebuttal, or he could even be called as a witness for one of the other parties. So let's see if anybody else wants to call him as their witness. Ms. Lynch, you want to call him as your witness? Or will
No,
you?
sir.
Yeah, it'd be good to get it out of the way if you did, or you had plans to do that. Mr. Bogatko?
No, thank you.
Mr. McMillan.
No, Your Honor.
Okay, well, I finished with my questions of him, so I say we let him go home for the night. Okay, so you're released, sir. Thank you very much for appearing and let us take shots at you and ask you hard questions. Appreciate your testimony. Have a good day.
Thank you, sir.
Okay, so council, let's talk about tomorrow. I think, yes, sir, Mr. Marks.
I was going to suggest we do that and let Mr. Lee take a break for his fingers and.
Oh, sure. Off the record. Absolutely. Thank you, Mr. Marks. Good tip. Mr. Lee, take a little break and we're going to talk off the record about reconvening tomorrow. I might want to put it back on the record, our agreement. So if you could hang around, I'd appreciate it. Okay, oh yeah, let's say we start at 9 o'clock tomorrow morning. Is that good with everybody?
Yes.
Yeah, I figure the earliest we start, I like 10 o'clock, but 9 o'clock gives us another hour at the end of the day. If we started at 10, we might not be ending till 6:30, and you know how that works. You guys already agreed on an order. I really didn't have a problem with that. It's fine with me. By the way, we're still on YouTube, I should add, even though we're off the record. Let's see who has to testify yet. Mr. Goodenough, Mr. Kojak, and Mr. Elsey. Am I reading that correctly? And that's the only witnesses that would testify, right? Mr. Marks, you got your hand up. Yes, sir.
Yes, that's correct. And we've waived cross for Mr. Goodenough.
Okay.
We think there's the obvious pun there.
Whoa, wait a minute. Let me think about that. I get really literal during these cases. You wait because it's good enough, right?
Yes, but
it's testimony is good enough.
And Mr. Kojak will be short.
Okay.
Mr. Elsey will be another one of these, probably an hour and a half.
Right.
Give or take slogs, depending on the way it goes. So that tells you where we're going, how much time we're going to consume. So
lots.
My best guess is we'll get done by lunch tomorrow.
Okay. Are you going to let Mr. Smith do the hard work again, or are you going to call Mr. Miller?
We're going to let Mr. Smith do the good work again.
Okay.
In fact, he's my boss, just for your information. So
I did
he's
not
going to let
know
himself
that.
do that. Yes.
Well, I understand that concept completely, frankly. He lives in a part of the world that I plan to settle. And look, I ended up in Santa Fe. How about that? I learned to ski. Sierra Nevada is up at Badger Pass. You know where Badger Pass is, Mr. Smith?
I do. Yeah.
You do. So I would spend at least a week there every winter learning to ski for many years. Something near and dear to my heart. That's a long, long story we'll talk about some other day, with your permission. So yes, well, we got 3 witnesses. Sounds relatively easy. Maybe we'll be done by lunch, and I'll give you guys a lot of time to resolve without, in best interest of your clients, resolve some of the issues about how we proceed with this case, and maybe even better things than that. You guys are all going to connect with each other. Am I correct? Tomorrow afternoon? Well, the reason I asked, not just Sierra Club and SPS, but obviously I have to go through the other parties. You can at least, bring them in and maybe have them involved in the case too. What do you think, Mr. Marks?
We can do this. This is the one outstanding issue I have is that Exhibit 9. We may by tomorrow, SPS may have more insight into what they propose to do with the oral testimony and how extensive it will be. It sounds like you would like the parties to confer.
Yeah, I'd like you to confer and work it all out and send me a nice email that tells me you guys have worked out all issues. And we just need to get the testimony into the record.
We will try.
Okay.
We've council has been, as I said this morning, 25 years ago, feels like, but you would have had many more disputes to consider, and SPS council has been very, very good about finding solutions. And so we'll continue to do that.
Thank you. Kudos to Mr. Santos, or were you referring to Mr. Walker or both?
I was referring to the whole team. I think I wouldn't presume to be inside their rooms, but I get it seems to be a team effort on their part, and a consistent, not just in this case, but I've been litigating with them for multiple clients over the past 5 years, and it's just their attitude.
A good attitude.
Yeah.
Excellent, most excellent. Okay, can we go back on the record and just conclude the hearing essentially? All right, Mr. Lee, I just said back on the record. I hope we're back on the record. We just took a few minutes to take a little break, and there was a discussion off the record. It was purely procedural about what time we start this tomorrow morning. A little bit of dicta from me that had absolutely nothing to do with this case. We also talked about expectation that we may conclude 3 witnesses by lunchtime tomorrow. We don't really know, but that's a best estimate, or it's an estimate, if you will. And I also suggested that it behooves me, if not each of the witnesses, that they have discussions as planned during the afternoon, and that not only Mr. Marks and SPS counsel include each other, but they may also wish to include the other parties, including staff, into discussions. And if I wasn't clear, I'm not sure I was, I'll be kind of on the hook until 5 p.m. tomorrow at least. And I actually check my emails in the evening before I go to bed. So if you guys want to drop me an email to tell me what you've resolved, it may allow me to sleep more soundly tomorrow afternoon. We can talk about that again tomorrow when we conclude tomorrow. But at this point, we're not ending the hearing, and not really a recess, but we're going to continue the hearing until tomorrow morning at 9 a.m. Are there any questions? Okay, that concludes the record for today. See everybody tomorrow morning. Good night.
Good night. Thank you.
Thank you.